Good morning, good morning, good morning. It is the retrial of Karen Read, day 14. It's Monday, May 12th, and yes, we are going to be resuming trial with the, continued and extended cross-examination of Sergeant Yuri Bukhenik. Why? Well, because the defense isn't done yet, and the defense can cross-examine as long as they need to, so long as they are still getting into new areas of cross-examination. They cannot, repasturate the exact same ground over and over and over again. That becomes asked and answered. But if there are new areas of cross to get into, they can still do that. And there are some areas of cross that we know they haven't gotten into yet. So another morning of cross, but immediately when the lawyers came in and when the jury was coming back this morning, an hour later, I was like, are there going to be things the lawyers want to talk about with the court? Immediately, yes, but they did it 99% at sidebar. So we'll look at what they put on the record. We'll zoom past the sidebar and get back into the jury being present, because that was a long sidebar this morning. And we've got breakfast, we've got coffee. Let me know it's Monday. Let me know where you're coming in from, what you're drinking. I've got a cup of cappuccino. And we're going to go to court together and hopefully figure out how to talk while we're there. It was a good weekend. I hope you guys had a good weekend. I hope everyone had a good Mother's Day. And replay crew, love you. Everything's timestamped down below. If you guys are on the Law Nerd app, well, you get your notifications when, shit goes live. But if you're not on the Law Nerd app, now is the time. Just now is the time. Now is the time. Now is the time. Just free for you, iOS and Android app stores. Let's roll the intro. Let's go to court. Let's just, I don't know.
Do it.
It's time to just do it. It's time to do it.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
Time to get to court. Remember, the court went on the record briefly before the jury came in this morning. That's what we're doing right now. So
you are unmuted.
We are unmuted. Yay for us. Yay for the unmuting. It's a Monday.
Now open an AC.
I have no idea. I just want to move.
Good morning.
Can we just move the...
I came into 3 motions.
It's the sound of a judge that's
I did not
thrilled.
have when I checked email before coming to court today.
Baby, that's
so
why.
I'll hear you quickly on these. I've had a chance to read them. So, Mr. Brennan, I'll hear you.
3 motions filed in court that the judge did not have notice of. She said, if you need to hear me, if you need to be heard by me, let me know. But to file them where the judge has no notice is just going to piss off the judge on a Monday. It's just going to piss off the judge on a Monday. Oh, Brennan, it's just going to make the judge mad.
Let's today focus on the Bowden ones. We can focus on the other one later.
My motion memorandum on Bowden just iterates my objections continuously at sidebar that not all evidence is admissible.
Oh, we're going to get some more evidence about what was going on at sidebar. Remember, the defense is bringing a Bowden defense. A Bowden defense is named after the case law. Unlike gymnastics or ice skating, you don't name the move after the person that perfects it or does it first. It's named after the case, so it's often named after the defendant where this issue comes up. The Bowden motion or the Bowden defense is the defense saying this investigation did not pursue avenues it should have. It's not saying that dude did that thing, so it's not my client because it's that dude, like specifically naming dude in all senses of the word. This person did it. It's not a third-party culprit defense. It is, hey, there is person or people that should have been investigated. Law enforcement knew this, and they either ignored it or they should have known it and they didn't, and they did not investigate those leads, and this was not a good investigation. I personally think this is a better avenue for the defense than trying to go the route of like multiple third-party culprits. I think it's much cleaner. The Bowden defense does have some limitations, but not as many. So getting into the realm of Bowden seems to be what Brennan was objecting to at sidebar all day on Friday.
Admissible characterization of evidence is not admissible, and the defense should have the ability and intention to follow up with substantive proof if they're going to ask a question.
You have to have a good faith
Not
basis in the
limitless.
question.
Bowden is wide parameters to ask the investigator about their state of mind, about the scope of the investigation, but it has boundaries of reasonableness. And my earlier objections about offering information that go in beyond Bowden, delve into third-party, inadmissible evidence, those objections will compel me to draft this motion. And I can continue.
Oh, he's
and will
mad.
continue to object during the case,
I mean,
but
obviously he's mad,
once the
but
questions are asked, if they're improper, the jury hears them, it inflames the jury.
yeah, the shit's out of the
And
horse.
Without a basis and an intention to follow it up with substantive proof, the question should not be asked.
So the one point I want you to focus on, Mr. Brennan, is the specific evidence regarding materials that Sergeant Bukhenik has not been able to look at.
I mean, if there's materials you can't look at, I don't
Is
know
that
how that
something
goes
we
into
can do
Bowden.
here in open court, or based on the protective order? Is that something that should be done at sidebar?
Sidebar.
All right, why don't you come up, Mr. Jackson?
Oh, the federal investigation information. I wonder if the defense wanted to ask about maybe Jen McCabe and her, because they said we trusted our witnesses, trust but verify. Well, did you know about this? But if this sergeant doesn't have that information, the argument seems to be they can't ask about that. We're not going to know much more about that because they're at sidebar for an extended beat this morning. So let's get to our hear ye's as the jury comes in. Oh, we got a little bit. We got right on the money with the hear ye's, almost a bit too much. So let's get to our hear ye's as the jury comes in. Once I see those motions filed, because it seems that Brennan just brought those directly into court this morning, we can chat about it tomorrow morning. I'm not going to cover those today. We'll give it a minute, and the defense hasn't even had a chance to review them or respond. We'll get into them later if they become part of the public docket. But for today, we're just going to go to court for how long will we be in cross-examination? I mean, who knows today? Will it be the rest of the day? Probably not. Half a day at least. I can't imagine they're almost done.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right, jury's in. Court is
Good
called to
morning
order.
again, counsel. Good morning, Ms. Reed. Good morning, Julie. We appreciate your patience this morning. We're trying really hard to cut back on the sidebar conferences, so we spent some time this morning.
We're trying not to sidebar, but you're going to have to sidebar. You're going to have to sidebar. But again, calling them in early, calling the jury in an hour later and then making them wait like 20 minutes is also something that's not going to make the judge happy, like at all.
Hopefully,
Like things that will piss off a judge immediately.
so we do appreciate your patience. I do have to ask you those questions. Were you all able to?
A lot of you are saying the motions are already on Twitter or whatever. Okay, I'll grab them. We'll talk about them tomorrow.
Everyone said yes or not affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case?
Hey, Caramba said she's trying hard to be their friend. Judges,
Did anyone happen
most
to
judges are like
hear
this with
or
juries.
anything about this case
Most.
you left here for the week?
Most are very mindful of jury
We
time.
have Sergeant Bukhenik again,
And
please,
the jury likes this judge. We heard that from jurors from the last trial that they liked the judge. So the jurors see the judge in a very different light than maybe the internet does, but the jury likes this judge. So they are, appreciative of the updates. This judge really does keep them in the loop.
Good morning.
Lulu
All right, Mr. Jackson, whenever
Amy
you're
asked,
ready.
are they
Thank you,
calling
Your Honor.
Proctor? Karen Read says she doesn't think that Proctor will be called. The defense is treating Sergeant Bukhenik like the Commonwealth might not call Proctor, but the Commonwealth can still make that decision later. They can still change that. So they can still shift that strategy. So we're going to have to wait till the end of the Commonwealth's case to see. But the prosecution's in a real catch-22 with that one. I think it's worse if they don't. Kiki reminded that they can't hear the judge's sighs. It's true because the microphones go out to us, not to the courtroom. So.
Good morning, Sergeant.
Good morning.
I'd like to ask you, just to start off with, at some point during
I'm
the
saying
course
I
of your...
think the jury likes this judge based on what jurors from the last trial have said. But also, I've seen this court's demeanor with the jury. I've talked to a lot of jurors, and this judge keeps them in the loop. They're going to like the judge. The jury is going to like this judge. The last jury from the last trial said that they liked this judge.
Your investigation, did you become
That
aware
doesn't surprise me.
that a snowplow driver had reported having seen a Ford Edge
right into the
being
snowplow.
moved into a location in
We're
front
resuming
of
cross.
34 Fairview sometime in the early morning hours of January 29th, 2022?
We learned about a plow truck driver. I don't believe his recollection was as you described, though.
Do you remember him mentioning a Ford Edge?
Yes.
Okay. And do you remember him saying that the Ford Edge had been moved? He had passed by, it wasn't there. At some point, he passed by again, and it was there, impeding his plow route.
Yes.
Okay. What is your best memory about when he said he believed the Ford Edge? Sorry, I guess a better way to put it is, when did he say he first saw the Ford Edge in place in front of 34 Fairview?
I don't remember exactly. I know it was during the middle of the night. My not adopting your narrative was the fact that he saw it being moved there.
Understood. I figured that. I clocked that as soon as I said it. He didn't see it moved. He saw it. He saw 34 Fairview without it there. Then about an hour later, it was there.
I believe so, yes.
Okay. Would about 3:30 in the morning sound right to you in terms of what he reported?
Judge Abbey
in terms
says hi
of
to the
time that
loners.
he saw it there?
It sounds right, but
Chip Cheryl having a good day.
I'm not sure of the exact time. My report would reflect the accurate time.
I know.
Fair enough. Let me see if I can grab that.
The thing is, he keeps doing this in areas where he thinks the defense has a narrative, and I don't think that the jury will see it that way. So I think we're in a very, very different trial.
Let me ask this. Well,
And Bukhenik's
very
own
maybe
feelings
more-
about this defense
instead
team
of
are
making
going
you
to
sit
make
there
him
and
look
wait, let me
more
just ask
evasive.
this. Do you remember him?
He looks worse because of the way he's engaging with the defense team, because there is no reason for it at this point. And he's basing off of past interactions, not what's happening in court. And the jury's going to be like, dude, why? Like, why? You're here as a cop. Why aren't you answering the questions?
Saying that he had
It's
first
evasive.
plowed the area free of the Ford Edge. In other words, first passed in front of 34 Fairview around 2:30 in the morning. Does that sound right?
I believe his dispatch time for the plowing of the roads that evening was 2:30. But I would have to look at my report.
That's fine. And then it was sometime subsequent there too that he saw the Ford Edge in place. Maybe an hour later.
Sounds about right. Again,
Okay. Did you take any investigative steps when you learned about this snowplow driver to determine who, if anyone, might have owned a Ford Edge associated with 34 Fairview?
I did not know.
IDK. All of his
Did
I
your
don't know
investigation ever
answers.
reveal that the
For me, all of the I don't know answers just indicate that he's not the lead investigator. Every single time he's like, I don't know. That's exactly what a lead investigator would investigate. Because he's not the lead investigator.
Albert family actually had a Ford Edge at the time?
Yes.
I want to shift gears for a second to
Margaret,
Meadows,
there's no
if I
age
could.
limit on
and
the
ring
gallery
video evidence associated with One Meadows.
unless there is
You
disruption.
testified that on direct examination that there was no video from Ring at or around the time 12:36 a.m. When Miss Reed's SUV.
That said, we regularly had, not in a trial like this, but during regular court happenings, we regularly had younger kids either in the gallery or in the hallway if they needed to come to court with a parent or with somebody who was doing whatever. Judges were generally, especially if there was no jury, generally pretty chill about it. But for a case like this, the only gallery is friends, family, and media, so nobody can just walk in.
Returned back to One Meadows.
So it's a whole different
Remember that testimony?
thing with this court.
Yes.
But school groups in
You did
Los
receive
Angeles, Emily, are you tired of cross? No. You're very chatty. Yes. School groups in LA regularly will go observe court happening. I actually covered a case with a high school group going and observing court that went sideways. That was not in Los Angeles, but school groups will go observe court. I think it's really important. So we will have lots of classes at like elementary school and then high school going through in court. You just can't do that in courtrooms that are sealed or closed, like juvenile court is sealed and closed. So you can't do that in those courtrooms. It was a good question. Emily, just eat your breakfast.
search warrant returned from the Ring
Let's see if we can
Corporation. in
figure out what's
furtherance of
going on
a
with those
search warrant
Ring
executed
videos.
by Trooper Proctor, correct? Former Trooper Proctor.
It looks like Yannetti and Alessi.
Evidence was returned
Alessi
by
as the
Ring,
highlighters.
yes.
And in addition to the actual video recordings, there was also an activity log that was returned associated with that time and that location from the Ring Corporation, correct?
Cass, I'm going to answer this when we get
There
to
was a key
break. It's a long answer.
log identifying each video that was provided by the time and date when the video was recorded. It's not an activity log per se for the account. It's strictly a key describing the video, telling you what time the video was recorded.
During the entirety of your investigation, was there any evidence uncovered at all that Ms. Reed had accessed the account information associated with that Ring account?
No evidence could be provided by Ring documenting that activity.
Okay, no evidence.
But there is evidence that someone had accessed the account through John O'Keefe's cell phone, correct?
I am not aware of that.
Are you aware
What?
that
How are you
after
not
John
aware?
O'Keefe's cell phone was recovered by Massachusetts State Police, someone at Massachusetts State Police actually opened the Ring app on his cell phone?
Yes.
Who is the person who opened and accessed the
I know,
Ring
I
app
know.
on John O'Keefe's cell phone?
I'm not 100% sure.
I know.
I have just a moment, Your Honor.
Yes.
I suspected this is where the defense was going when they were asking about leaving John O'Keefe's phone unlocked and wanting to get into John O'Keefe's phone being unlocked and who was accessing what on John O'Keefe's phone before John O'Keefe's phone was forensically imaged. If you're going to ask me, Emily, how would it be proper for them to be going through a victim's phone into applications before it's forensically imaged? You know the answer. It's not. It's not. It's not. Forensically image it first. The only time I could see law enforcement going through a decedent's phone without everyone absolutely flipping their shit is if they are trying to find a next of kin. That would be the only circumstance when I could see them going into like call favorites and trying to find next of kin if it's unknown to notify people. That's the only time. And they don't need to do that in this case because next of kin was readily apparent. So should they have been in the victim's phone looking for anything? No. Say it with me. No. The only, I could see a situation hypothetically, and it would have to be a really specific situation where there is fear of deletion of evidence and it's a race against the clock to try to preserve something, but that's not happening here either. And again, if you're in a race against the clock, they seem to have forensic people within their department. So how long does it take to forensically image a phone when you have the passcode? The experts, I think, said that forensically imaging a phone when you have the passcode does not take that long. So, you know, when you have a unattended death of a police officer, and it is during working hours at this point, call up your forensics person and be like, we need to extract this phone literally ASAP. Okay, just do it. It doesn't take long. You have the passcode. But does it leave room for the defense to make the argument that there's missing ring footage, not because the motion sensor didn't pick up? Well, I think maybe there is. And if you see the apps on the phone from the forensically image filed, can't you just start sending preserve notices? Yes. If something gets deleted off of Ring on the phone, it's not going to necessarily delete off of Ring servers if you send them a notice to preserve immediately.
Yes.
May I approach?
Yes.
Back up. But the defense has an argument, I think. Who had access to John O'Keefe's Ring footage? They had, some of you are asking, how could they get into John O'Keefe's phone? They had his passcode within very short amount of time. They had his
Refresh
passcode.
your recollection, take a look at a report, perhaps.
Yes.
May I approach?
Yes.
But it leaves the argument for the defense to make. Who was messing around in John O'Keefe's phone before it was forensically imaged? Because even if they didn't do anything, assuming that they did
Take a look at that
nothing,
three-page report.
and they just
Tell me
wanted to make
that
a motion to
refreshes
preserve or whatever, it still looks bad with everything else you know, and the defense can argue that perception. I believe it was his niece or his mother that provided the passcode. The jury doesn't know that yet. But they did not need to crack the phone. This is your daily reminder that a 6-digit passcode takes like 36 years for law enforcement to get into. And if you have someone who's an emergency contact that has your passcode, you can tell them who it's okay to give it to and who it's not okay to give it to. If after your death, you need your bestie to wipe your second Audible account, let them know that. Or don't. Just depends. So, Michaela said, I changed my passcode to a 7-digit code after this aired last week, right? I mean, that's true, unless it's a birthday. Rex88 Moser said, unless it's a birthday. Yeah, that we learned about all of using a birthday when we watched Josh Duggar. Part of, he was using his birthday as passcodes to a whole bunch of stuff. Lucy said, I don't have a passcode. Lucy immediately add a passcode to your phone. It immediately add the passcode to your phone. I will say, back in the early days, back in the early 2000s, there would be DAs who would leave their phones in court with no passcode on them. I'm not going to say that we would prank our coworkers at work. I'm just going to let you imagine what the natural inclination would be to remind people that leaving their phone in a public courtroom unlocked as a district attorney is a bad idea.
May I approach, Your Honor?
Yes.
Well, bad idea.
Sergeant, having looked at this report, does that refresh your recollection as to who may have accessed that ring app?
This is how my kid does
Yes,
it.
that report
This
is
is a pattern.
authored by Michael Proctor, and it
Shock me,
says
shock me,
that
shock me.
investigators accessed the ring application.
Thank you. I want to show you one other document.
Can we just take a moment to memorialize what he just said? There's a report from Proctor that says that they accessed the victim's ring. Who's kind of surprised they actually made a report? Who's actually surprised that they made a report? Got to be honest.
If I could.
Was someone good to see you this morning? I know. Everybody raises hands in the chat. 30,000 people are like, you wrote a report? Wow.
I've just handed you what purports to be the search warrant return for the ring, from the ring company, correct?
I got to take a look through all of it.
Of course. Take your time.
I saw a number of you in the chat say, was that the report that was over 500 days late? That you make an excellent point. Or was it after someone noticed, maybe like the defense forensic expert? Who knows? And in a normal investigation, if law enforcement came in and said, yes, we were under a time constraint, we accessed the victim's ring, is it proper procedure? No. Does it look as bad as it does in this case? No. A one thing in a case might not be the end of the thing. This case is not a one thing. This case, there's a handful of things that are normal and then everything else. And so if you only have a handful of things that are normal, everything else starts to stand out. Many of you ask, can the defense call Proctor? Yes, I think Proctor becomes a game of chess for the prosecution and the defense. We can talk about the strategy of that more. I don't know which one's worse for the prosecution. Proctor's bad for the prosecution no matter which way you slice it. I think not calling him looks worse. A lot. Haley asks,
Thank
is
you,
the defense
Sergeant.
able to
Have you
call a
had
witness
an
that the prosecution has already called to question them on reports that were introduced after their testimony? It has to be that they weren't able to cross-examine on it during the time for cross-examination, so it wasn't known to them. If it was known to them, they have pretty broad ability to cross. So if it was known to them at the time of cross, then no. But if it's something that comes up later that was not known to the parties, then yes, with limitations.
Opportunity to review that document.
I have.
Does it
Welcome to all our
indicate
new
that,
members.
in addition to several other files, there is a login session report
That was me, not you.
by the Ring Corporation as well? It's highlighted
Sorry, I don't have my do not disturb
Number
mode on
4
yet.
is highlighted with one Excel file containing login session information.
Thank you. Mayor Pro-
You don't have a meeting. That's me. That's me. I have a team meeting that I'm going to be streaming for. Sorry to everyone who was triggered thinking they were late for
Again,
something they didn't know about.
Just to make sure I'm very clear about this, nothing from the Ring Corporation suggested or intimated that Ms. Reed actually accessed any of that Ring account information, correct?
The information provided did not indicate that, no.
Thank you. I want to ask you a couple of questions about your testimony on direct examination related to
I think
your
the
trip
defense
to the
did a good
hospital
job of
and
getting this
your
info out there
observation specific
before
to
the prosecution
Mr.
could say
O'Keefe's
anything.
right arm. You indicated that you saw bruising on his right arm in addition to the abrasions, the parallel
Yeah, let's talk
abrasions
about
that you
that.
described, correct?
I believe bruising is very similar to abrasion.
Okay, that's my
What? He uses them synonymously. Okay.
question. Can we, Your Honor, with the court's permission, can we show Exhibit 1? It's already been introduced.
I saw everybody said their heart rate
Is
spiked.
this a fair and accurate depiction of what you saw
the victim's
in terms
arm.
of the condition of Mr. O'Keefe's arm while at the hospital, if not exactly like this?
Yes, it is.
Okay. What did you mean when you said you saw bruising on his arm? What were you talking about?
I actually indicated bruising on his right hand, the back of his right hand.
Okay,
He
that's
said more
fair
than
enough.
that.
From his wrist, when I say arm, can we agree, at least for this purpose of
Can we agree on anything? For those of you that are going to ask about bruises on the back of the hand, it was my impression after the last trial, and I think we will have explanation this trial, that those were from medical intervention, that the bruising on the back of the hand was from medical, not from something else, but we'll get to that later.
for the purposes of this discussion, that I mean from the wrist up to the shoulder.
Mm-hmm.
Did you see any bruising from the wrist to his shoulder?
I saw exactly what's depicted there with the abrasions and lacerations.
Okay.
That's
you know
not
what
bruising.
lividity is, correct?
I do.
Okay. Describe for the jurors what lividity is.
Lividity is the pooling of blood inside the body as
Well, I mean, he is a
a
homicide
deceased
detective.
individual falls or is positioned naturally with gravity. Blood begins to settle in the lowest portions of the body.
Because it stops circulating.
If you're laying face down, it'd be your face. It also contours to the imprint or the force that's exerted on the body from below. If someone's deceased on
This is a bad explanation.
TV remote control, you can see the remote control, the buttons underneath from the pressure.
So it's a bluish, purplish discoloration of the skin, not from an impact, but from the pooling of blood after the heart stops, correct?
That's correct.
Do you see an area at the upper arm that the skin looks discolored in addition to the abrasions that we see?
I'm sorry, I was looking at that one.
Oh, sure, I'm sorry, yes.
Y'all, we will talk about it, but when the coroner testified last trial, I see a lot of questions about why they would use a hand. The coroner testified that she saw what appeared to be a needle puncture and then the bruising. Why they would choose to do that, I don't know, but that is the coroner's testimony from last time, so that's what we're going off of. Why would the hospital clean up his arm? This is not a photo from the hospital. This is a photo from the coroner's office. So the cleaning is part of the coroner's office. So let's continue on.
Right up toward the upper biceps, triceps area?
I see that area, yes.
Okay, is that consistent with lividity rather than bruising?
He doesn't know.
I would not agree with that, no.
You don't
believe
know.
that that's a bruise?
I believe that that's a laceration.
I'm sorry, I'm talking about the discoloration of the skin, the reddish purplish hue of the skin, separate and apart from the abrasion, from the abrasions or lacerations to the skin. The discoloration. Do you see that discoloration or no?
I do not know.
You do not?
I do not know.
Okay, we can take that down. As you sit here today, you're not suggesting that you saw bruising from the wrist to the shoulder on John O'Keefe's arm?
Nothing that stood out to me.
Okay.
I observed lacerations and abrasions.
All right, thank you.
He had said bruising on direct, and all of us went, excuse me, what?
I want to shift gears
This is why it's
one
being
more time
followed
and
back
ask you
on.
about your trip to Dighton and the seizure of the SUV. You testified that you seized the SUV somewhere, I think your testimony on direct examination was somewhere around 4:15, 4:17, something like that, correct?
Yes, sir.
Does 4:12 sound like it could be a reasonable time that SUV was actually seized in Massachusetts State Police custody?
It could be reasonable.
You would
I'd
need
have
to see
to
a
refer
report.
to the
report.
video evidence that, and then also the exact time that we advised the defendant that we are going to be seizing it. I guess it could be argued that that's when it was seized. Even we had the intent to seize it right there.
Right. Took the key fob.
When it was in
went
your
outside,
custody.
had a
He's just trying to figure out when it was in his custody. Smokey Joe asked, why isn't the Commonwealth objecting? He doesn't or can't answer. He is a homicide detective. It's fair to ask the difference between lividity and bruising caused by injury. And he said on direct that he observed bruising. So the Commonwealth's not going to object to that. He said he observed bruising. He's going to have to explain it.
pardon me, had a tow truck driver actually put it onto the back of a flatbed. Ultimately, it was transported, correct?
Correct.
And you became aware at some point that there was video evidence. You just referenced it. Video evidence of that, I'm going to call it seizure process. Is that right?
Yes.
I mean, that's
And
exactly
that
what it
video
is.
evidence had,
They seized
timestamp on
the
it,
SUV.
correct?
yes.
okay. You're also aware, as the supervisor of Michael Proctor, that he swore under oath in multiple affidavits in support of search warrants that the SUV was seized at 5:30 p.m., correct?
Yes.
And you knew at the time, because you were actually there, and you knew when the vehicle was seized, that stating under oath in an affidavit that it was 5:30 p.m. and not 4:12 p.m., that was a false statement, correct?
There's a discrepancy in time there, yes.
Did you take any action
There was a discrepancy in time, yes. You're the supervisor. The time that the SUV was seized matters. And I don't think you can genuinely say that what they wrote was the time it arrived at Canton, because nobody said that.
And you yourself, as a supervisor, did you take any action
That-
to correct that false or misleading state? Let me ask it a different way. Did you take any action to correct that time to the accurate time of 4/12 in any of the affidavits that you became aware of?
No, the actual time of the seizure through the video, we learned much later. So the approximate time, 5:30, although inaccurate, I did not take any action to correct it, no.
And you received
Look, it's your job to know what time you seized something. So looking at a watch, which we know you wear, and making a note about what time the SUV is seized, isn't that part of the report writing process? But no, Proctor put 5:30 is when it was seized and put it in all of his search warrant affidavits instead of 4/12. Did it matter to them a lot at the time? Well, why did they change the time? It's not like it's just an hour off. Well, we didn't realize there was video until later. Right. We didn't know there was video showing what time it was taken till later. Isn't that the only reason that it was corrected then? Because there was video.
received that video as a production from the defense. You did not have access to that video, correct?
Yes.
And so at the time that Michael Proctor actually wrote and drafted these affidavits and swore to them under oath, he did not know that a video existed.
Correct.
Correct?
Objection.
Sustained, you have to word it differently.
Sure.
That's correct.
At the
That
time
calls,
that let me ask it a different
it calls for speculation as to what Proctor knew. It's going to have to go to what the investigating team knew. The investigating team doesn't know that there's a video that's going to contradict their time. Right.
way. At the time that you reviewed his declarations under oath,
It's just so bad.
you did not know that a video existed.
No, we did not know.
Jackson has kind of reworded himself a lot today. It's just so bad. And again, one thing might be an innocent one thing. It's too many things.
I may have just a moment, Your Honor.
Sure.
Blue Jays in the chat asked, where did the video come from? Karen Read's family. It was the video from Karen Read's dad's home, the Ring camera or the doorbell camera or what have you. But it's not just that, because I think the argument would then be made. It's like, oh, well, it came from Karen Read's side. They could have somehow manipulated the time on the camera, but it also links up to the travel time and then the Sallyport video. So it's not just the camera from Karen Read's dad's or parents' home in Dighton. It's also travel time in the snow and then the corresponding video at Canton. Steph, yes, the jury can use lack of investigation
I
as
wanna ask
reasonable
you
doubt.
about
Yes, they can. That's the
Something that was
whole
brought up on
point
direct examination.
of this type of argument for defense.
Sustained findings as it pertains to you.
We've moved right on. We've moved right on into Bukhenik getting in trouble, which is going to be real interesting. Lulu, I have never seen anything like this, but then again, I started working in Los Angeles after LAPD's Rampart scandal, so there was a consent decree. So there were already eyes on one of the departments that I worked with. But this is wild. All right.
You've already talked about the fact that, Sergeant, you're a supervisor and were a supervisor back in January of 2022 moving forward over Trooper Proctor, correct?
Yes.
Generally speaking, as a supervisor, your job is to properly and professionally supervise, show some authority over those in
Honesty
your
and
charge.
integrity.
Is that right?
Yes.
Michael Proctor was in fact a trooper in your charge.
Yes.
And you would agree that your supervision has a direct impact on the character and quality of the subordinate investigators that you supervise.
Yes.
The whole point of having supervision and a chain of command is to establish a certain amount of, for lack of a better phrase, quality control of the subordinates.
Yes.
That would
I
also
think
include
that's
quality
clear.
control over the subordinates' investigations.
Yes.
On August 17th, 2022, you were in a group text with the following individuals: Michael Proctor, Trooper Kukowski, a lieutenant named Fanning, and a trooper named DiCicco, D-I-C-I-C-C-O, correct?
Yes.
Jackson sounds positively restrained getting into this line of questioning, and he looks anxious. And I might be reading into it because I know some of what is in the texts, that he's sitting there being like, what is going to come? And I think the pause is actually worse for him. For those of you asking, is he still a supervisor? Yes, he is still a supervisor.
I'm handing you a document. Can you tell me if you recognize that document?
Dave Stop Powell asks, can he be jailed in the future if there's something in the future? He's already been disciplined for actions involved in this case. So there's already been an investigation. He was already disciplined. There's not going to be new discipline based on that old action that would go against due process. It would have to be something new. He's already, that's already been done. So. Kiwi Girl 75 said from New Zealand at 3 a.m. Tuesday.
I recognize
Great news. Monday was a
parts
great
of
day.
it.
I'm glad
You
you had a
saw
great
that
day
document
Monday.
on direct examination. I think you were shown
That
the
is
same
true.
document, correct?
Thank you. Harry asked, can the defense call Brian Higgins
It
and
was
Proctor?
different parts of it, but same. It's inclusive of within this document.
Okay.
They can.
Let's start with this. You indicated that
There's
you
some
did not
strategic
see
quirks to that. But
Michael
they can.
Proctor's name on that document, correct?
During direct, they skipped and hopped over the 3 texts he read in very
Correct.
quickly.
His name is not on here.
But you do recognize that as being reflective, accurately reflective of the text chain that you were on August 17th, 2022, that group chat.
Yes, sir.
Can you read it all?
I'm going to do this a little bit backward, but bear with me. You do see the name Kukowski, correct?
I do.
You do see the name Fanning, correct?
I do.
You do see the name DiCicco, correct?
I do.
And you do see the name Bukhenik, correct?
We might need to know.
No, it's misspelled, but I know they're probably referencing me.
Okay.
Someone misspelled his name. He is not happy with it. And yes, I think we do need a spoilers emoji.
The only other text or person texting on that chain is a code, a lengthy, almost like a URL code with no name, correct?
Yes, you're right.
And
Yes.
the only person that I didn't name, whose name I did not read off, it's obvious on that document, is Michael Proctor, correct?
Correct.
So deductive reasoning tells you that that is the code
Is
is
he going to
Michael
quibble
Proctor.
over
Is that
what
right?
deductive reasoning
I would agree
is?
with you, yes.
Okay.
Oh, thank God.
In that text chain,
I'm almost done the copy.
starts
We're not
with-
fighting over deduction.
Trooper DiCicco sending
at
a
us,
photograph,
everybody.
correct?
No.
The May I approach?
Yes.
Everybody is just positively calm this morning. It's really nice to see on a Monday. I'm really happy that everybody's just kind of chilled out a little bit. There's no need at this point to come in all guns blazing because it's going to be another long day across. It's better to save the frustration for later.
Do you see a photograph there?
Yes, I do.
Okay. Fair enough. There were some texts between and among the group that preceded this photograph, correct?
Yes.
I want to start on this date, August 17th.
And again, that's fair for him to say, hey, so the first thing that was texted was a photograph. No, there were multiple texts before the photograph. Fair.
2022
Fair.
with this photograph. This photograph was sent by Trooper DeChico to the group, correct?
I want to see the... That has Yannetti's name on it, from what I could see, the photo.
It possibly appears that way. I really can't. I mean,
Your Honor, with the
Yes.
court's permission, I'm not sure this document has been marked. I'd like to have this marked and
Sure,
admitted.
we'll mark it for ID.
LA had its own photo
I'd
scandal
actually like to have
over
it marked and
the
admitted.
death of Kobe
There's certain
Bryant.
things I'd like to show.
I covered that briefly.
What's the Commonwealth's position on that?
The
No objection to
County
admission,
of
but
Los
not in
Angeles
this
is
form.
paying quite a bit of
Yeah.
money on that civil lawsuit because first responders, including fire, were taking photos with their personal
do it?
phones.
I can,
They
what
should
I
not have been
intend to
taking.
do, I can do with one photograph. If I may have a moment with counsel.
Okay.
This I will zoom because it's not him delaying an answer. For all of you saying, V-Rod said EDB, I went, look at this photograph. Look, I went and saw Nickelback, and you know what they didn't play? Photograph. That night is a story that
I'd like
lives
to
in
publish
members only.
just one page of what's been marked for identification. I'm sorry, I would ask that it be marked, the entire document.
And I'm going to say it. Agree, don't. Creed was better live than Nickelback. That's what I'm saying. Creed was better live than Nickelback. Just hands down, a better live performance. Now, Creed and Nickelback are both performing, I think, in Wisconsin this summer, so you can go and judge for yourself. But I know. They played Rockstar. They didn't play Photograph.
Be marked for
Creed
identification.
was better live.
yeah, I need this.
Yeah, Creed was so good live. They were so good live.
And with the court's permission, I would ask to display or to
I
publish.
did not
page
ask for a refund on Nickelback
263
because
of that
my
document.
friend Amy Van Dyken took
So are
me.
you admitting into evidence, page 263?
I would.
Do you
just,
have a separate one rather than tearing it out of what's been marked for
I can-
identification?
I can take it out of this copy.
Popcorn history set as an early 2000s indie kid. I
Can you
hate every part of
redact it
that sentence.
before it's admitted, please?
It's been redacted.
Fair. Look, man, Creed was great live. They were so freaking good. It was fun. Three Doors Down played. Nashville was a very friendly crowd. It was good. It was good. Ketra, I didn't see that.
Here we're talking about the same thing, Sergeant.
That's really sad.
I
I
just
did
handed you
not
a
see that
page
about Three Doors Down not being on tour.
that's been marked.
They're local.
Exhibit 116. Do you recognize that as being a copy?
Just to talk about Middle Tennessee a bit more, it's really funny every time I go to a concert and somebody's like, oh, I live in Franklin. Oh, I live in Murfreesboro. Oh, I got to sleep in my own bed last night. I just love it. I love it. The amount of musicians here is great. The amount of kids who go to my kids' school where their parents are musicians in bands that I have seen on massive stadium tours blows me away. Just blows me away. I'm just like, oh, there's a kid in your band whose dad's a professional drummer with an amazing band that I love. That's wild.
Copy of one of the multiple pages in the document that you're holding that's been marked for identification as FF.
Yes, sir.
Okay, if we could publish that single page, please.
Okay.
Is that a photograph that was sent by Trooper DeChico.
For everyone who wanted to know, Taylor, that's amazing. For everyone who wanted to know what the photo was, I don't think we saw this last time. The big story, David Yannetti, criminal defense attorney. Bum, bum, bum.
To the group.
According to this document, yes.
Who is depicted in that photograph?
The big story, Mr. David Yannetti, criminal defense attorney.
Do you see that person in court?
Yes, I do.
Where is he seated and what is he wearing?
He's seated right there wearing a blue tie and
I don't remember this from last time at all.
dark suit, white shirt.
Thank you. We can bring the lights up.
And Mr. Yannetti is just like, thanks y'all for using a good photo. It's not even a shady screenshot.
Your Honor.
Okay.
How old is that photo? Who knows?
In response to...
Yannetti's like,
and
hey.
going back to the multi-page
If I was Yannetti, I would be turned towards the jury too. It me. They're talking about me.
document FF.
Why are you talking about me?
In response to Trooper DeChico's photograph that he sent to the group,
Context.
you responded to that photograph, did you not?
Yannetti looks appropriately mad. The cheekbones are still cheekboning though.
Yes, this document indicates so, yes.
And you responded by laughing at it, correct?
That's what it says, yes.
Well, that's what it says, or that's what you did?
I don't remember.
Trooper Proctor then, former Trooper Proctor,
Smart.
Michael Proctor, then
Smart
responded,
to just move
correct?
on.
That's
I
what
don't
it says
remember
here,
seeing
yes.
that picture either.
And he responded to the group, funny,
Oh boy.
I'm going through his retarded client's phone, correct?
That's what it says, yes.
Michael Proctor then responded again.
How many times is Jackson going to say that?
Is that right?
Yes.
He wrote, no nudes so far, correct?
That's what it says, yes.
Michael Proctor responded yet again. Is that right?
That's correct.
And in reference to Mr. Yannetti's photograph, he wrote, I hate that man. I truly hate him. Correct?
That's what it says.
These are the text, these are the context, because when the prosecution went through these, because he was disciplined in part because of these. It's giving context to the jury, because we all are sitting here, or at least a lot of us are sitting here going, we know he's talking about Yannetti because we have context for that. The jury didn't. So the defense is going back through and tying those back together to the fact that they are talking about Karen Read and they are talking about David Yannetti. The prosecution, I think, went through it about as best they could. They buried it in the middle of direct and they skipped right. Oh, they were just like, boop, boop. They skipped just right over it. So the defense circling back to it, I don't know if this will be towards the end of their cross-examination, but they're going to make sure the jury knows exactly who they're talking about, exactly who they're saying derogatory things about, and let the jury know they're talking about Yannetti and Karen Read.
There's a trooper by the name of Moore, M-O-O-R-E, correct?
There is.
And he disliked Trooper Proctor's phrase, his statement, no nudes so far.
Oh, there was a
correct?
thumbs down to that?
That's what it says.
There was
Does
a
that
thumbs down to
indicate
that?
you that Moore was
Oh,
disappointed
that's going to be objectionable.
that Trooper Proctor, Michael Proctor, had not found naked pictures of Miss Read as yet?
I don't know what that indicated for Mr. Moore.
And then you,
Trooper, I appreciate that you're trying to be honest in this regard on the stand. I'm just surprised that the answer isn't he was thumbs downing it because that's what we're not supposed to be looking for. I think he's being truthful with that. We can talk about the no nudes so far at some later point because I have different thoughts on that than how the defense portrays it, but we'll get there. But he's just like, I don't know. But the response was a thumbs down.
responded to the phrase, funny, I'm going through his retarded client's phone.
He's going to say that
Correct.
with the emphasis all the time.
I acknowledged that text message being sent.
You acknowledged it by liking it, correct? With a thumbs up.
I acknowledged it by responding with a thumbs up emoji.
The fact is, Trooper Proctor told you, his supervisor, in this series of text messages, that he was going through Miss Reed's phone. Is that right?
Correct.
And he also informed you, his supervisor, that he was going through her phone looking for nudes or naked pictures of her on her phone. Correct?
I disagree with the defense interpretation
He
of
did
that.
not tell me that he was going through the naked pictures.
I don't think it makes it any better, and I don't think it's a justification. The defense is going to read this as he is searching for nudes. I think it's an expectation when going through a phone search that nudes will be on the phone. That's how I interpret it because, well, there generally are. Every time somebody goes through a phone dump, there are very often nudes. So I can see where the defense is arguing it. I interpret it differently. If I'm the defense, I'm arguing it the exact same way. But I think it's I haven't come across this so far versus this is the goal. I think the goal is to put her in prison. I think that was the goal. But I think that the statement was, haven't come across this yet. That's how I interpret it. The defense is going to argue it how they argue it. Does it matter? No, it doesn't. It doesn't matter at all. I'm just saying in most phone dumps, there are in fact nudes. But does that matter? No, it's gross. He shouldn't be texting his supervisors, no nudes so far. Though, can I see it being like going through jail calls and being like, well, we haven't reached the phone sex part yet. Yeah, I can. Because in most jail calls, if you've got them recorded long enough, somebody's having phone sex. Are you looking for it? No. But is it coming at some point? Probably. But should they be texting this back and forth? No. It's gross. Is the jury going to agree with how the defense sees that? Probably. Does it get worse? 100% it gets worse. Like 100% it gets worse. So we will see. But that's how I think, well, I don't think that's what he was searching for. I think it was I'm searching the phone and we'll see what we see. But we'll see, because there's way worse coming up.
4 naked pictures through the phone.
He wrote.
But again, if this sergeant says, I don't think he's searching for that, I don't necessarily disagree.
For nudes or naked pictures of her on her phone. Correct?
I don't think it's okay.
He did not tell me that he was going through the naked pictures, 4 naked pictures through the phone.
He wrote, no nudes so far, right?
That is what is written.
That
yes.
is what's
What
written.
did you think he was looking for when he wrote that phrase?
No, Chat, you can absolutely disagree with me. I'm just giving you my context of
I don't know what he was looking for.
What
What I
would be
think
a
the context
reasonable
was.
interpretation of what Michael Proctor was looking for when he wrote, no nudes
that he's searching her phone, and in every phone dump, there is inevitably nudes of some sort. That.
so far?
I mean, literally every phone dump.
I don't know.
Motorcycles, handbags, pair of shoes,
Handbags for
or
sure.
naked pictures of Miss Karen Read?
His mission was to go through the phone to look for digital evidence that's related to the crime. The fact that he wrote no nude so far, I cannot comment on.
You cannot
probably
comment
can.
on, or you don't want to comment on.
I don't know what he was looking for in that specific time.
Have you ever seen a phone dump before? Like, have you ever seen a phone dump before? Have you ever seen a phone dump before? Is that an uncommon occurrence or a more common occurrence? Do you not look at phone dumps? But also, he's not going to speculate. And I appreciate that he's not going to defend it either. I don't think it's defensible. And I think in the rest of the context, I don't think there's any stepping away from Proctor objectifying Karen Read. The jury just doesn't know that yet. But we'll see.
You certainly did nothing. You took no action to stop him from potentially looking for naked pictures of my client, correct?
Gator
That's
Pam,
correct.
fair enough. I don't phone dump my friends.
In fact,
but I've seen
last
phone
week you
dumps at work.
testified that in your view, Michael Proctor handled himself in this investigation
That's the question.
with integrity.
That's
That's what
the
you
question.
said, correct?
That's correct.
That's the question. You go through the 3 texts and then you ask the question. That's the
Do you
question.
stand by that testimony?
Emily, stop talking about the fact that phone dumps always have nudes.
Nudes so far.
I don't know.
Motorcycles, handbags.
I wouldn't expect
pair of
motorcycles
shoes,
on Karen Read's phone. Handbags and
or
shoes,
naked
possibly.
pictures of Miss Karen Read.
His mission was to go through the phone to look for digital evidence that's related to the crime. The fact that he wrote no nude so far, I cannot comment on.
You cannot
Good
comment on,
answer.
or you don't want to comment on.
I don't know what he was looking
Good
for in that
question.
specific time.
You certainly did nothing. You took no action to stop him from potentially looking for naked pictures of my client, correct?
That's correct.
In fact, last week you testified that in your view, Michael Proctor handled himself in this investigation with integrity. That's what
That's
you said.
the question.
Correct?
That's correct.
Do you stand by that testimony?
The investigation was handled with integrity and honor.
Do you stand by your testimony that
Could he have spit those words out any faster? Here's the thing. You've got a group text where they are demeaning Karen Read, and we haven't even gotten to the rest of it, and joking about no nudes so far going through the phone extraction. How do you even spit those words out knowing what you know?
Michael Proctor conducted himself during the course of this investigation with integrity?
Yes, I do.
Then why was he fired?
He also called her retarded, correct?
That is what's written.
That's what's written? That's a very passive way of saying it, Sergeant. That's what's written, or that's what he wrote?
That's what he wrote.
And that's what you read.
I have no memory of reading that. I acknowledged him going through the phone
Sir, we don't,
on my
we just
Apple
don't,
Watch.
We just
I have
don't
no
believe
memory
you.
of him writing
We just don't believe you.
retarded on a text message.
We just don't
And
believe
you'll agree
you.
that that is one of the most vile and
Well-
insensitive and incendiary terms one could use in modern society.
I think he used
Retarded.
a lot of terms
Correct?
that fit
That is correct.
bill.
And in fact, through your response to that vile phrase, you encouraged it because you liked it with a thumbs up, correct?
Objection.
Renee, we have not gotten the rest of Proctor's
you
text, only
encourage-
these 3.
That statement by Michael Proctor by liking it with a thumbs up.
I don't know if it encouraged him, but so I cannot speak
But
to
that's
that.
You're his supervisor. You're his supervisor in a work group text. You're his supervisor. You're his supervisor. And you were just like, thumbs up, glad you're going through the phone. Sir, what?
You did.
I acknowledged the text message being sent.
I want to be clear. These
Sure.
text messages were sent to
sure.
you by your direct report, by your direct subordinate, correct?
Sure.
That's correct.
And there was even someone on that
We just
text
don't
chain
believe you.
who was more senior than you, Lieutenant Fanning, right?
That's correct.
Michael Proctor was both your partner and the lead investigator on this case when he wrote that, correct?
He's a subordinate, and he was the case officer.
Chad has been so restrained in not calling you names, sir. I'm really proud of them. You, on the other hand, still have a job,
This
which is kind of
thread-
shocking.
Text thread
Not just based on these texts.
contains communications between a subordinate, the person you call the case officer. By the way, let me ask you another question. Did you ever, during the course of the investigation in which you were a part, the sustained findings, the internal affairs investigation, did you ever review Colonel Noble's determinations about your subordinate, Michael Proctor?
Objection.
Did you review them?
No, Your Honor, I did not.
Really? 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 The tightness of your
What
collar
would
says
Colonel
not
Noble
really?
call Michael Proctor's title in this case?
Emily.
You think he'd call him the case officer or the lead investigator? What is your experience with?
He said he didn't see it. This is going to be hard to get into, but in the sustained findings against Proctor, they call him the lead investigator. They call him the lead investigator. But he's like, I didn't review it.
Massachusetts State Police in that regard?
Objection.
Sustained.
Glitz and Glitter said, Emily, you're giving us too much credit. We're calling him names, just not in chat. That's what the credit is for. It's positive restraint.
Notwithstanding the fact that a subordinate was
absolute
on
restraint.
this text chain and a supervisor to you. Was Lieutenant Fanning one of your supervisors?
Yes.
Notwithstanding the fact that a subordinate was on this text chain and one of your supervisors was on this text chain, you felt comfortable enough within this group of law enforcement to actually like when the subordinate refers to a suspect as retarded. Correct?
I acknowledge the text message with
Y'all were
the
just
thumbs
fine
up
with it.
emoji.
Y'all were just fine with
Do you
it.
believe that?
Y'all are just fine with it. Exactly.
Well, let me ask you another question, a predicate question.
What else are y'all fine with?
You were also comfortable enough
Bing, bing, bing.
with that text chain to receive information that your subordinate was looking for naked pictures on a suspect's phone, a woman, no less. Correct? You took no remedial action against Trooper Proctor for that, correct?
No, I did not. No.
Do you believe, as you sit here, that that was a misuse of power and authority by a Massachusetts State Police officer?
By myself or
No,
somebody else?
by Michael Proctor.
Sir.
Misuse of what?
Misuse of authority and power. To go through a suspect's phone, to get her phone using the authority and the power vested in that officer by the
These are
community
good
members.
questions.
That's the power that you derive, correct? You work for the public. Would you agree?
Sustained.
Do you believe it was a misuse of his authority and power to use Massachusetts State Police authority to go through her phone and look for naked pictures of her?
Objection.
Sustained.
Do you believe it was a misuse of authority or power to go through her phone and potentially look for nudes?
Objection.
Sustained.
Let me ask it differently.
That's probably wise at this point.
Did you think his text was appropriate?
It's a good question. Put him right
I
on the
don't
spot.
remember reading that text.
As you
so-
sit here now,
The jury is sitting there answering in their head, I imagine, like all of you are. When he's saying, do you think it's a misuse of power? The jury's sitting there going, obviously. And now we're getting to, do you think these texts are appropriate?
do you think that text is appropriate?
No, it is not.
Do you think it's professional?
No, it is not.
Do you think it shows integrity?
That text message does not show integrity.
Do you think it shows
Honor.
A word I expect you hold dear.
That text
Marine.
message does not show honor.
Right. What about the others?
On October 15th, 2022, you completed a performance review of Michael Proctor, correct?
That's correct.
Sir,
Specifically,
you're sitting here representing the
You were
Massachusetts
asked
State Police.
to rank his, quote, oral and written communication skills, end quote, correct?
Correct.
That's part of an overall evaluation and performance review. Is that right?
Yes, overall 90-day, quarterly, annual review.
You were specifically asked to rank
Oh boy.
whether he effectively would whether members, your subordinates, would effectively communicate with others, both within and outside the department, in oral and written form, correct?
That's correct.
And you rated him as exceptional, a number 4 rating out of 5, correct?
That's correct.
You actually went on to write and comment on Michael Proctor. And you wrote,
I wanna know
quote,
the date
Trooper
of this.
Michael Proctor displays professional demeanor, composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public.
What date is that
This is
from?
seen during interviews with witnesses, suspects, as well as victims and their families, end quote. That was a statement you wrote about Michael Proctor, correct?
Good use of performance
correct.
exam.
And
He
this
said
is
the date.
after
Thank you, Chad.
The
October
text chain
15th.
that we've just been talking about,
Thank
where
you.
he calls Miss Read retarded and references looking for nude photographs of her, correct?
That is correct.
I mean, he didn't back
Was your
away from it
statement
or
in that
stutter.
evaluation true or false?
It was true.
Okay.
You knew Michael Proctor's proclivities, obviously. He told them to you, correct?
The term proclivities,
You
what does that
knew
mean?
what he tended to do, what he wanted to do through his own comments, to look for nudes on a woman's phone, correct?
Objection.
Sustained.
You were aware, sir,
Calls for speculation.
that he had received evidence in a case, evidence that doesn't belong to him, belongs to the Massachusetts State Police, at least at that point, correct? Cell phone.
I was aware that he received a cell phone, yes.
And he used that power and the authority to go through that cell phone and look for nudes of my client, correct?
Objection.
Sustained.
Those call for speculation.
During the same course
I don't think-
of your evaluation, you were also
Do you think Jackson really cares about an answer, though? At that point, it's also kind of argumentative. But do you think that Jackson cares about an answer to those? I don't think Jackson gives a shit if he answers it or not. The question's the point.
asked to evaluate his investigative ability, correct?
That's correct.
You rated him the highest
And he's going to keep
standard
asking
in the
it.
Massachusetts State Police, outstanding, a 5, correct?
That's correct.
And you went on to write about Michael Proctor in the commentary below that rating to justify it. Is that
Look
right?
at how
That
good
is accurate,
Proctor's
yes.
performance review was.
You wrote, quote, Trooper Proctor
Woof.
has had a high-profile caseload with a lot of eye and pressure from external sources during the first day of the investigation. He handled himself and all the case with utmost professionalism and competence. He is able to investigate his case thoroughly and with strict integrity, end quote. Correct?
Sir.
Which quarterly review was this?
This is the same one. October 2022. Is that right? Those are your comments.
That sounds very accurate. I just was not sure which quarterly review that was for.
Is that what all his quarterly reviews read like then?
Professionalism.
Yes.
You believe that he acted in accordance with the highest standards of professionalism?
During his 90-day performance, yes.
Which
And you didn't
includes
just
this
say he
case.
displayed professionalism. You said utmost professionalism, correct?
Yes.
Competence. Do you
Yeah.
believe he displayed competence?
Yes.
And not just in integrity, but he conducted himself, as you've put it, with strict integrity. Is that right?
That is correct.
Did it show integrity in your view when your subordinate Michael Proctor called Miss Read retarded?
Objection.
I'll allow that one.
I didn't read that
I believe
text.
that as a U.S. citizen, he has the right to comment. That's his First Amendment right.
It's a work group text. It's a work group text. It's a work group text. I can't believe I didn't have the First Amendment on my bingo card. Maybe I should have. It's a work text. There are restrictions in how you comport yourself at work.
conducted himself, as you put
Sir.
it, with strict
Wow.
integrity. Is that right?
That is correct.
Just wow. Just
Did
wow.
it show integrity in your view when your subordinate Michael Proctor called Miss Reed retarded?
Objection.
I'll allow that one.
I believe that as a U.S. citizen, he has the right to comment. That's his First Amendment right. We uphold the Constitution, and it's unfortunate, unprofessional what he said in the private text message communication. He might have been voicing his frustrations. I cannot speak for Michael Proctor. It is unprofessional and unfortunate that he said that.
This was not, Sergeant Bukhenik, a private text message conversation. This was with his boss and 4 or 5 other individuals, one of whom was your boss.
Like the bossy boss.
Correct.
Who says that shit in front of like the bossy boss? It just goes to the culture. Because they're real comfortable. Like real comfortable.
Correct.
This was a communication intended for and received by members of his unit in furtherance of his investigative authority, correct?
It was amongst members of the unit.
He was updating his boss about what he was.
Chat, I don't think we can go to code red yet. Because I think he actually answered what he thinks. I think we're at bruh.
Bruh.
I just think we're at bruh. I think we're at bruh. I don't think we're all the way to WTF just yet because I think we're at bruh. We're between bruh and audacity. But if we go directly to red, we've got nowhere left to go. And I know. I think we need a little bit of buffer room because I feel like there's ways it can get worse. So I grant you a code, bruh. We'll hold on to an audacity. We might need an audacity because what the fuck? I hear you. I hear
doing
you.
in furtherance of the
We'll go,
investigation,
bruh. Let me
going
change the
through her
lights.
phone.
It is audacity.
No, I would disagree with you on that. This was a group chain, text message chain that we were discussing private matters in our personal lives.
Private matter.
You're not discussing private matters when he's discussing searching the phone. Isn't this on your work phone?
Boss and 4 or 5 other individuals, one of whom was your boss, correct?
Correct.
This was a communication intended for and received by members of his unit in furtherance of his investigative authority, correct?
It was amongst members of the unit.
He was updating his boss about what he was doing in furtherance of the investigation, going through her phone, correct?
No, I would disagree with you on that. This was a group chain, text message chain that we were discussing private matters in our personal lives.
Private matters, including going through Miss Reed's phone?
That is unfortunately shared on that group text.
So in other words,
Should have been on a different group text.
to the public, he holds one face in private conversations with you and your colleagues within the unit. He shows a completely different face, private face, correct?
Objection.
Sustained.
It's argumentative.
You said that he
And calls
thinks
for
you
speculation.
believe that he has a constitutional right, a First Amendment right,
He said that.
to call Miss Reed a suspect in his official investigation, in his official capacity as a Massachusetts state trooper, to call her retarded? That's your justification?
Jackson's going to say that in court as much as possible.
Do you justify his statement, that vile statement?
I do not know.
Do you think it's appropriate, given the fact that he has a First Amendment right to say whatever he wants?
No, I do not.
But you said,
Do you think there actually might be members of the community, parents, siblings,
Objection.
children?
Mr. Jackson, I'm going to exclude that question as argumentative. Move on.
There's been a lot of argumentative questions.
You wrote in your report.
He's gotten a
if I may
number
have
of them
moment, Your
in.
Honor. You wrote in your report about his
Way
conduct.
argumentative.
He shows composure, dignity, and respect during the
That's
performance
the
of his
question.
duties, and especially during his interactions with the public. He has a duty to the public, to the community that he serves, correct?
Yes, he does.
Just like you have a duty
It's just gonna
to
do it
the
a different
public
way.
and the community that you serve. Is that right?
That is correct.
Do you think community members might take offense to the use of the
Objection.
word retarded?
Sustained. It's argumentative again, Mr. Jackson. Please don't do that.
Your Honor, if you're worried about it, call him to sidebar. If they're continually argumentative, which a lot of them have been, call him to sidebar. Just call him to sidebar.
He didn't just put it, that derogatory comment. He didn't just put it, or he didn't just say it, correct? You talked about the First Amendment.
I mean, I don't know why we're spending this long on these texts when there are more that are going to come in at some point. But I think the stronger argument for this is he said this in a text, and after that, your performance review was this. I think it's a better line of questioning.
Objection.
Sustained.
I'm not finished with my question, if I could.
Nope.
So just ask a question.
Sure.
No comments first.
Woo, buddy.
My question is, did he just say the word, or did he go further than just saying it?
Objection.
Okay, we've gone through this. Move on, please.
The fact is, Sergeant, you put it in writing and you liked it, correct?
I acknowledge the text message. I never saw the vile term.
Your Honor, may we approach it just very briefly for a scheduling issue?
Okay, jurors, feel free to stand up and stretch.
I wonder where we're going to get with a scheduling issue like, Your Honor, I need to know now, are they calling Proctor or not? Because I've got more questions. They are going to sidebar. That is a long sidebar. We are almost caught up in real time, and we had quite a lot of Zoom room.
You are unmuted.
I bet they excused the jury for the morning break as we are coming back. I bet it seems that they took the morning break. That doesn't surprise me. So we have very little Zoom room left, which is fine. I saw two great questions in the chat, so I'm going to answer them real quick. Terry asked, are the other texts somehow not coming in? The other text will likely come in through Proctor. I don't know if the other text can come in through this witness. The witness was disciplined for a number of texts, and those are the ones that are coming in, and wrote the performance review after he saw those texts. But if he's not on the other text thread, and I don't remember if he is, or if it's the same text thread, if he's not on the other thread, he can't be asked about the other texts. So that's where we're going with that. Julie MC, question, can you quickly define argumentative for us? It is a question that is making an argument, not argumentative like bickering back and forth with the witness. It's argumentative that the question itself is making an argument to the jury. And in cross-examination, there's a fine line between questions and questions that are making argument. But wouldn't members of the public be offended, or shouldn't members of the public be offended, is going to argument to be made in closing argument. It can also call for speculation, because now you have to think of what members of the community might feel. So there's a couple different reasons why those are objectionable. Does Jackson care? No, he doesn't. He's like, okay, Your Honor, yell at me in front of the jury again. Because the jury's going to be completely put off by these texts. Any jury would be. So we're going to keep going through that, I imagine. Nightshade Winter said, Emily, I know this is off topic, but heck, I finally had my baby girl on Friday. I went into labor before you went live and gave birth in 6 hours. Nightshade Winter, congratulations. Happy Mother's Day. And I hope that all is well. Get some rest. My best advice is sleep when baby sleeps. And remember that you now exist on a 24-hour sleep clock, not like a nighttime is this time to this time. So you've got to try to be on that 24-hour sleep clock. It is the best advice I can give. Ask for help as much as you can, because you will be exhausted. Baby will be exhausted. Just sleep. It is totally okay to also just binge watch trash TV or this trial well, baby sleeps if it is soothing. So rest as much as you can. All right, let's continue on.
So, Mr. Jackson, I've considered your argument, and this
No.
is simply the wrong.
Jury's not in. Retract everything I say. Retract. The jury's not in yet. They argued at sidebar, and the court is coming back to give them a ruling.
Witness, so I'm not permitting that line of testimony. So, Mr. Jackson, I've considered your argument, and this is simply the wrong witness, so I'm not permitting that line of testimony.
Even for the singular request that I made sidebar.
For that, so. All right, I think the jurors are on their way.
Rise to the jury.
I think the jury is on their way, is what the court said. She said, I think this is the wrong witness, which is likely what they discussed with scheduling, whether or not this was the right witness. I know Karen Read has said she thinks that the Commonwealth is not calling Proctor, but I'm not going to base what the Commonwealth may or may do off of what Karen Read's perception of it is. They might not, but the defense can call Proctor as well. At some point, Proctor's going to testify. Who calls him is really the
Whenever
question.
you're ready.
Thank you, Your Honor. Sergeant, I'd like to move to a different area. At some point during the course of your investigation, you and Michael Proctor interviewed Chris and Julie Albert, correct?
That's correct.
That was at the Albert residence, the Chris and Julie Albert residence, is that right?
Yes.
On or about February 10th, 2022?
All right, we're moving into a different line of questioning.
Yes,
Does that sound right?
it does.
Okay. At any point before or during that interview, did Michael Proctor discuss with you a previous relationship
that's a great question. I'm gonna
that
hold on
he
to it.
and or his family had with Chris and Julie Albert or their family?
Yes, as we were walking up to the door, he stated that he knows them from he knows of them from around town and through
Knows them or
friendship.
knows of them?
Did that cause you any concern that the case officer that had been assigned to the case, dealing with, obviously, involving the Albert family, had a pre-existing familiarity or relationship with any members of the Albert family?
Yes, I followed up asking him if he hangs out with these people, how well he knows them, and he stated that he does not hang out with them. They're not his friends. He just happens to know them through people in town.
Did he tell you any specifics about communications he had related to Chris and Julie Albert?
No, he did not.
Did he tell you any specifics about communications Michael Proctor had with his sister as it pertained to Chris and Julie Albert?
No.
Proctor might have downplayed
Did
the
he
nature of that
volunteer any
relationship to this
information
witness.
about
May well be the case.
the relationship that
Doesn't make
he
it
might have
better.
or his family might have, including his wife, with Chris and or Julie Albert?
That information did not come up.
Right.
Did you ever later learn, now I'm taking it outside of your conversation with Michael Proctor, did you ever later learn about friendship or connection that he and his family, Michael Proctor's family, had with Chris and Julie Albert or the Albert family?
I've learned of accusations. I don't know the extent of how familiar they are.
What accusations have you learned?
Through trial or through court proceedings.
Right, what are they?
What are
Give me
they?
the nature of what you've learned.
Objection.
No, what did he learn?
Sustained, we need a time frame.
Sure. When did you learn of these, of this information?
That was
Timeframe's not the
July
issue.
of 2023, I believe.
And what were the circumstances in which you gained this knowledge?
He said prior court proceedings.
There were accusations that Michael Proctor had familial friendship with these individuals, but the accusations were not factual.
Did you learn any specifics?
It sounds like the words are difficult coming out of your throat, sir. It sounds like you are having a hard time like saying the words out of your throat. He's like, they had no basis, which means he's going to, or they were not factual, which means now we're going to get into all of it because Proctor's kids were babysat. The jury doesn't know that yet, but I imagine saying he doesn't even know them is not going to go well.
Of the allegations, you used the word allegations, or I think you used the word accusations.
Yes,
Go the way you think it's going to go, dude.
there were.
You just said that there, what were some of the specifics?
Objection.
Sustained.
Well,
Oh no, he answered.
by the way, did you say that you learned of
He
these
can be asked about all of this, I think.
accusations during the last proceeding in this case?
Not the last proceeding. I
Or a
said
prior proceeding in this case?
it was through court proceedings.
Okay, how did you learn that specifically, Sergeant? Did you watch some of the proceedings? Were they televised? Did someone
Did you
report it
talk to
you?
Proctor?
What were the circumstances?
I was present in court.
This was what year? 2020, 2023.
Yes.
And did you take any
fair.
action to investigate further the accusations that you said came up in 2023?
No. Well, yes, I did. Yes.
Okay, what did you do in that regard? What were the accusations and what did you do to investigate?
How'd you
The
determine they weren't
information had
factual?
been learned and that it was not factual. So
Okay, you're using the word information. Help me out. Details. What'd you learn?
there was claims that
I object.
Sustained.
Jackson's going to have to ask it a different way. However, he said he looked into it. So asking, what did you look into would be helpful.
May we approach, Your Honor?
He looked into it. You're allowed to ask him what he looked into. And it's not improper for him to be present in court, depending on the proceeding, if there's no sequestration order. He's also now being treated as the lead investigator. This also, I imagine, and this is me speculating, would have come up in part of the conversation around Proctor's disciplinary hearing. We're going to zoom past this break after one question that I wanted to get to. Ryan Johnson asked in the chat, if the defense calls Proctor, does that limit how they can question him? It may, but we are far afield from that. It may limit the way they can question his text messages. It is, I think, net positive for the defense if the prosecution calls him. But I also think there's room to argue if the Commonwealth doesn't call him. However, the text messages, if they are subject or part of the disciplinary proceeding, they can question him about the disciplinary proceeding, and then the text can come up as part of the disciplinary proceeding. So I don't think they would be greatly limited. They would be limited in that they can't cross-examine him unless he then became a hostile witness and was designated as such. But that's a whole, back to the fan. That means it's going to be a longer sidebar than we anticipated. All right, let's keep zooming to try and get past this sidebar. The court earlier today, I'm trying to limit sidebars also today, this. What if the defense calls Trooper Proctor, is he considered a hostile witness? Not until he becomes a hostile witness. No, because they called him. A hostile witness is not based on vibes. It is based on being allowed to treat the witness that you call as an opposing witness. So being able to do cross-examination instead of direct examination on a witness you call, but there's a process for that to be determined. So.
Final question, Sergeant. I think
moving
I
on
asked
from
this,
that.
but let me make sure I'm clear. Your interview, along with Michael Proctor, with Chris and Julie Albert, was February 10th, 2022, correct?
I believe so.
Okay.
I'm not certain on that, but I believe it was.
Okay. Well, let me just clear that up real quick. Would it refresh your recollection to look at your report?
Yes, absolutely.
Now they're all friendly. I think final question on this line of questioning.
Thank you.
Does that refresh your recollection, Sergeant?
Yes, sir.
What was the date?
February 10th.
Thank you. Okay, I want to move
This is
to
with Chris and Julie Albert.
back to Canton PD. Did you at some point recover some videos?
There it
or a
is.
series of.
We did a poll on this Friday, and the majority of you thought that somehow we were going to get to the Sallyport witness, and we are now going to get, I think, or the Sallyport witness, the Sallyport videos, the ghost of the Sallyport cameras. I think that's the direction we're going in now with Cross.
Electronic data that purported to be videos from Canton PD in furtherance of your investigation?
Yes.
And to whom did you deliver these
Who said
videos,
ride
and whom
Sally?
were they
Natalie D in the
requested
chat
by?
said ride Sally, ride.
The initial request was by Michael Proctor. I delivered them to him.
Okay. Since that delivery, have you seen these videos?
Yep.
Yes, I have.
Okay.
Oh boy, oh boy.
No, I'm holding a flash drive.
Sometimes I think the waiting makes it worse for this witness. What do you think? Do you think it's worse when he has to sit there and wait for Jackson to decide what he's going to ask next?
A couple of seconds of it and just establish the foundation first with the court's permission.
Have you shown it or discussed this with Mr. Brennan?
I've just discussed it with Mr. Brennan at the break.
What's the Commonwealth's position? I have no idea what it is.
You do too. How can we not assume it's, if I'm being fair, it could be the defense corrected Sallyport video and it could be the original Sallyport video. We know there's Sallyport videos, but it could be either version. So I guess that's fair.
Sure, we can mark it. Yes. Mr. Brennan said he'd like to review them before they get entered into evidence. We can mark it for ID for purposes of this examination.
I don't expect I'll object. I just want to review.
Okay. So we'll mark it for identification, please, ma'am.
Which one are they?
Exhibit GG for identification.
Marked for ID
Just to establish
before they
the
come in as
foundation
evidence.
so we know what we're talking about, did you see on some of the electronic devices that you picked up in furtherance of this investigation video of somebody outside, now the outside cameras?
Chad, who said probably the Higgins video? Not when the car's arriving.
Or outside camera view at Canton PD at about 1:30 in the morning on January 29th, 2022.
The digital video, one of the collection items. It wasn't a device. It was, well, I guess it is a device, but the digital storage that was collected had video from external view of the PD. I do not remember specifically seeing an individual, but I did review it.
Being of the parking lot area, at least one of them, one of the clips being of the parking lot area outside Canton PD.
I don't remember seeing outside parking lot. I'd have to see it.
I understand. Do you remember another clip being of the outside Sallyport? There's a pedestrian door, not the big roll-up door, but a pedestrian door. Someone going in and out of the pedestrian door.
I know the view you're talking about, but specifically what you're stating, I'd have to see the video, tell you if I saw it or not.
And I'm asking a couple of these other questions. I think I may know what the answer is. There's another, do you remember another video being an internal corridor?
I think I may know what the answer is. I think you may, counsel.
Yes,
Do you
yes,
remember that one?
I do.
Okay, and then one on the outside, again, sort of passing from right to left, may not be attended to a parking lot, but at least an outdoor view of someone moving from frame right to frame left across the camera angle.
I don't remember that.
You do remember that all these videos, I just mentioned 4, we've talked about 4, these videos were from January 29th, 2022, around generally 1:30, 1:45, 2 o'clock in the morning?
I'm sorry, I don't remember the exact time and date. I just remember seeing the file and reviewing it.
Do you remember Mr.
And then turning it
Proctor
over.
asking for video attendant to January 29th? At least can we narrow it to that date?
From Canton PD?
Yes.
Yes,
Okay.
yes.
So these are all from January 29th, 2022. You just don't remember the specifics of them. It's been too long since you've seen them.
I don't know when each video was collected and then reviewed.
Okay.
Exactly.
With the court's permission, well, may I have just a moment to confer with counsel?
Okay.
He would need to be refreshed on that before we would
With the court's permission,
get into
I'd
it
ask
more.
that, what's been marked as GG, at least the first video be published for the jurors.
All right, so there are 4
He has to
videos on this
review
flash
it
drive?
first, no?
One video, 4 different camera angles as it's set from the one video.
Are you ready to see this now? I thought you wanted to review it.
I'll agree, and if I have a problem, I'll let the court know. I have no problem.
All right, so for the first one, the first camera angle?
Correct.
Okay.
It's one video, but 4 different angles.
All right, we just have to keep
Okay.
Understood.
asking all these
It's a
questions.
little complicated, I get it.
All right, we can do that.
Thank you.
Okay, we're going to see some of the outside
And
video
this
that I
is-
don't think we've seen yet.
Your Honor, just for the record, actually, let me do it this
I'm
way.
gonna go off screen real quick
Sergeant,
because
would
my
you
chair's
agree that
pissing me
we can
off.
call this the rear lot main side at Canton PD, just for identification purposes?
Sure, if you'd like.
He's like, I don't know.
I'm not.
Familiar
I don't
with
know
Canton PD.
which side this is, so I can't argue with you about the location. So
Okay.
I'll agree with you that we can call it that.
Great. It looks like a parking lot. There's cars.
Yes, yes, sir.
Okay. Just for purposes of, so it doesn't get complicated, we'll call this rear lot main side. That doesn't mean anything unless you adopt it. So just for identification purposes.
He's like, I
Thank
don't
you.
know Canton
If
PD
we
well
could
enough.
move to runtime 1:26:32. Okay. With the court's permission, may I play it at this point?
Okay.
Thank you. Stop. Did you see a car pass in front?
Yes, sir.
I did.
Okay. What kind of car did that look like to you?
Beep, beep.
It looked like a 2-door Jeep Wrangler with a plow on it.
Okay. Let's go ahead and play it.
I think it's really helpful that they get a look at the Jeep with the plow and the amount of snow, maybe slightly more than you could track a cat by at this
Okay,
point.
stop.
And you get the time.
Sergeant, did you, during the course of your investigation, learn whether or not anybody associated with your
I know.
investigation had a 2-door Jeep Wrangler with a plow on it?
Yes,
Who is that?
Mr. Brian Higgins.
Okay, thank you.
So
Let's
this
go
is
ahead and play
1:25 a.m. according to the camera at 1:29. I think we're now at 1:26 with Higgins getting out of the car. That's really good to establish time. You see Higgins, well, you see a figure walking in the snow. We can assume it's Higgins. We're going to see his sweatshirt. You could see him pull out a device. You saw the screen light up.
Okay, stop. Sir, do you see a person who appears to have alighted from the car,
Yes.
from the Jeep?
Miguelino, will you let the app know we're getting to the Higgins videos from Canton PD? Because I feel like some of our app crew might want to come and see what we have not seen yet.
Sergeant, if you could turn your attention to the
Thank you.
screen on the right. Does that appear to be the location of the person that you're describing?
That's the individual that came out of the vehicle, yes.
Okay. I know it's super blurry. May not be able to at this point. Do you know who that is?
I do not know.
Okay. Let's go ahead and play it. Okay, stop. All right, did you see the person walk off the screen?
Yes.
Did it appear that that person had something in his or her hands?
It did. Play it again.
Possibly, yes.
Okay. May I have a moment, Your Honor?
Okay.
Thank you, Your Honor. If we could play the second clip on this same GG. before this is played, Sergeant, do you recognize what's depicted in this photograph?
I do not know.
Okay. Let's go ahead and play this. Stop. What do you see on the video at this point?
An individual crossing the frame with a couple of cars parked, one of which has a plow on it.
Does it look like an exterior video?
Yes.
Does that appear to be an exterior video if you don't know exactly where, an exterior video of Canton PD?
From the facilities, yes.
Okay. And describe the person that you see in the foreground at the bottom of the screen.
Hoodie.
Appears to be wearing a black sweatshirt, a hooded sweatshirt.
Larger in stature, smaller in stature, can you tell?
I'd be speculating because there's no comparison, but possibly larger. I don't know.
Okay, let's go ahead and play it. And that's it for that. Your Honor, if we could play the next video. By the way, can we agree, before we move off of this, just for identification purposes, can we agree to call this rear lot cruiser side
I mean,
as opposed to rear lot main side?
I don't know
just
if he
to
has
keep it
any
separate?
idea, but
Same as last time. I'm not aware where, familiar where that
I'm gonna
camera
move my
is, so I
chair.
cannot.
I'm right here. you can
I
still hear
cannot
me.
argue with you nor adopt, but if for
He's like, I don't know
identification
Canton
purposes
PD.
only, we can agree on that.
Can you see from where you are, I know the answer to this, can you see from where you are the timestamp on the bottom of this?
No.
Your Honor, with the court's permission, it's very, very small. Is it possible to ask the witness to adjourn from the witness stand just to get close enough to see if he can read the...
You can't increase the size of it?
Maybe we can. I'm not the tech guy. Mr. Wolk?
The court's like, you can't embiggen the timestamp? Embiggen.
Magic.
127:41 on the timestamp.
Okay. Can you
There
read
we
that?
go.
Yes, it says rear lot cruiser side.
Okay. What about the time?
The timestamp reads 1:27:41.
Do you see a date?
Yes.
What is that date?
1/29/2022.
Thank you. This was my fault. Your Honor, if we could move back to rear lot main side, I'd like to do the same thing. I failed to ask for the time and date on that one.
I'm glad they're going to go back to the other one. Hopefully they're going to embiggen. I saw it, but rear lot
Is it
main
possible to
side.
see from there the time and date?
Yes, the time is 1:27:32 a.m. and the date is 1/29/2022.
Thank you. Okay, if we can move to the third clip.
I'm glad they embiggened it. I'm going to leave myself up at the top for a minute because I think it's easier.
If we could start, Mr. Wolk, by enhancing with the court's permission the time and date. Let's just start with that. Do you see what the timestamp designates this camera angle to be?
Church
It
side?
appears to be church side. And I can't read the third word there.
Exterior?
Oh, yes, exterior. Sallyport.
Okay, and if you could tell the jurors what you see in terms of the time and date.
The time is 1:27:43 a.m. and the date is 1/29/2022.
Thank you. Mr. Wolk, if you could play that with the court's permission.
Okay.
Stop. Do you see a person in that video?
I do.
Although it's somewhat blurry, can you describe that individual for us, please?
Individual wearing dark
Person.
clothing, possibly. I
Possibly in a
that's the
hoodie.
best I could do, really.
Okay. Does it appear, given what you've seen in terms of the time of the main side, cruiser side, and now this exterior church side, does that appear to be the same person moving through on the outside of Canton PD?
It does, yes.
Okay. And what are we looking at here, by the way? What is this door he's about to walk into?
I'd be guessing. I was never
Don't
present
guess.
on that side of the Sallyport.
Understood.
I
Don't
don't know.
guess.
Let's go ahead and play this.
Somebody from Canton can probably answer these questions at some point.
And for the final clip,
Everyone in the chat saying, did we see these videos before? No, we didn't. This is going to be from inside
go down to the
Canton.
timestamp
Yes,
and
chat,
date.
sorry, I did not move the closed captions when I moved me. Apologies.
a little bigger, Mr. Walker.
I was moving my chair because it was making me mad. Some
Can
days
you
are just
see
like
what that is designated as that camera angle?
Yes, it says first floor corridor,
Look at how clear these are.
and the time is 1:28:03 a.m. on the 29th of January, 2022.
Okay. Is this the corridor
Look how clear. Look how clear that video
version of
is.
video that you did have some recollection of?
Yes, this is, yes.
Okay.
So a lot of questions in the chat about where these came from. We covered this in pretrial motions. They kind of miraculously appeared after the last trial and were turned over to the defense. But they appeared because they were found in some kind of a file or something. I'm going to leave myself at the bottom.
Go ahead and
But
play this.
there was a lot of pretrial motions about them. But I don't think these did not come from federal officers.
Stop. Do you recognize the person in this video?
It appears to be Mr. Brian Higgins.
Okay. And what is he wearing?
Chat. Chat, in the waterfall video, wasn't Higgins in a Harley Davidson sweatshirt? I want to see the back of this sweatshirt. But it does appear to be Brian Higgins.
Describe it for the jurors.
Black sweatshirt with some sort of logo on the front. It appears to be blue jeans and shoes with a white trim.
And is the hood up or down on the sweatshirt?
Boots with
It's
the
up.
fur.
Okay. Let's go ahead and play this.
Oh, that might be the same because it looked like a Harley logo on the back. It looked like a Harley logo on the back when he went into the
Just a
door.
moment. Could you pause this? Mr.
It was
Walker?
really hard to see the sweatshirt in the waterfall video. I would need to go back and look. But it looked like as he walked in, it looked like a Harley Davidson logo on the back. It might just be because the video from the waterfall is so bad. But as he walks in, I'm just going to play it real quick so I don't cause wild speculation on the internet. But that looks like the same Harley Davidson logo as he goes in. Yeah, that looks like
Yeah,
the
just a
Harley
moment.
Davidson
Can you
logo
pause
as he
this,
goes
Mr.
in. And the hood is up, so it is a little clearer to see. So the back looks the same to me. The front was really, really hard to see in the waterfall videos. And the waterfall
Can you
videos
make,
are so
note
blown out.
of the time as it's paused right here?
Yvonne, they didn't have these videos the first trial.
Do you want me to say it again or
Yes,
write
sir.
it down?
Yes, sir.
The time is 1:28:16 a.m.
Okay. And if we could just continue playing this video.
Until he comes back out. So we're at 1:28:16 a.m. inside Canton PD.
It is playing.
How are we going to know when he comes out?
Stop. Now, if you could take a look at the time now.
1:29:42.
Okay. What's that time?
1:29:42
Okay.
a.m.
And if we could go ahead and go forward. Is it still playing, Mr. Wolk? If we could take a look at the time one more time.
Now it's, you want me to say it?
Yes, sir.
1:34:12 a.m.
And in the time,
What?
just so the record's clear, in the time
I'm not
between
clear.
you saying 1:28:16 to 1:34:12, 6 minutes has not gone by, correct?
Just under 6, I believe, yeah.
Well, 6 minutes for us in real time.
Oh, in real time, yeah, no.
It is not. So it
Sorry.
appears that the camera jumped, or the time jumped.
I mean,
The time difference from what was this?
these cameras are motion activated, so the time skipping isn't, well, the jury doesn't know that yet. So the impression it leaves with them is going to be different than the impression it leaves with me. But the cameras are motion activated.
Displayed is approximately 6 minutes, yes.
Okay, which is much further, much longer than the time we've actually been looking at the video, correct?
That's correct, yes.
Okay, so it appears that it may
I'm
be
curious
motion
what
activated
triggered
and
it.
it just jumped.
That's a possibility, yes.
Okay,
yes.
let's go ahead and
I'm
continue
curious
playing
what
this.
activated it at 1:34. We'll see.
And stop. Do you see someone in the screen
Coming back
now?
in. Oh, now you can
Yes.
see the Harley Davidson
And
logo.
one more time, I know this is laborious, one more time if we could clock the time.
So it
you
seems
see
that
that?
his movement triggered it again.
No, it's really blurry for me.
Yeah, it looks like the same hoodie.
There we go.
Yes, now I can see it 1:34,
15.
15, if I'm not mistaken. AM.
Okay, fair enough. And let's go ahead and play this all the way through. Okay. Who did that appear to be walking away from the camera in this shot?
I'm not certain. I would be suspecting or guessing if I gave you an answer, but I'm not
I
certain who
mean,
that
are there
is.
that many people walking around
As
Canton
best
PD
you
at
can determine,
1:34 a.m.?
Does he have the same stature? I know you can't see his face. Same stature, same clothing, jeans, shoes with white stripe around it, dark hooded sweatshirt. It should appear to be the same person as Brian Higgins.
It does appear that way, yes.
Okay. Is that it? Okay. There's
Right.
one more clip that I'd ask you to look at on this same GG device.
Back to the door.
Okay. What do you see in this video?
Appears to be the church side Sallyport, and an individual came out of the door.
Okay. And can we highlight the time, please? Or increase the size? What time do you see there?
1:34:40 a.m.
Okay. If we go ahead and play this through. Pause. Does it appear from this video that the person has anything in his
No,
hand?
it appears that Bigfoot's at Canton PD. This is a terrible video.
I'm sorry, can you play that again? I wasn't looking at the hand,
Oh,
but
sure, sure.
It looks like his hand goes towards his face.
I really can't tell.
Okay.
It looks like his hand goes towards his face.
There should be another video of the rear lock cruiser side. Let's take a look at that.
And it'll get tied together with phone records. So the jury just gets pieces.
Pause.
That's easier to see.
do
There
you
we
see in that
go. That light's gonna give it away. There we go. Much easier. That's much easier.
It appears to be an individual wearing a black beanie hat, black dark colored sweatshirt with some design on it, and something illuminating by his face.
Can we enhance the time, please? What time is that?
It says 1:34 and 53 seconds in the morning, a.m.
Looks like a
And if you
phone
could
screen
move,
lit up to
the
me.
screen over to the individual. Mr. Wolf. Does that appear to be the same person?
It could possibly be, yeah.
And does it appear as something in his hand up
The
to his
pixelation
face,
cuts
the right
off
side of
so
his face
weird.
here?
Yes.
What do you think that is?
It's consistent with a cellular device, possibly a phone or a tablet.
Okay. If we can move on, please.
These videos were not used during the
that's
first
good.
trial. Defense didn't have them yet. And I saw the great question and observation from Helena. Did he even move any vehicles at all? I don't see any vehicles moving. I don't see any vehicles moving. Do you? Do you? I haven't seen a video move. Vehicle move. We've seen the videos. I haven't seen a vehicle move. It's a great point.
And I believe there's one more video. And Your Honor, this one is a little longer. This is about 10 minutes.
Maybe vehicles get moved now. I don't know why I'm saying videos. Maybe vehicles get moved now. Who knows? We'll see.
Okay, stop. Do you see a person in the video walking from screen right to screen left?
Yes.
Oh, it's like
That person appeared to have
1:35.
something in his right hand.
09 a.m.
I can't tell. I can't see his right hand.
Okay. When he first walked into the screen, could you tell?
I couldn't. No, I'm sorry.
Mr. Wolk, could we back that up with the court's permission about 2 seconds? Stop. Did it appear as something in his hand?
It's a possibility, yes.
Okay. And just for, I'm going to ask you for 2 times when we start and when we stop. What's the time on this video at this point when he walks into frame?
1:35 and 8 seconds in the morning, a.m.
Okay. And let's go ahead and play this through.
The snow is definitely coming down. That is clear. He's not walking very quickly. I mean, in this kind of snow, I'm definitely not moseying. That is a mosey. Jay Cash asked if the defense got this footage from the feds. No, it was found in a detective file when Brennan asked for it, and then turned over to the defense after the first trial. But it seemed that it was found because Brennan asked somebody to search for it, and it was just in some detective file somewhere. I haven't seen him get into his car yet. The car door hasn't opened. Inside light didn't light up, but the car lights are on at the back of the lot. So if you're looking towards the back of the lot in this video, you see lights go on back there. So it looks like a car may verifiably move. But it hasn't moved yet. I see lights. I'm waiting for something to move. Y'all are waiting for something to move. So for those of you that are like, I don't remember this the first time, it's not you. It's not you. This is new. However, it represents the snow at this time very well. Y'all, look, it's snowing. There's a car moving. Where does it go? I don't know where that car went, but that car disappeared. Well, I shouldn't say disappeared. It went off camera. So the jury hasn't heard from Higgins. They have no idea why he's moving cars around. They haven't heard testimony that he was moving cars around, going back to Canton PD. Murph, are they able to increase the video to 1.25 in court? No, it would not be an accurate representation of the video. Abdullah asked in the chat, is this the afternoon John died? No, this is at 1 we're at 1:35 in the morning. So it's 1:35 a.m. on January 29th. So this is 5-ish hours, 4.5 hours before John O'Keefe is found at 34 Fairview. And this is the parking lot at Canton PD. But they have not tied back. Higgins has not testified yet. I don't know if he will testify for the Commonwealth. There you see Higgins walking
at this
back
point,
into
do you
frame.
see a person walking into the frame from
Presumably.
into the video from frame left to frame right?
Yes.
Okay, go ahead.
I wish he would time check that. So he walks back into frame. It looks like it's 4-ish minutes later. 1:39. Whenever this goes to the jury, they will have the ability to play these if they're admitted into evidence. This hasn't been admitted into evidence yet. It's just been marked. I don't think there's a reason it won't be, but still standing out in the snow. Now the Jeep door's open. So there was a car moved, it looked like. Back into the Jeep. Oh, he's not in the Jeep. Back out of the Jeep. And then walked behind the Jeep. And then the truck lights went on and the truck door opened. All right, so maybe there are 2 cars that moved. That counts as cars.
Can you pause it? Did
Ned,
you see something happen with
that's
the
the microphones in
vehicle
court.
next
They're
to the
moving
Jeep,
the necks on the
in the
microphones.
last few seconds?
Yes.
What was that?
It appears as though the headlights are activated.
Okay, let's go ahead and play it.
Looks like the door's open too to me. And now the door's closed. And now there's a person outside.
Pause it. You see a person that is walking from screen right to screen left in the middle of the screen?
Yes, he just, or she just appears to
They-
have closed the door on that vehicle next to the plow.
Okay. And walking toward which vehicle?
The one on the furthest on the left.
Okay. From what you've seen, Sergeant, that you said he or she, does that person appear to be consistent with the video that we've seen of, in other particulars, of Brian Higgins?
As far as I could tell from here, the individual accessed Brian Higgins' vehicle, so I'd be speculating with the whiteout conditions or near whiteout conditions. It's tough to tell.
But
With
no
the
reason to
near
believe
whiteout
it's anybody
conditions.
other than Brian Higgins accessing Brian Higgins' vehicle.
No,
Okay.
no.
No.
Let's go ahead and play it.
All right. The
And what do you see Brian
door is
Higgins,
open.
or
Passenger
that
door
person doing
open
now?
on another vehicle.
They accessed the vehicle on the far left.
Okay. And where's that person going?
Back to the
Now they're
Jeep.
accessing the Jeep Wrangler.
And the snow is definitely coming down. It's a lot of walking around. In like a hoodie. He's getting something out of... I can't say that for sure. He is opening the side of the truck. It looks like that truck has like a work door on the shell or whatever. back to the Jeep. And like, it's snowing enough that leaving the door open is just,
Can you pause it?
what?
Where does that individual appear to be now in the video?
Last I could tell, they might be by the Jeep Wrangler.
They're inside the door.
Before that person got to the Jeep Wrangler, was he standing by the vehicle on the far left? SUV or truck?
Yeah, it looks like a
It
truck.
appeared that way, but with the heavy whiteout snow that night, I can't tell exactly what they were doing.
Did you see anything in his hand, like a bag or a satchel or a duffel bag or something?
Looks
when
like a truck
that
with
person
a
walked from this vehicle over to the Jeep?
Clamshell. Or
I did not notice, no.
Go ahead.
the chat noticed. The detective didn't notice. The chat 100% noticed. So the lights are now on the Jeep. The lights went off on the other truck and now into the passenger door of that truck again. With the lights on.
Now, has that person walked off screen to the left?
Yes, sir.
Okay.
The lights of the Jeep on. I mean, one car was moved, but he's opening into a lot
See
of cars
person
that look
entering
like
screen from screen left.
Yes.
they might be personal vehicles just by the paint, and they're all unlocked. Jeep doors back open. Still outside of the Jeep. Walking back towards the passenger side of the Jeep with something in his hands.
What did you see the person do?
My lights just
They were
unplugged.
carrying possibly like a snow broom, walking from left to right.
I mean, how can you tell that's what it is? And I gotta plug my lights back in because something just unplugged in my office. Yeah. I'm gonna sit in the dark until this is over. It'll be fine. The lights on the Jeep are back on. Or went off and then back on. We are still watching this video. The time is now after, at the tone, the time is now 1:45 a.m. The time on the video timestamp is now after 1:44 a.m.
What do you see happening now?
And now the Jeep is pulling out.
The Jeep Wrangler's leaving the spot it was parked in.
Okay. Okay, we can take
It's
that down.
1:45:52. So the Jeep is
Oh, I'm
leaving
sorry.
at
I failed to ask you
1:45:52
the time.
a.m.
I
Timestamp
promised I would
it.
do it, and I forgot again. Can we look
Timestamp
at the
it.
time real quick?
Yes, the time for the rear lot main side is 1:45:52.
Yep.
And it appears that's the approximate time that the Jeep Wrangler drove off.
Approximately, yes.
Okay, thank you. In are you friends with Brian Higgins?
I am not.
Do you know Brian Higgins?
I know who he is, yes.
Have you ever socialized with Brian Higgins?
Like out on private time?
Go out, have
Like
a
on
beer,
private time?
No.
see him at a bar, hey, Brian, let's grab a beer, nothing like that?
No.
How long have you known Mr. Higgins?
I'd be speculating. It's before this case. He was a law enforcement individual that worked in the area. So I've had cases where he assisted on and that I've assisted on.
Would you consider yourself to have a professional relationship with him?
I knew who he was, so yes, I would
You worked
consider
cases
a
together.
professional relationship.
You
But
know
you would not
who he is.
consider your relationship
I'm
to have
gonna
gone
go turn
over
my
to the
lights back
personal
on.
relationship? You don't
Not at all.
socialize, do any
No.
private
No.
get-togethers?
No.
Okay. You would agree that this video pretty clearly shows, at least at one point, around 1:34 a.m., Brian Higgins was on his phone.
At one point,
Is that the one that he has by his face?
Correct.
It appears that way, yes.
And just to be clear,
yes,
when you
it
interviewed
does
Mr.
appear that
Higgins,
way.
he did not volunteer to give you his phone, correct?
He did not volunteer it, no.
And you didn't
volunteered
seek his
portions of
phone
his
through a
phone.
warrant or any other mechanism.
I did not know.
These back in.
Do you have any personal knowledge as to the status of that phone as we sit here today?
The one that he got the extractions from?
Correct.
No idea, no.
I want to shift gears to another series of videos. Last year at another proceeding, you were asked about a couple of videos from the interior Sallyport garage at Canton PD. So now we're going to move to the interior. You remember those series of questions and answers that you gave?
Generally.
I do.
Okay.
I remember. We all remember. We remember.
You were asked at another proceeding
We remember quite
to
well.
describe when the SUV, Miss Reed's SUV, first arrived at the Sallyport garage around 5:30 or so.
Here we go to the
correct?
inside Sallyport. I was not
Based on
listening, I
my
just had to
recollection of
plug
it
my
first
lights back
arriving
in.
or what we were viewing?
No, what you were viewing.
I'm objecting to this.
Ask it differently, Mr. Jackson.
Do you remember being asked a series of questions concerning the arrival of the SUV, just in general?
I remember that it happened. I don't remember the exact questions on what my answers were.
And you remember seeing a video about which you were asked questions concerning the arrival of that SUV, pulling into the
Time.
Sallyport, who was who, what the time frame was, Jim?
Yep.
Do you remember that colloquy, that discussion?
I remember it taking place, yes.
That was Mr. Lally asking you questions,
Sir.
correct?
I believe so.
You don't remember?
Under questioning by the Commonwealth, you were asked whether the video that you were looking at fairly and accurately represented the SUV arriving at the
This.
Sallyport garage, correct?
Yes.
And you indicated, in fact, it did fairly and accurately depict the arrival of the SUV at the Sallyport garage. Is that right?
That's correct.
I'd like to ask you a question about that particular video.
There's two videos, though, is the thing. So, trying to figure out which timestamp we're asking for or which video will be interesting because there's one from the exterior and then one from the interior.
Your Honor, I'm holding a flash drive. May I approach?
Yes.
They're going to approach and mark these videos. It's hard for the defense because they can't exactly impeach him on what he said prior because he hasn't testified to it this time. But they can get into it. So we will see them get into it as they are showing counsel and talking about the video with their team. I'm going to. Oh,
Jurors, you know what? Let's take. Jurors, you know what? Let's take the luncheon break.
what? It's real early for lunch. Your Honor, it's real early for lunch. It's real
Relationship.
it's real early for lunch. Hold on. They go back on the record. What in the heck is happening? Oh no, this video. Give me one sec, chat. Because it looks like they go back on the record. Hold on. She tells the jury that they're going to lunch. This whole feed cuts.
Paul, the lunch is here. Jurors, you know what? Let's take the luncheon break.
Thank you.
She tells the jurors to take the lunch break. We're going to zoom because.
Voir dire right now.
Oh. Because they're not done. They're not done. All right. So the jurors are going out for lunch, but we're not done in court. Aha. Aha. Let's see what they're going to put on the record. No lunch for us just yet.
Do is have the voir dire right now to see what Sergeant Bukhenik knew regarding that line of testimony you wanted to get into. So let's do that now, and then you can all work out.
They are doing voir dire outside the presence of the jury to question the trooper about, well, we're going to find out. So let's see. Can we change the pinned comment to update that we are doing a voir dire outside the presence of the jury? The jury is at lunch. Let's see what the defense wants to
The
ask.
video issues.
Oh, boy.
Yes. Okay. May I inquire briefly?
Yes.
Thank you.
Jury out
Sergeant,
for lunch?
we were talking before the jury left. We were talking a little bit about the conversation that you had with Michael Proctor, either during or just before or just after that first interview with Chris and Julie Albert. What I'd like to ask you is, what information did you have?
They are going back and voir diring Sergeant Bukhenik regarding the interviews with the Alberts and what he knew about the relationship between Proctor's family and the Albert family.
And what did you ultimately learn about their relationship? You said there were some accusations and we never really got to the heart of it. What did you know and what did you do to investigate? What did you learn?
What I knew as we were walking up to the door is that he had knowledge of the individuals prior to us conducting the interview. I asked him if he knew them personally. My words, do you hang out with them? Do you socialize with them? He said, no, I do not. I said, are you comfortable doing this interview? And he said, yes. And me
he said yes.
Being a complete outsider and his supervisor and realizing if there was any impropriety that I would step in and recognize it, report it, and act on that.
How can you know if he's telling you that the nature of the relationship is fine? A lot of you are asking in the chat, what's a voir dire? It's questioning outside the presence of the jury.
The interview was conducted without issue, and we moved on.
As a matter of fact, one of the things in Trooper Proctor's report, it said, the report started with following formal introductions. Did that suggest to you that Trooper Proctor had no knowledge of who Chris or Julie Albert were from a personal standpoint?
Not at all. I believe maybe I wrote the report, or was it him?
Yes, I think it is you.
Yeah. So
Yeah, Coach.
Yes.
So you wrote the report and he told you Trust
Thank
me,
you.
bro. It's fine.
Yeah, since I authored the report, I wrote following formal introduction since I've never met them before.
Okay, so that was more attended to you than to Michael Proctor.
Correct.
Okay, but the report does say we introduced ourselves, basically. Following formal introductions.
Greeted, but I had formal introductions to them. I've never met them before in my life.
You said that subsequently you learned about your word accusations that had been made concerning possible relationship
I'm
between
interested about
Michael
this.
Proctor and the Alberts. What was that information that you learned?
When was it? I need that.
When did you learn it? I thought you said 2023, but I could be wrong. When did you learn that?
It was I believe, during the July motion proceedings when you guys had pictures up of
You guys.
of children.
July of what year?
I believe 2023.
Okay. And what was it that you learned in July of 2023 about the potential?
The accusations?
Yeah.
That those were Albert's or McCabe's kids in the photograph with Michael Proctor?
Okay.
There was like
Did
a
you
wedding.
ever learn about personal communications that Michael Proctor or his wife may have had with any of the Albert family, including Julie Albert?
Ever?
Ever?
Yes.
Okay. Tell me when you learned that and what you learned in that order.
Well, Michael Proctor had communicated with those individuals, Elizabeth Proctor and communicated with those individuals due to the harassment that they've sustained.
Okay.
So with the crazy behavior that's been imposed on them and the torturous harassment that they've endured, the traumatic
He just wants to say all the things.
experiences they've had to live through, they've communicated. So I've learned about that, yes. I was taking in all of that evidence, hundreds and pieces of evidence that I've archived in order to
Go ahead. In order to?
investigate it.
Okay. You're talking about Elizabeth Proctor well after the fact of the interview.
If
and
all
the
of you want to
incident.
know why this is done outside the presence of the jury, this is part of why this is done outside the presence of the jury. Because they want to ask everything that they can ask, and they want to get into everything that they can get into to figure out if this is going to come in to testimony or not. But this is part of why it's outside the presence of the jury, because it limits answers like that from being in front of the jury when it's not supposed to be. So I know some of you do not like the way that the judge does things, but this is not an improper reason to do a voir dire, because you don't know what this trooper is going to say as we're getting into all of this. So let us continue.
In 2022. That's what you were just describing.
It was after the harassment
Okay.
started, yes.
Which is well after January 29, 2022, right?
January 20, yes, it is.
Okay. I'm asking about information related to a relationship prior to January 29, 2022. Did you ever learn about a pre-existing relationship that may have existed between the Proctor family and the Albert family before January 29, 2022, and maybe a couple of days after?
All I know is that there was a relationship explanation provided by Mr. Lally during one of the motions, and it was like 6 degrees separated by individuals
But did you know about the relationship?
residing in the community, living in the community, raising their kids in the community, working in the community, so making them community members and having relationship within that. I don't know the extent of those relationships.
Okay. Did you, during that hearing where you said there were pictures of the kids and et cetera, that July 2023 hearing, did you see a post, a Facebook post during the course of that hearing wherein the Albert family called the Proctor family their second family, or vice versa, where the Proctor family Michael Proctor's mother, they've called the Alberts their second family. You remember that Facebook post?
I don't remember seeing that post. I just remember there was like a picture of kids that weren't Michael Proctor's kids.
Okay, but you were in court that day.
I was in court in July. I believe it was 23rd of July, for
Okay.
the motion, yeah.
Leaving aside the photographs that you've talked about, did you see the post, the Facebook post about those two families, specifically Michael Proctor's mom, saying that the Alberts were their, quote, second family?
I don't remember seeing that post.
That didn't strike you, or that didn't...
That would
didn't-
also be
That was not in your brain,
inappropriate to get
in your
into in
head.
front of the jury if he doesn't know it.
I don't think I've ever seen a post like that, so I just remember seeing the post of the kids.
What
I believe
about,
it was Miss Little that was holding up the poster.
what about the text messages, or what about any text messages between Michael Proctor and his sister concerning Julie Albert, very specifically concerning Julie Albert? Are you aware of those?
No.
Have you ever seen a text message between Julie Albert, between Courtney Proctor and, it's Courtney
There's too many of them.
Proctor and Michael Proctor, where the sister says, Julie wants to give you a gift because you're doing such a great job leading this, meaning this investigation? Are you aware of that?
No.
Are you aware of a text message in which
You laugh, sir, like it's preposterous. I never saw a text like that. We know from the first trial that that text exists, though, sir. So even if you don't know it, we know it. Oh, boy.
Michael Proctor responds, get it for my wife? Meaning, if you're going to give us a gift, get the gift for my wife.
No idea.
Okay. Are you aware of a series of text messages between and among Michael Proctor and Elizabeth Proctor in which they talk about, between Michael Proctor and Courtney Proctor, in which they talk about Julie Albert? This is 10 days before the incident, 10 days before January 29th, so mid-January, where they talk about the possibility of Julie Albert babysitting for Michael Proctor and Elizabeth Proctor's kids.
I am not aware of those text
This is
messages.
the first you've heard of any of those.
Of these text messages?
The text messages
Yeah.
that I'm describing, have you ever heard of any of those?
No.
Okay. Did you ever talk to or investigate the circumstance of the possibility, even the remote possibility, that Michael Proctor may have had a relationship with the Alberts that you were unaware of?
No, I never investigated anything like that.
So after your initial conversation with Mr. Proctor, where he said, I know of these people, and you said, is there any issue with you going forward? And he said, no, there's no issue. You took no further steps after that to investigate that relationship. And I'm talking about the relationship that existed on or around January 29th, 2022, not in 2023, not in 2024.
Once Michael Proctor stated that he was comfortable conducting the interview, and I asked him if he was sure, and he said yes, we moved on.
Right.
Yeah, just a moment, Your Honor.
We moved
Yes.
on. Oh, Miguelina, this might end before we can let the app know. I think it's worth letting them know, because we might get a little bit of cross after this.
Last couple of questions. Were you in court? I know you're indicating that you've never heard about these text messages. Were you in court in February of 2024 following the federal investigation revelation, the documents that we got from both sides got from the federal investigation, which revealed, and was revealed in open court, the text messages about gift giving between Courtney Proctor and Michael Proctor? Hey, Judy wants to get you a gift, and Michael Proctor's response was, get it for...
Well, darn that siren, but I'm going to back up just a little bit because he's saying after we learned from the federal investigation, just in case anyone's still wondering where all those texts came from. I backed up because
Last couple of questions. Were you in court? I know you're indicating that you've never heard about these text messages. Were you in court in February of 2024 following the federal investigation revelation, the documents that we got from both sides got from the federal investigation, which revealed, and was revealed in open court, the text messages about gift giving between Courtney Proctor and Michael Proctor. Hey, Judy wants to get you a gift, and Michael Proctor's response was, get it for Elizabeth, or get it for my wife. Were you in court when those were revealed?
Following the harassment, intimidation that I experienced on the 23rd, being followed into the bathroom, then being followed outside,
I'm going to back his answer up. They're talking about pretrial hearings in February of 2024 ahead of the April 2024 start of trial number 1. Do not follow people into the bathroom, man. Do not follow people into the bathroom at court. It does not. Do not follow people into the bathroom at court. Do not. That
that I experienced
bad
on the 23rd,
idea.
being followed into the bathroom, then being followed outside.
All right, I'm going to back that up just a little bit.
Were you in court when those were revealed?
I want to hear what he has to say.
Following the harassment, intimidation that I experienced on the 23rd, being followed into the bathroom, then being followed outside, I stopped coming to court proceedings due to that. So I was not in court in February of 2024 and describing the information that you're revealing. I was not aware of that detail.
All of these proceedings are televised, Sergeant. You know that, right?
I'm not aware that it's televised, no.
You're not aware.
I know it streams, but
I know it streams.
aware of that
Did you
detail.
review, all of these proceedings are televised, Sergeant. You know that, right?
I'm not aware that it's televised, no.
You're not aware.
I know it streams, but I'm not aware that it's televised.
Okay, streamed. However, what
I mean-
streamed on the internet. You can find it.
You can, yes.
They're recorded.
Right.
Did you ever review the hearing in February 2024 talking about what's been referred to as the Fed dump and the revelations that were made pursuant to that federal investigation and the text messages attendant thereto?
I am aware of a Fed dump. I'm aware that it exists. I was not privileged to any information outside of the information that was revealed to me during the internal affairs investigation.
Right.
That was the first time I saw documents from that federal investigation.
By the way, were you privy to, Michael? There were 3 individuals involved in the investigation: yourself, Lieutenant Tully, and Michael Proctor. Is that right?
In what
The
investigation?
internal affairs investigation.
I'm aware that I was. I know they were as well. I don't know who else might have been involved. I don't know.
In terms of your awareness of Michael Proctor's investigation, you're aware, obviously, that he was terminated, correct?
I am aware that he's terminated, yes.
Yup.
Did you ever see or were privy to any of the documents or investigative materials associated with his termination as his supervisor?
No.
So nothing was ever shared with you, the final decision?
Other than the documents that he was attached in the text message that I was shown from that investigation, nobody showed me anything of his investigation.
Okay, so let's wrap this up.
Okay, that was basically all I had.
Okay, all right. Do you want to be heard, Mr. Jackson?
No.
Okay.
On that.
Yeah, I'm not letting any of this in.
I think it's all admissible, but I understand the court's ruling was if he doesn't have personal knowledge of it.
He doesn't have personal knowledge of it.
But then, so our objection, but that's been noted.
Okay, so you got your voir dire, and I'm glad we fleshed it all out. So you have to be back here in 35 minutes. All right. When's the jury coming back, Paul?
20.
All right. Be back here at 25. Ready to go.
Okay. Well. It looks like we are now on lunch from that voir dire. I'm going to go to lunch real quick, but let's summarize what we got from the morning. I think it's time to go back to the normal lights real quick and then get into what we take away from the morning. Oh, my in-ears are just pulling on the rest of the stuff. So it's day 14 and the cross-examination has covered a lot of different areas this morning with Alan Jackson and Sergeant Bukhenik. We have not gotten into the Sallyport videos of Karen Read's SUV arriving, but at the very beginning of the day, we heard that the Commonwealth has filed additional motions. The court is going to take those up at some point. And then we started into the cross-examination. And when the jury was excused for lunch, the court took the time to do, or allow the defense to do, a voir dire of Sergeant Bukhenik in a few different areas to determine whether or not he had personal knowledge of those areas, which is a requisite for witnesses to testify about information, depending on what the information is. They have to have personal knowledge of the facts of that information. As we got into it, that voir dire was regarding a line of questioning that had been cut short earlier in cross-examination regarding Proctor's relationship with Chris and Julie Albert, and text messages Proctor and his sister were talking back and forth on, conversations between Proctor's wife, I think, and Julie Albert, because they went back and forth between names and whether it was the wife or the sister. It got much more clear once we got to the wife or the sister, and text messages about Julie Albert and the relationship. What Sergeant Bukhenik said that he was aware of is that Trooper Proctor told him when they went to go interview Chris and Julie Albert that he knew them from like being a parent in the community, but wasn't really friendly with them. Now, we know from the first trial that that is a substantial downplaying of that relationship. The issue here is evidence-wise that Sergeant Bukhenik did not know that. He knew what was told to him by Trooper Proctor the day they went to do that interview in February 2022, and he knew some of what he's learned since, but he has not been presented things in person. So the court is not going to allow a further questioning into the area of the relationship between Proctor and the Alberts to Sergeant Bukhenik's knowledge, because he says he does not have knowledge of those things. He heard some of the information, but it was not part of his investigation. It's not something he looked into. I wish Alan Jackson would have asked him that, because he said he needed to look into it. I wish we would have heard about, well, did you look into this more? Did you try to determine what Proctor had told you, not told you? But that was not asked on voir dire. What was asked about was what information he was aware of from the federal dump, is what they're calling it, of information, what he was aware of from text messages. He's not on those text message chains. So that information is going to have to come in through a different witness, probably Trooper Proctor or his sister or his wife. Can the defense call any of those witnesses if they want to? Yes, they can. Can the prosecution call those witnesses if they want to? Yes, they can, but they probably won't. So we will see what happens, because the prosecution, I think, is in a real interesting spot with deciding if they call Proctor or not. We then got into, during cross-examination, video that we had not seen before because it was not turned over prior to the first trial, of Brian Higgins' movements around and about Canton PD in the early morning after 1 a.m. hour, between after 1 a.m., I don't remember the time of the very first video, but after 1 a.m. to after 1:45 a.m. when he finally leaves. And you see video of Brian Higgins, presumed to be Brian Higgins, pulling in Brian Higgins's Jeep with the plow on it, parking, going into Canton PD, going into an office, going down the hallway, coming back to the office, back past the office, down the hallway, back out into the parking lot, going and moving a car, then at the Jeep, then at a car next to his Jeep, then at a car across from that car, back and forth to all these different cars, getting things out of a truck in and around different truck doors. And all these cars are just unlocked. And he is undertaking quite a lot of activity in and around these unlocked cars. Well, it is snowing pretty heavily. At one point, Sergeant said it was near whiteout conditions. I don't know if I would agree to that, but it was coming down. But the snow's coming it seemed pretty straight down. It didn't seem to be particularly windy. And he's out there in what looks like a Harley Davidson hoodie, walking around in the snow for a significant period of time. You also see one still shot where Higgins has his cell phone up to his face and the screen is clearly brightly lit. So in some of the shots, you can see kind of a gesture towards his face. But then in one of those stills, you can very clearly see a phone to his face with a bright screen. Can this officer testify that that's a phone call? No. Could he be voice texting something? I mean, sure. But I think we will see other evidence establishing what was going on with phones at that time. Again, from other evidence. So does it really matter ultimately? The jury has seen the phone to the face with the screen on. But is it fair that this witness is like, he's on the phone, but I don't see if he's on a call or not? Sure. But we will see information about that at some point later. It will have to get all tied together. So all in all, we got a lot into the Brian Higgins of it all and his motions around Canton PD. And wow, those videos are much more clear than any of the other videos we've seen out of Canton PD. Is it just me? Or were those videos pretty clear and easy to see? Because those videos were pretty clear and easy to see. So for everyone who keeps asking about the Brian Higgins butt dials, this trial's not there yet. This trial's not there yet. But we got into a lot of areas of cross, including a report, and I think this came in the first trial, a report from Proctor about accessing Ring or the Ring app and Ring videos on John O'Keefe's phone after they took John O'Keefe's phone into custody. You heard me correctly, not accessing a forensic download of John O'Keefe's phone. No, accessing the Ring video app and Ring videos on John O'Keefe's phone. And I think we're going to hear more about that from the defense as they get into their case in chief. So a lot more. Will Higgins be done? Will Higgins be done today? Higgins isn't testifying yet, Emily. We'll see when and if Higgins gets called. That's going to be a real interesting strategic conversation. Like, if you're the defense, do you leave it alone? Do you not let Higgins come in and explain? Do you leave it and say, look, they never investigated Higgins. Look at all this behavior. I think if you're the defense, you wait and make that decision at the end of the Commonwealth's case to see how much comes in, because giving Higgins the opportunity to explain might be something the defense doesn't want to do. They might want to push it back on, and the Commonwealth never called him, and they never investigated him, and he's got a plow, and he's driving around doing all of this stuff, and you just leave it for argument and you bring it in and closing arguments and say, and then there's this, and then there's this, and then there's this. They never even got his phone. They let him just hand over those texts. I think it depends how much comes in during other witnesses and then make that decision and keep it in mind that maybe not calling him and letting him explain is the right call, and just looking at the jury going, and they never investigated all of this. Isn't that odd? Don't you wonder what they chose not to investigate? What is he getting from that truck? Don't let him explain what it is. What is he getting from that truck? Weird. It's snowing. It's 1:30 in the morning, and he's walking all over that parking lot at Canton PD. The jury doesn't know how many drinks he's had yet. But after being out at the bar, and they never even ask about it. Isn't that odd? Shouldn't that have been investigated? But the prosecution might now be forced to call Higgins to let him explain. But then if the prosecution chooses to call Higgins, then you can impeach Higgins on all the things he said in other proceedings and what he said about his phone calls or lack thereof if the timing is different between when Higgins is saying he got home and when video shows that he's not home, then that all comes up in cross-examination. So does the prosecution choose to run down that Higgins side quest, or do they leave it? It's we're going to get into a game of chess with what the Commonwealth chooses to do and chooses not to do. And I'm interested to see if they just stay the course or if these cross-examinations force the Commonwealth to shift what they do to respond to some of these cross-examinations that leave, I think at minimum, I said at minimum, I think at minimum, these cross-examinations leave a ton of questions in the mind of the jury. And that's what they're supposed to do. Will the Commonwealth be able to close those gaps or not? We're going to have to wait and see, because what we still haven't seen on day 14 is how John O'Keefe died, how the Commonwealth thinks that happened, when the Commonwealth thinks that happened, and the experts that back up that theory of the case. And it's day by day becoming more noticeable that that is not in yet. So with all of that, we're going to answer just a few questions, and then let's see. And then I'm going to go to lunch and take like 15 minutes because, because my new in-ears got here. And I actually want to put them on and give them a try. Emily, you have new things. Yes. But also a reminder for all of you that are here. Hi, welcome. This is what we do. We talk about cases. For those of you that don't know me, I was a trial lawyer, very long time, still a lawyer, not doing trials anymore, just doing other people's trials now, which is the best when you get to retire from doing the thing and then comment on other people doing the thing. But we built an app so that you don't miss a thing. And we have sent lots of app alerts today because shit keeps happening today. And we're going to keep sending you those app alerts when stuff happens in court and let you know, oh, there's a voir dire. Oh, there's videos we haven't seen. Oh, they're getting to the see you next Tuesday text of it all. Like, those are the things you guys want to know. Those are the things you want to know. Canton PD's integrity in the chat said, this guy's making me look even worse. It's not helping, though, to be fair to Sergeant Bukhenik, he doesn't work for Canton PD. He works for Mass State Troopers, which I think for him is worse because it's a much larger agency. So you expect to see less nonsense from larger agencies, and we're not. Commuter Mike says, I feel like reading of Higgins' text opened the door to Aruba witnesses. I don't think so. Pre-trial, Brennan said he would not call them unless the door was open. Was it opened? I don't think Higgins wants to run down that rabbit hole, and I don't think it helps. So I don't think Higgins is going to fight to call the Aruba witnesses. We'll see if he brings it up at a sidebar. I think it would be a mistake to try to run down that rabbit hole, but they didn't talk about Aruba. I mean, they talked about New Year's. It's the same incident. It went pretty fast in testimony, but it's in those Higgins text messages. Those text messages that the defense choose to elicit do talk about Karen feeling like John was cheating over New Year's, and Higgins repeatedly saying, did they bang? And saying repeatedly, okay, but did they bang in those texts? So if Brennan wants to argue that the defense eliciting all of those texts from Read and Higgins need explanation, I think they can argue that. I don't think the prosecution wants to go through that, but they might want to explain that John didn't cheat. And now we end up on a side quest of bringing in the witnesses to say, no, I think they're sympathetic witnesses, to bring in those witnesses to say, no, he was drunk and she was reading into it. And we absolutely did not bang. And I say it that way because those are Higgins's questions, but can they do that? The defense elicited the entirety of those texts. Those texts can be seen to leave the impression. Let me know if you've seen the text and nothing else. The text can leave the impression that John O'Keefe did something over New Year's that caused Karen Read to maybe want to take revenge. That was kind of the answer that was given there. So if they ask, I could see them being allowed to get into it because of the impression that it leaves. So that's a long way around to say, I think the court would allow it at this point because of not just because of Bukhenik's answers, but because the defense elicited all of those text messages, and those text messages can be seen to leave that impression, in addition to the answers from Bukhenik about the conversation with Higgins and Read. So there is that. Let's see. Puddlegum said, I thought the protocol was trust and verify. Well, and honor and integrity. Gwendolyn said, I just received my Lawnerd badge pin. I mean, we definitely have a couple different Lawnerd pins in the Lawnerd shop, and I love them. Oh, excuse me. Kim R said, before this trial is over, the Commonwealth and defense are going to need a snap cup. I mean, there's moments where they can get along and there's moments where they can't. So let's see. I'm going to answer like 2 more questions and then we're going to zoom to lunch. J May said, do we know who cars those are that he moved open? No. Did any of those officers find evidence later? We have no idea whose cars they are. And I don't know if we got into that at all in the first trial because there was no video. So it wasn't who's this, who's that. It was, I was moving cars around. I was doing administrative tasks. Does the video look like administrative tasks to you? He said he was moving cars out of the way to allow for plowing of the parking lot. A car got moved, but North Star said, say it, forget it, write it, regret it. I mean, they're very comfortable texting with their supervisors, all kinds of stuff that I think a lot of law enforcement, whether they say it or not, wouldn't text. The Fall of Sparrow said, as someone who has listened to jail calls and looked at phone dumps, I 100% agree with Emily's interpretation. The jury's not, because it's not their work experience. And Jackson is allowed to paint the picture. I think there's a lot going on in Proctor's text, and the jury has no reason to be charitable with their interpretation of Proctor's texts, and they're not going to be. It's just looking at it through the lens of working in the criminal justice system for a good bit of time. But it's going to be interesting to see because the jury has no reason to be charitable with that. And even if there is a question of like, is he expecting to find or searching to find or seek and destroy? I don't know. I don't think it fucking matters once you hear the rest of the text either way. Like I just don't think it's going to matter. Jojo said, do you think there's any change in his behavior than previous days? To me, he seems less sassy than before. Jojo, I think that Higgins has slowed his roll a little bit. Not Higgins. Bukhenik has slowed his roll a little bit on fighting with Jackson. There were still moments that he was fighting with Jackson, but he's had a weekend to like rest and reflect that it doesn't go well and it looks bad. It just looks bad with how evasive he's been. But the Commonwealth can't have conversation with him before or between his testimony outside of what the court had ordered. So Flying Ryan said, how come they don't put the text messages up? I don't think putting them up on the board is going to help. And there was a narrow room of questioning on that, and they might not have it narrowed down. Kelly B said, my son went to Metallica last night, his first concert. That is an iconic first concert experience. Lawnards, I'm going to go to lunch for 15 minutes. If you guys want to share your first concert experience in the chat, feel free. If you want to know when I am back from lunch, well, make sure you have the Lawnard app. I'm going to put on our Lawnard hold video real quick because it's needed like 100%. Let me just grab it because I think I closed it over the weekend as I was restarting the computer and letting it have like a timeout because my computer needed a timeout over the weekend. Court days are long days. Court days are long days for sure. So let me just pull that up real quick. It just jumped. Why did it do that? That was sus. Don't be sus, hold music. We need. Okay, well, also don't step on me talking. It's like, I do what I want, Emily. I do what I want. Just
respect my authority.
The video's like, I do what I want. I do what I want. All right, let's get to, I need lunch. Do y'all need lunch? I need lunch. You need lunch. We need lunch. Lunch is 100% needed. It's time. Let's go. Law nerds, I'll see you in a few.
Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Lawnerd, court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnerd app has all of your live court notifications to keep you in the loop. LawnerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. All right, Lawners, are we ready? Are we ready to go back to court? Are we ready? We have one of the new in-ears in. It is a bit bulkier than I anticipated. We don't have the other one in yet. We'll see how we feel about it. We'll see how we feel today. But the other ones were killing me. So, you know, at some point, you gotta try to figure out what's gonna make it work. And I think we can probably hear my fan in the background. So I'm gonna turn that down as we get back to court after the lunch break. Hopefully you got some lunch. I got a new shaker bottle yesterday. So we've got a new shaker bottle for the lunchtime. Cause did we have time to
do much? No. I was messing with this. So it's just what it is. All right. Are you guys ready? I think you're ready. I'm ready. We had the voir dire over lunch. I was messing with in-ears, grabbed a protein shake, and we're going to go back to court. But don't worry. I'm going to take a look at what was filed before we get there. So do not worry. Do not worry. We'll take a look. So, but we got to test this one out. But are we going to test it out with both? No, not today. Not today. We're not. But what we are going to do is go back to court. Today's been a lot. I feel like I say that every day of trial by the time we get to lunch, but every day.
Bring the jury.
It's time to bring the jury. It's time to get back to court. It's time. It's just, what are we doing? I don't know. We're still on we're still on cross-examination well into day 2. Did I think this witness might be done at lunch? Sure did. Was I wrong about that? Sure wrong about that. So let's go to court, shall we? Yes, we shall. It's time. Oh, I need my live court button. Let's go to court. I don't know what horrible, ungodly noise is happening in that courtroom, but it's terrible.
All right, Mr.
Terrible.
Jackson.
Thank you, Your Honor. As a matter of housekeeping, I would ask that GG for identification be moved in evidence.
Yes.
All right. I think they just moved Gigi into evidence. That's fine. Laurent, good to see you in the chat, friend. So, if the jury's not in, they're
May I
probably
inquire?
walking.
I'm so sorry. I did it again.
Oops, I
Thank you.
did it again.
Yes, go right ahead, Mr. Jackson.
Thank you.
Sorry.
Just before the lunch break, Sergeant, I asked whether
Lots was asked.
you had engaged in a discussion with the Commonwealth at a prior proceeding in which you were shown a video and you talked about the fairness and accuracy of that particular video in the Sallyport when the SUV was first pulled in. And you indicated that you did
Yep.
indicate that it was fair and accurate, correct?
Yes, back then, yes. Yeah.
Back then, not now. Oh boy. Oh boy.
I want to play a copy, a bit of that video, if I could, please. with
Doodlebug, the
court's
chat will help
permission.
you. Don't worry.
Is it in evidence?
It is not.
It's probably a setting.
I would ask that we
You gotta
mark
unlock it at the bottom.
next order,
All right.
thumb drive.
I'm glad y'all are getting your app alerts. I always try to give us a few minutes to make sure that A, we have Zoom Room, and B, that the app gets notified, because I let you guys know you got like 15 minutes to go get the rest of your shit done for the day
Green light is going into evidence.
before we come back to court.
I'd like it in evidence.
We agree with the stipulation that it's authentic.
I mean, okay,
I'm not going to argue
Brennan.
metadata issues or authenticity issues, so.
All right, so is there a stipulation that this is authentic?
Yes.
Okay, so folks, again, a stipulation means the parties agree, and with that, I will allow this into evidence as the next exhibit. Madam Court Reporter?
That's it.
Okay,
So they
now you
stipulated-
may display it.
Thank you. Okay. Could we play?
The defense
Beginning-
is stipulating,
runtime,
as
Mr.
well as the Commonwealth, that these are the videos that were provided
This
from the
is
Sallyport.
53703.
And they-
If we just play this
defense said
forward
they're not
for a
gonna
couple
fight over
seconds. A little bit further. Pause. Do you see what's depicted in this video?
The jury's back.
Yes, I do.
This is the video that you were shown at a prior proceeding, correct?
Yes, it is.
Does this appear to be the interior of the Sallyport at
Cross
Canton
is
PD?
resumed.
Yes, it is.
And this is what you were questioned about regarding the SUV being pulled into the Sallyport, correct?
Yes.
From a time frame standpoint, just
This is the video that the Commonwealth provided to the defense. They will get into the accuracy of this video. This is the one that was provided to the defense, not the one that the defense flipped after this shit was flipped.
the time frame. This is
The
right
jury
after
doesn't
the
know
SUV
about
has
shipping
been
flipped
driven
yet.
in from the flatbed
They didn't get to
after
do
having
that.
been seized in Dighton, correct?
Yes, it was driven off of the flatbed after transportation from Dighton to Canton PD and driven into the Sallyport.
All right. You previously have identified individuals in this video, in this still shot, correct?
Yes.
And what you previously said, and we'll get to subsequent testimony in a second, you previously indicated that the person to the right was you, person to the left, Michael Proctor, correct?
Yes, previously I identified that being Michael Proctor. I was mistaken. That is not me on the right.
That would be the tow truck driver, correct?
That's correct.
That is, in fact, Michael Proctor, however, in the two-tone jacket, correct?
I believe so.
Okay. And as the video is portrayed, at least as we're looking at it, and I'll get to the next question next, as we're looking at it, it appears that we're looking at the right passenger side of the vehicle, as it appears in this video, correct?
That's correct.
And you see a timestamp and a date stamp on the bottom, correct?
It is present. I don't know what it says.
Okay, can we highlight that just a little bit? Can you see what that says?
Yep.
I believe it says interior Sallyport back wall,
Okay,
537, maybe.
okay. When you indicated that this was a fair and accurate depiction of the interior Sallyport when the SUV was brought in, you were specifically asked whether or not you or Michael Proctor approached or manipulated or touched the right rear taillight area of the vehicle, correct?
I don't remember the exact verbiage used, but in something along those lines, that's what was asked.
And you indicated that neither of you did, correct?
That's correct.
Okay. But in point of fact, this video is backward, correct?
Yes, it is a mirror image of what is actually taking place as recorded by
Right.
the camera.
Shit's
Can we play
flipped.
this forward? Do you see
Gidget Gale in the
where
chat asked, was it
Mr.
purposely
Proctor was
inverted?
looking and
There's
do you see where
controversy
Mr.
over
Proctor
that.
went?
There's controversy over that. They said this was the way this camera and numerous other cameras recorded, and that's the way that it recorded.
The video depicts him
So that's what they
going
say.
to that portion of the vehicle, but we can't tell how close he is.
Okay. And
Sir, just answer the question.
from all appearances, importantly, it appears to be the back driver's side, back left of the vehicle, correct?
That's the way it appears, yes.
Let's play this forward for a second. Pause. Can I ask you to pay special note to the far rear side of the vehicle? Do you see what appears to be Mr. Proctor's head?
Yes.
As the tow truck driver walks past the rear of the vehicle, can you watch and tell me if you see Mr. Proctor do anything or move in any way? Let's go ahead and play it forward. Pause. Did you see any volitional movement by Mr. Proctor as the tow truck driver moved past
It
him?
looks like he shifted his
Yes,
weight.
it appears if that is his head, it shifted weight.
Okay.
Yeah.
Let's go ahead and play it forward.
That's what it looks like to me, too.
Stop. Did you see a person that appeared to morph toward the back of the vehicle? Right there.
They apparated.
There is some anomaly there with the footage, so it could possibly be used to describe that what took place.
Can you recognize that person?
I cannot know.
You indicated previously, does that person look large or small in stature
I can't tell.
as compared to, for instance, Michael Proctor, whose head you can see above the car? What about this person? Taller, shorter than Michael Proctor?
I can't tell from here.
The person
can't.
walking
You
away from the
indicated
SUV
that-
is not Proctor.
Chief Berkowitz was a smaller statured person, correct?
Never said that.
I'm sorry?
I didn't know his height.
Larger or smaller?
He said he didn't know.
Generally. How about this? Larger or smaller than you?
He's shorter than me.
Okay.
How tall are you?
Can you tell whether or not that is Chief Berkowitz?
I cannot know.
Okay, let's go ahead and play it for him. And
Lights are
a
off.
little bit further. Pause. What does it appear that Mr. Proctor does at this point in the video?
He's walking.
Okay, do you see
He
anything in his
says that
hand?
like he's not sure.
I cannot tell from the video, but that he might be carrying something.
Remember we looked previously at a portfolio?
You know what would be so helpful? Just reports with like who was at the Sallyport when this happened. I'll just clear all this up.
Black portfolio. Does it appear that he may have a black portfolio in his hand?
That is very likely, but I don't know exactly what he's carrying.
Okay, let's go ahead and play this forward. Okay, and did it appear that somebody just appeared at the front right, or sorry, the right-hand side of the screen toward the front of the SUV as well?
Yes, it appears that way, yes.
Okay,
Okay.
let's take this down.
It does look like they have a broom.
I'd like to mark.
Caffeinated Hummingbird asked, are they going to show the Sallyport video unflipped? I don't know. Because we don't know. Yeah, I don't know.
Another electronic device.
We will have to
thumb
see.
drive that has
They may.
another video
That
on
might
it.
be what they're
Your Honor,
doing
I'd like to
now.
have that marked as next in order. Court permission.
All right, so there's no objection, Mr. Ryan?
No objection, thank you.
Okay.
Exhibit 119.
With the court's permission.
Yes.
Now, Sergeant, what is
And
this
that
show?
answers your question. There you go.
It
Unflip.
appears to be the mirror image of the previous footage. I don't know the exact timestamp there, but
Can we increase the date and time?
Not easily. Because can you
Do
read
you see-
that?
Can you read the date and timestamp on this
No.
Chiron?
I cannot know.
It's because it's backward, correct?
I can't
Well,
read
it's
it.
also
I can't
so
make it out, sir.
Can you make it
Fuzzy.
any bigger, Mr. Wolk?
That you can't. I mean,
Does that appear to be backward?
it appears to be fuzzy.
Based on me recognizing some of the digits, it does appear to be backwards.
Okay, let's look at the whole screen again.
This is the defense video
Sergeant.
where they took.
Let's play this forward.
This is where the defense took the video from the Sallyport and flipped it the wrong way, or flipped it the right way, but the other way from the one that was turned over.
For just a quick second.
Dion in the chat asked, was the Commonwealth not punished for giving an inverted video the first trial? The Commonwealth says that it was recorded that way, and had they manipulated the video, that would have been a problem.
You see Michael Proctor in
I
this
think-
video?
The bigger problem for the Commonwealth was portraying the video during testimony as if it reflected the opposite side of the car and not making it clear from the beginning that it was flipped. That's the problem. Turning over the video in the state that they recovered it from, as they say, not the issue. Not notifying the jury that it was inverted so they weren't looking at the driver's side, passenger side, the way that they thought they were. That was the problem. And no, that was not addressed well.
I believe that's him, yes.
And which side, and let's start with this. Do you agree that this is the correct version of the camera angle and the SUV as it pulled into the Sallyport?
This is
The portrayal was the issue.
the footage, the way that is depicted right now is very accurately depicts, or very accurately
What?
represents what I remember from being there.
In fact, this side of the vehicle that we're looking at that's closest to us, that I'm highlighting on the screen to your right, that is in fact the driver's side of the vehicle, not the passenger
Correct.
side of the vehicle. Is that correct?
That is correct.
The far side over here would be the right rear of the vehicle, correct?
Yes, sir.
Which area is Michael Proctor walking to? The left rear or the right rear in this footage?
It appears if that's him, he's walking to the right rear of the vehicle.
Can we play this forward? And do you see Mr. Proctor's head above the SUV?
Yes.
And watch him as the tow truck driver walks by. Did he appear to move?
He shifted weight, yes.
And it appears that there's another person that showed up in the footage, an anomaly of some sort.
It actually looks
Walking-
more
walking
clear
off
that the
screen, left to
person
right. Is that right?
walking
That's what it appears, yes.
triggered the
Mr. Proctor
motion
still at the right rear
activated
taillight area.
He's in that general
in
vicinity,
this
yes.
time.
Let's go ahead and play it forward. A little bit further. Pause. Can you see anything in his hand? Let me just ask it. Closed in. Do you see the portfolio in his hand?
No.
It would not be unlikely that it's there, but I can't tell exactly what it is in his hand.
Let's play it forward. Do you see anything in his hand now as his arm?
Yes, yes.
Does it appear to be consistent with the black portfolio that we saw earlier?
Yes, it is, yes.
Let's move forward. And he is now off screen, correct?
Yes.
So, in point of fact, Sergeant, when you were asked previously
That's the
whether
point.
the prior video fairly and accurately depicted what you recall as it pertains to the SUV and the Sallyport, that was not quite true, correct?
I'll allow it.
The way I understood the question is what I'm watching accurately depicts what's taking place. It is. Just because it's a mirror image doesn't mean that it's not recording what the actions and what is transpiring.
But you would agree, at least, that the previous video showed exactly the opposite of what was true and correct, not just a mirror image. What is left is right, and what is right is left, correct?
That's compound.
Changes to that form.
Yeah, it's compound.
Would you agree that in
And
point of
it's
fact,
argumentative.
a mirror image video is not a true and accurate depiction of what's depicted in a scene?
He's not going to agree
I
with
think
that.
it just is a mirror image of what's taking place. If you see someone walking in or driving a vehicle and it's depicting the action of the vehicle being pulled in, and if it's mirrored, it's pulling in from left to right or right to left. It's still documenting the activity that's taking place.
Or if someone walks to the left rear of the vehicle versus the right rear of the vehicle, those two things will be switched, correct?
They
That
would
is correct, yes.
They would
You'll agree
appear.
that the prior video that we showed,
They appear
You and I-
switched to the jury, and that is the whole issue. The issue is that it appears like he's going to not the side of the vehicle that is at question. That is the problem. The representation leaves a wrong impression. Even if everything is documented as it happened, it leaves the wrong impression as to what side of the car it's happening to, which is the problem.
I just talked about, the inverted video appeared for all intents and purposes
Because I was
to
inverted.
show Michael Proctor stay away from the left, from the right rear taillight, walk all the way around, and position himself to the left rear taillight. You'd agree with that, correct?
Objection.
Do you agree with that? I'll allow it.
It appeared that that is what was happening, but he was standing next to the taillight that was already damaged.
But in
That's
the
an issue.
corrected video, which is this one, it actually shows unequivocally that Michael Proctor walked directly to the right rear taillight portion of this SUV. Correct?
I'm sorry, can you repeat that?
Sure. In the corrected video, this video here,
Sir.
this unequivocally shows that Michael Proctor walked toward the right rear area
This
of that
witness.
SUV, where the right taillight is. Correct?
Yes.
Right.
And you'll also agree that this video was taken before any taillight material was ever found at 34 Fairview, correct?
Can you zoom in on the time?
He's like, tell me what time it
This
is.
is backwards.
Then I would need to see the other one.
I know that the SUV pulled into the garage at the Sallyport at 5:35, and we were still on scene at 5:51, almost 52. So, yes, if that's timestamp before 5:51, before we left Canton PD, then yes, taillight pieces had already been found.
So 5:35, 5:37 is before the first taillight pieces were found. Right.
I'd have to see a timestamp of when they were exactly found, but if
Let me ask
that,
it a different way. 5:37, 5:35 is before 5:45.
yes.
Jackson
just
walked
a
away
moment
from the
ago.
mic, but the first pieces of taillight were found at 5:45 p.m. at 34 Fairview. Sergeant Bukhenik said that they were at Canton PD until 5:51, 5:52. The video, to the best of his memory, is that the SUV pulled into the Sallyport at 5:35, 5:37. But the first pieces of taillight were found at 5:45.
Sergeant, Canton PD is about a mile and a half from 34 Fairview, is that right?
Approximately. I don't know the exact distance. I never measured it, but I would not be shocked if you were accurate in that.
Maybe a 3 or 4 minute drive.
Depending on the traffic conditions and the weather conditions, that could be a possibility, depending on the speed you travel.
I'm sorry. Your Honor, I have a photograph that I'd like to have marked with the court's permission. If I may approach.
Marked for identification.
Marked for identification for the time being.
Okay.
Okay.
May I approach?
Yes. Let's mark it first, please.
All right, they're marking that for identification, showing it to the witness. I zoomed.
Let me take a look.
Thank you. Let me ask you a couple of other questions. We just looked at the videos of the interior of the Sallyport. Harkening back to what we just looked at, the corrected video, there would also be a camera on the other side of that Sallyport garage, pointing down toward the right rear taillight area of the SUV, correct?
Yes.
There's a camera situated on the opposite side. We'd be looking at that camera, correct?
Yes.
Okay, taking a look at that photograph, I know the quality of it, but can you tell if that appears to be a still image from that camera?
Oh boy. What, if anything, can you make out from that video? Oh, there's another camera. I mean, everything it records.
Yes, it
is
appears to be a still image from that video camera.
I'd ask that this be
like just
moved into evidence, Your Honor.
all shadow.
Objection?
Like nobody set the exposure of the camera. It's just a mess. We'll take a look if we see anything from that camera. That camera is a mess. Like all of a mess. Like all of a mess.
If we could display this for the jurors, Your Honor?
Because the jurors are going to want to know, right? Don't you want to know? Is there a camera on the other side? You want to know.
Do you see what's depicted? I know the photograph that you're holding is very poor quality. It's
Look
a
at
little easier
this
with this lighting.
photograph.
Do you recognize what's depicted in this photograph?
A head,
I'm sorry, your laser was bouncing off on the ceiling. I
I was trying to
apologize.
make it easy.
a head, a car, and an SUV, and what looks like a dolly of some sort.
Easier for you.
Yeah.
This photograph here.
That appears to be the seized SUV belonging to the defendant, with it being situated inside the Sallyport.
And what is that vehicle there?
It's an antique police cruiser.
And who is this person?
I do not know who that is.
Does that look like Michael Proctor?
Dude,
Don't know. I'd have to get a zoom in.
all of them
I
have
don't
bald
know.
heads. How are you going to know who it is? I want to know what time that's from.
Could that be, does he have glasses on?
I don't know.
Could be Chief Berkowitz.
What
It
time
could
is
be
that?
Chief Berkowitz. I don't know.
11?
Can you tell me the date that's on the time, the date and timestamp at the bottom?
What?
I cannot. I think I might be able to make it out in the actual photograph you printed out.
1:30.
Could I
Okay.
take a look at that?
2022. It looks like 11 something a.m., maybe 11:01
Yes, please, Your Honor.
a.m. But that's from 1:30:22.
It appears the time is 11:08 and 59 seconds in the
08?
morning of
Okay.
possibly January 30th of 2022.
Okay. Let's go ahead and pull this back out full frame.
Thank you.
I wanted to ask you, do you have a point of reference? Does that appear to be the interior camera facing the other direction
Looks like a dolly sitting
where
right
the
there.
SUV was depicted in the Sallyport earlier?
It's the opposite of what we had viewed earlier, diagonally across, I believe.
So this would be the right rear of the vehicle, correct?
That is correct.
Now I'd like to ask you to take a look at a video.
And that person's
We
hand.
have that point of reference. You want to have a final video.
Scientific services didn't come out till February 1st or 2nd to process the vehicle. Council are chatting for everyone listening in the background. Jackson and Brennan are chatting about whatever is coming next and whatever is going to be played next.
As next in order, Your Honor.
As next in order, so there's no objection, Mr. Brennan?
I have no objection to that being entered now.
Exhibit 121.
So that's being marked into evidence with no
Your Honor, with
objection
court's
from the
permission,
Commonwealth.
we present this?
And they're going to play the video that was after they established the photo.
Play it.
Oh boy.
Pause. Can you make out, now that that's paused, can you make out what's depicted toward the top of the screen?
Sir.
Yes, it appears to be a distorted image of that antique police cruiser.
How?
And does the area next to the police
That's
cruiser
from the
appear to
29th
be
at
empty?
6:07 p.m.
Some snow on the ground?
Yes, it does. Actually, yes, it does look that way. Yes.
Okay.
What?
So there's nothing next to the police cruiser, at least at this point, correct?
That's what it appears to be. Yes.
Can we take a look at the timestamp on this document?
Is that
Or on
5:07?
this frame? I'd ask you to let the jurors know if you
Yep,
can see
5:07.
what the actual run time is on this.
I could see the timestamp. I don't know
the only thing you
the
can
runtime,
see.
what it's going to be.
It's 5:07, 10 or 12, something like
That's
that.
the timestamp.
That's the
not
timestamp.
runtime.
Yes.
Okay.
Yes. PM.
Now, if we could just play this forward, go back to full screen.
Holy shit. When y'all asked if there was video, this is what there is.
Pause. Now,
Sure.
how many seconds would you estimate, just in your head, just went by in real time?
Approximately 5 seconds.
Okay. Do you see something in the video now?
Yes.
What is that?
It appears to be the seized Lexus SUV.
And now let's look at the timestamp. What time is that?
5:47 p.m.
So, in about,
What I would want to
according to your
know
testimony,
is all the video that is really, really squiggly. I'd want to know the timestamps before that if it triggered the video earlier than 5:47. Like, when did it trigger again, even though the video is total garbage? But that's not the point of the defendant's cross.
in
I'm
about
just
5 seconds,
curious.
the time jumped from before the SUV was in the Sallyport to about 5:50 p.m. after the SUV had already arrived and is now situated in the Sallyport, correct?
Yes, that is correct.
The time frame that we just saw earlier, of about 5:35, 5:36 or so, with you and, with the tow truck driver and Michael Proctor in the video, that is not in this video. It's not captured in this video, was it?
It did not present itself, no.
No, there was a lot of squiggly bits. I just want to know what time the squiggly bits were from, because I'm curious.
That's all I have now.
Mr. Brennan?
We're done with cross? We're done with cross. We're done with cross. We're done with cross. Okay. Back to redirect. I'm surprised that that ended there. Well, let's see what else happens, because he said, that's all I have. Okay. We didn't get back. I'm surprised that we didn't get back to the video from 1:30:22. All right. To redirect with Mr. Brennan, which I imagine is going to take quite a while, but maybe not. Brennan has done brief redirects at certain points. That was a relatively short cross after lunch, which surprised that that's a lot of binders, Brennan.
Good afternoon, sir.
Good afternoon.
You had just asked questions about
Because there's a lot of questions.
some of the video footage from the Canton Police Department Sallyport area. Is that fair to say?
I appreciate
Yes, sir.
starting from
I'd
what
like to
we're
ask
just
you
talking
further
about.
questions about that. In your investigation, did you obtain
Oh, he's got
camera footage from a number of different angles
Brennan's
from
got a binder full of discs. Okay.
the Canton Police Department Sallyport area?
I did.
And one of those series of footages, did that include the interior Sallyport back wall for January 29, 2022?
Yes, it is.
Is that the video that appears inverted, and then we saw the second where it was present as you would see it?
Yes, sir.
Did you look at that video? Did you invert the video in any way?
No, I did not.
Did you investigate and learn whether or not there was any other video
Those are
in
good
addition
questions.
to that interior Sallyport back wall where video was set up by the town of Canton that appears inverted rather than forward?
Objection.
I'll allow it.
Yes, the investigation revealed that multiple cameras had a lens applied to it that was inverted.
In addition to the Canton Police Department Sallyport interior back wall, where else did you learn around town there was video that appears inverted?
I believe it is inside the Canton PD, the hallways, possibly. And if I am not mistaken, a other locations within the town of Canton. And
Ask the question. No, is that your answer? Is that your final answer?
He wasn't.
I wasn't
Is
finished,
that your
but yes.
final answer? We're not phoning a friend. Is that your final answer? Your Honor. All right. And they're going to sidebar to talk about the fact that there were other cameras that were inverted. Having a lens installed wrong, I think, is the first time we've heard that, or a lens applied to it. I don't know what he means by lens. I don't know if he means hardware or software. I don't know. What we heard from pretrial hearings is that there were other videos that were, in fact, inverted.
The answer.
And those
Sure,
were, I don't know, discovered later.
Sure is I'm going to strike the portion of the answer that follows hallways of the Canton PD.
He said other locations within the town of Canton. That was stricken.
And sir, when you obtained the video from the interior Sallyport back wall, which was inverted, did you provide a copy of it?
Yes, I did.
Because
When
it
you
was
looked at that
inverted.
video, does it have time and date stamps on it?
Yes, it does.
May I approach?
Yes.
I'd like to introduce a copy of that.
I don't think he even clocked that it was inverted. He should have, but I don't know if he did or not. He should have. We went, for those of you that did not watch the first trial, I completely understand. We
When
went
you
a
provided
day
the
with the
video
chat
for
saying the number on the back wall is flipped. The writing on the back of that cruiser is flipped. Like shit is flipped. Is this inverted? And me saying, well, the Commonwealth should address it. The Commonwealth should address it. And then we got to cross and Jackson was like, yo, this is me summarizing, that shit's flipped. And it was like, yes, it appears to be a mirror image. They never even asked about it on direct examination. I was just like, what are you doing?
January 29, 2022, for that inverted video. Did you do any further investigation to see if it was an anomaly that happened just on that date, or whether that was historically the way the video appeared?
I'll look into that matter, produced the fact that it's been recording that way previously to January 29th.
Why did you want to historically go back and see if it was historically the same way?
To show that it had not been manipulated or altered in any way, and it was accurately recording what was taking place on January 29th, 2022.
It was
As
accurately
part of the
recording
investigation,
flipped.
was the video taken from...
What strains credulity in my mind, and I don't think they'll get into this with the jury, is how were you able to go back beyond January 29th and check that video when we were told in multiple motions that that video all overwrote in 30 days? So if the video overwrites in 30 days, how in 2025, which the jury does not know, can you go back and look at video prior to January 29th, 2022? I have questions.
From January 1st, 2022.
Yes.
And is that before January 29, 2022?
Yes, it is.
I'd like to approach and move to introduce this.
Okay.
Will the jury know that? Probably not. Might it come up in recross? Maybe. But they say we have video of January 1st, 2022, and that shit's inverted.
You know how many cameras are inside the Sallyport?
I don't know exactly. I know that there's at the very least 2 inside the Sallyport.
You were shown a still photograph, not from the inverted video, but from a different video or a
From the
different
other
camera.
Yes, sir.
Do you remember that photograph?
I do.
And you were asked about gaps in time. Do you know what the health was of that camera around that time?
I do not know.
Did you
I mean, was it having its
obtain
well checks?
and look at video from that camera?
Yes.
That camera looks like shit.
May I approach?
Yes.
I'd like to introduce...
The health of that camera, poor.
I had to look at this before. introduce it? Do you recognize what that is?
Yes, I do.
What is it?
That camera was
It's
just
the
yelling
Sallyport
Johnny Five is
videos,
alive, I
the
suppose.
original
That
disc.
video
Or
is in worse
thumb
shape
drive, I
than
apologize, not
Wally
disc.
at the end of the movie.
No objection, Your Honor.
Okay.
Exhibit 124.
I know, it's easy for me to be picky about the weird way he asked the question. It's a weird way to ask the question.
When you saw that dark photograph, you later saw a picture that was clearer.
It's a
You were asked
shit
questions
camera.
about that. Do you know whether or not the video from that Sallyport area was clarified?
It was.
What does clarified mean?
It means it was enhanced to look clearer.
I think
And
that's
that
the
image you saw, was that a
best-
clarified photograph taken from the video that was not clarified?
It appears that way, yes.
Your Honor,
Do you know
no
who
cap. That camera
clarified
needs to
the
touch
video?
grass.
I do not know.
May I approach?
Yes.
Okay. All right, they approach the defense. I don't know what they're doing, but they approach the defense with the disc.
I know what is on that.
All right, we're going to back up as this disc gets admitted. I don't know if we'll see any of these.
On that.
Oh, yes, we went
Yes.
full cringy Gen Alpha slang. I do have
It's
a 13-year-old.
Sallyport clarified video from the front wall.
Thank you. I moved into this as an exhibit.
No objection, Mr. Jackson?
Sorry, Your Honor, no objection.
Exhibit 125.
With the court's permission, could I play a portion of the clarified video for the jury?
Yes.
With Ms. Gilman's assistance, could you take us to the clarified video?
Sure.
Of the Sallyport, and could you take us to about 5:35?
Is this from the shit camera? I think this is the super dark camera that the defense just showed. Ada Screen asks, why do the attorneys have to ask to approach? Anytime they're going to approach the witness or approach the bench, they have to ask to approach. It's part of courtroom decorum. It also it keeps things civil, but it is a long-standing part of courtroom decorum to
As
ask
Ms.
to
Gilman
approach the
searches, I have
witness.
other questions I can proceed with.
Okay, we'll turn the light
Also,
on
you just
again,
don't want...
please.
Did they play something?
Go ahead, thank you.
You also don't just want attorneys wandering around the courtroom.
Did you obtain video of
They played something. Hold on. I was waiting for something to happen,
you take us to about
and apparently they played it?
5:35?
I'm sorry. I thought by clarified it meant that we were going to see something. My bad. My bad. Just my bad. I thought we were going to watch this play. I thought that was just somebody bumping into the microphone. Was that the video? Because the videos don't have sound. I had to back up. We're still just staring at a black screen that doesn't even seem like a video is playing. Oh,
As
this is,
Ms. Gilman searches, I have other questions I can proceed with.
oh, as Ms. I was like, this is the camera that is unwell. It's called in sick. This video is out sick. It did not play. All right. Ms. Gilman's looking for something.
Okay, we'll turn the light on.
They're going to
again,
ask other
please.
questions. That presentation did not go
Yeah, thank
smoothly.
you.
Did you
Yeah, that did not
obtain
go
video
smoothly.
outside the Sallyport to show what time the tow truck arrived with the defendant's Lexus?
Well, I mean, the video.
Yes, it did.
Camera's apparently unwell, so you know,
May I
maybe it
approach?
needed a sick. I might need a sick day.
Hey, you and I, do you recognize it?
Yes, I do.
And what is it?
It's a disc containing CPD exterior Sallyport video.
Move to introduce this, please.
No objection, Your Honor.
Exhibit 126.
All right, we're going to get into when the tow truck arrived at Canton PD.
Similarly, did you obtain video from the front driveway of the Canton Police Department depicting the arrival of the defendant's Lexus?
Yes.
May I approach again, Your Honor?
Yes.
Thank you. And you another item, do you recognize this, sir?
Sometimes when they're doing a lot of
Yes, I do.
foundation, the
What
court
is
said
it?
you don't. Will
It's
say you don't
Canton
need to ask
PD
to
driveway
approach.
video.
But-
And
That's up for the court to say.
did you obtain?
Yes, it is.
I would move this into evidence.
No objection.
Thank you. Exhibit 127.
David JG said, why didn't they put all this on in direct days ago? They saved it for redirect because it wasn't the main point of their case. So I think they are waiting to see what came out on cross
Do you
and then
recall
address it on
when
redirect.
you arrived?
'Cause if
with
it
the
doesn't come up,
defendant's
they might not
Lexus
put
on
it in.
January 29th,
They're not gonna make it an
2022,
issue.
what time you reached the Sallyport?
To the best of my recollection, it was 5:35 p.m. is when the vehicle was placed into the Sallyport.
When you left Dighton after the tow truck lifted the defendant's Lexus and put it on the tow truck, did you follow the tow truck back to Canton?
Yes, I did.
Did you have your
Did the tow
dash
truck
cam
stop at any point
video
between
on?
Dighton and Canton Police
My
Department?
bad.
Other than red traffic lights, no.
When you were following, how were you following
I say my bad because he was in his personal vehicle, so he didn't have any dash cam.
the tow truck?
I was keeping a safe distance, always keeping line of sight behind the vehicle. I was following it from Dighton residence all the way to Canton PD.
Was Michael Proctor with you in your truck?
Yes, he was.
Did you take any detours on your trip back to the Canton Police Department?
No, we followed the truck driver. He led the way.
At any point, did you take any turns to Fairview Road?
No.
Did you know whether or not there was a search
The
team at
laughing
Fairview Road
is just
searching
a
while you
terrible
were driving
look.
back to the Canton Police Department?
I knew one was dispatched, yes.
Did you go to Fairview Road to speak to any of the CERT team members?
No.
Did you watch the CERT team members conduct their search?
No, I did not.
In any way, did you, at any point during that search, see it happening?
No, I did not, no.
When the CERT team members were there, do you remember that they arrived at 4:54 and 4:56?
I don't have a specific memory, but I know that they arrived sometime between that hour.
When you arrived at the Sallyport, at the Canton Police Department with the defendant's Lexus, what was your understanding of where the CERT team was?
My understanding was they were at 34 Fairview.
When you first arrived around 5:37 at the Canton Police Department, were any members of the CERT team at the Canton Police Department?
Objection.
I'll allow it. Lay your foundation.
Now, I asked you, do you remember about what time you got back to the Canton Police Department? Do you know specifically what time you got back?
I know we pulled in to the driveway at 5:30 p.m.
And did you see some of the timestamps that you were shown on cross-examination?
Yes.
Did you see the timestamp 5:37:18 when it was shown to you by the defense?
Yes.
At that time, when you were arriving and bringing the defendant's Lexus into the Sallyport, was there any CERT team members at the Canton Police Department?
No.
Were there any troopers who were speaking to you or receiving items or evidence from you or Trooper Proctor?
Absolutely not.
Was there any items
So back to the
exchanged
absolutely
between
not.
you and or Trooper Proctor and anybody else for that matter that you saw?
No.
While you were at the Canton Police Department in the Sallyport area, do you remember how long you stayed in that area?
Approximately 15, 20 minutes.
And so you were asked when the first items were found at Fairview Road. Do you remember that it was around 5:45?
Yes.
So at the time those items were first found at Fairview Road, where were you and Michael Proctor?
At the Canton Police Department.
When you were at the Canton Police Department and you had brought the Lexus back, did you ever see Michael Proctor leave the Canton Police Department without you?
No.
You ever see him hop in a car and take a drive?
No.
A 3-minute drive or a 4-minute drive?
No.
Did you ever see him leave for a 6-minute, 7-minute trip?
Objection, Your Honor.
It is
Major point.
awfully compound.
When you were at the Canton Police
I mean,
Department,
there's no answer in.
were you separate or with Michael Proctor?
We were together. Not obviously tied at the hip, but we were within eyesight, traveling together.
After you left the Sallyport area, did you and Michael Proctor immediately leave the Canton Police Department?
No, we stuck around.
Why did you stick around at the Canton Police Department?
To make sure that evidence was properly being protected with yellow tape around it. And we were making plans to go get dinner.
When you were making plans, did you go
believe
anywhere else
that.
in the police department after you left?
When the CERT team said it would be helpful to have pictures of what they were looking for after they found pieces of taillight at 5:45, what I don't understand is why one of y'all couldn't have busted out your department phones and just taken a picture of the car in the Sallyport and texted it back to the trooper that was on scene with CERT, because there was a trooper on scene with CERT. Because we heard from O'Hara and he said it would be so helpful to know what we're looking for. So maybe a photo would have been helpful. But alas.
The Sallyport area.
Yes, I believe we went to the conference room.
Was there anybody else that you saw in the police department when you went to the conference room with Mr. Proctor?
I remember talking to Chief Berkowitz in the police department. We were in the dispatch area at one point in time as well. So there was multiple people that observed us there.
At any point, did you give any items to Chief Berkowitz?
No.
At any point, did you ever see Michael Proctor hand or give an item to Chief Berkowitz?
Absolutely not.
You said Michael Proctor had a folder with him.
Yes.
Is that typical in an investigation?
Yes.
Did you ever see him place taillight or any item in that folder?
No, that would be absurd.
Did you ever see him retrieve an item or taillight pieces and give it or...
Sir, have you been listening to testimony over like the last, 14 days? I don't know if that would be absurd is going to help.
sneak it over to Chief Berkowitz?
Objection, Your Honor.
That's argumentative.
Did you ever see Michael Proctor ever hand any piece of taillight to Chief Berkowitz or any other officer for that matter?
No.
The entire time you were there, did either you or Michael Proctor, from what you saw, provide
Not writing
any
reports
items,
for
physical
500
items
days
to anybody
counts
else
as
that was
absurd,
there?
but, what do I know?
I'll allow that.
No, we did not.
Okay.
I'm going to back up that question because I was snarking at it. But Jackson objected vehemently. So we're going to back up that question.
Proctor had a folder with him.
Yes.
Is that typical in an investigation?
Yes.
Did you ever see him place taillight or any item in that folder?
No, that would be absurd.
Did you ever see him retrieve an item or taillight pieces and give it or sneak it over to Chief Berkowitz?
Objection, Your Honor.
Yeah, that one's argumentative.
Did you ever see Michael Proctor ever hand any piece of taillight to Chief Berkowitz or any other officer for that matter?
No.
The entire time you were there, did either you or Michael Proctor, from what you saw, provide any items, physical items, to anybody else that was there?
Objection, Your Honor.
I'll allow that.
No, we did not.
Okay.
All right. They're going to approach on, did you or Proctor provide items to anyone who was there? They're going to sidebar on that. I'm going to zoom until we get back from sidebar.
May I?
Yes.
At any point from when you first arrived at the Canton Police Department with the defendant's Lexus to the point when you left to go to dinner or to get something to eat with Michael Proctor, did you ever provide any
being
physical
allowed to ask
item
it again.
to anybody at the Canton Police Department?
No, other than dropping off the vehicle itself, we did not exchange anything.
Oh, don't say we, I'm just asking for you.
That's
Now I'm going
the
to
issue,
ask you, at
not
any
Proctor.
point when you got to the Canton Police Department until you left to go to eat with Michael Proctor, did you ever see him hand any physical item to any other person whatsoever?
No, I did not.
And after,
They broke it
do you know
down.
about what time you and Michael Proctor left the Canton Police Department?
I would have to estimate it to be around 6, maybe well after 6.
On cross, you said 5:51, 5:52.
The point you left, do you know how many of the items had been found by the CERT team at 34 Fairview Road at the time you left the Canton Police Department?
Objection.
When you left with Michael Proctor, where did you go?
I went to Norwood, Massachusetts.
Is that where you ate?
Yes.
Where is Norwood vis-a-vis Canton?
When you left and then arrived in Norwood, did you stop along the way at any other place, including but not limited to 34 Fairview Road?
I did not.
Did you eat?
Yes.
After you ate, where
Chad
did
is
you
saying
go?
Norwood is right next door.
Back to Canton Police Department.
Why?
Makes sense.
We were having a debrief for that day on the investigation so that everybody could get on a good understanding of what had been learned, what had been collected.
Like the same page, so everybody could get on the same page. So everybody could get on the same page.
And where the
Ah!
investigation stood, and to assign tasks on the next steps.
Who were you meeting at the Canton Police Department when you returned?
It was the Detective Lieutenant Tully, members of the Norfolk SPDU.
Do you know at
Who's
about
that?
time you returned to the Canton Police Department?
I want to say it was after 7:30, but I'm not positive.
When you left the place that you and Mr. Proctor ate at and returned to the Canton Police Department, did you take a swing by Fairview Road?
No.
Did you stop anywhere from the point you left where you ate and came back to the Canton Police Department?
No, sir.
When you came back to the Canton Police Department, did you get debriefed?
Yes.
Did you learn whether or not the CERT team had found any physical items at Fairview Road?
Objection.
I'm going to allow that.
Yes, I did.
Did they give you any details about what they had found at Fairview Road during the CERT team search?
Objection.
I'm going to allow that.
I learned that
Objection.
I'm going to allow this.
the second sneaker was located. Also, a large piece of red taillight was also located.
After you were debriefed, did you leave the Canton Police Department?
Yes.
Who did you leave with, if anybody?
It was myself, Trooper Proctor, and Trooper Keefe, I believe.
When you left the Canton Police Department, do you know what time that was?
I do not, but I would have to estimate to be around 8 o'clock, maybe 8:15.
Did you leave alone?
I was in my truck, yes.
Did you
So,
see
Mr.
where
Brennan,
Mike...
what I'm going to do is just interrupt you for a minute. Folks, a couple of minutes ago, when Sergeant Bukhenik testified as to what he learned at the debriefing, that's not offered to you for the truth of what he said was learned, but only so you understand that the police, what Sergeant Bukhenik and the police knowledge was at the time, that it was told.
Okay.
Go ahead, Mr. Brennan.
Thank you.
I mean,
When you drove away,
it's
were you
already
alone?
okay.
Yes.
Okay.
Your Honor, you can just do it when the defense
When
objects
the Lexus was
because of
Brought-
the hearsay. It's in evidence, but
to the Sallyport, did you have a chance to again look at that right rear taillight?
Yes.
And did you make observations of it?
Yes.
okay.
The right rear taillight. Those photos, the right rear taillight.
The judge was giving a limitation on the hearsay from the debriefing. It is already in evidence. But all right. The attorneys have approached one another. I go over what the judge said? She said the debrief was not for the truth. It was for that's what they were told, which is fine, but they've already heard from the search team
While you
search
were
with
at
O'Hara.
the Canton Police Department and in the Sallyport area, did you ever see anybody take a piece or in
The
any
defense
way
had objected quite a bit to that hearsay.
remove part of
I don't know
that
if the limitation
broken
helps after the
taillight
fact.
from the Lexus?
No, I did not.
If you had, what would have you done?
They're asking if he removed anything from the Lexus, so I'm going to back that up. They were, I don't know if they're looking at photos, but the attorneys were talking briefly there.
While you were at the Canton Police Department and in the Sallyport area, did you ever see anybody take a piece or in any way remove part of that broken taillight from the Lexus?
No, I did not.
If you had, what would have you done?
Objection.
Sustained.
May I approach, Your Honor?
Yes. Show Mr. Jackson.
The attorneys have to show each other what they are showing the witness and what they are putting up for court.
Okay.
And they're going to display that, it seems, for the jury.
Could you zoom in a little, please, Ms. Gilman?
It's a photo from the
Do
Sally
you
Port.
recognize that photo?
I do.
What do you recognize it as?
I recognize it as the damaged and missing pieces of the right rear taillight on the defendant's Lexus SUV.
When the Lexus was brought into the Sallyport, was there still snow on it?
Yes, there was.
Was there any snow on it that covered parts of the vehicle?
Yes, there was.
Was there any snow in that area
Currently, no.
When it
when
came
you first
in,
brought it into the Sallyport?
I'm sorry, in the area of the vehicle?
No, the area of that
Oi.
taillight.
Yes, there was, yes.
How close did you get to take a look at that?
I was within a foot of it.
Is that a fair and accurate depiction of what you saw?
Yes, it is.
I mean,
From
was
what
there
you saw,
snow in it?
Was the damage you saw when you looked at the car for the first time in the Sallyport area any different than the damage that appears on this Exhibit 13?
It is not.
It probably had
As part of your
snow.
investigation, did you look for, you can take that down, please, and lights on, thank you. Did you look for other evidence that the taillight was broken before it came into the Sallyport area?
Yes, I did.
Did you have a chance to view the ring video from Meadows Road at 5:07 in the morning?
Yes, I did.
And when you looked at that, did you have an opportunity to look at the defendant's Lexus backing up and then leaving that driveway?
Yes, I did.
Did you have a chance to see if there was any evidence?
When did you look at that, though?
Yes, I did.
And what did you see that stood out to you about the taillight?
The taillight is shining white and not covered by a red taillight cover, which would have produced a red light.
Did you further look at any video from the Canton Police Department dash cams to get a view of that taillight and determine whether it was broken before it was even brought to the Sallyport area?
Yes, I did.
And did you in fact look at video or still photographs from the Canton Police Department dash cam?
Yes, I did.
Could I have Exhibit 11 displayed, please? And during your investigation, when you were making this analysis, did you view this photo?
Yes, I did.
Did you make any particular reference or anything that caught your attention in this video?
Yes, the right rear taillight of the Lexus SUV is missing the red lens cover, and it is damaged.
You mentioned the observations. You can take that down, please. You mentioned your observations when you got to Dighton about what you saw relative to the taillight. And then at some point, video was provided of the tow.
Yes.
Did you study that video as well?
Yes, I did.
And did you see anything in particular when you were making these determinations that stood out about the video of the Lexus being put onto that tow truck relative to the taillight?
Yes, the video indicated that there was white light coming through, exposing the missing red right rear taillight cover.
You told us on direct examination you've watched a number of videos and interviews of the defendant.
Yes.
Without getting into the content, did you watch any videos where the defendant talks about the broken taillight prior to the Sallyport?
Objection.
Not formal, sustainer.
Did you listen to any interviews of the defendant relative to the taillight?
Yes.
He's going to have to be more
I
specific.
want to go back and I want you to take us through your investigation, and I want to be specific about what you learned and when and what you did with that information relative to the decisions and the direction of your investigation.
Okay.
When you were called on the morning of January 29, 2022, when you first got a call, where were you?
I was at home in bed.
You mentioned that after you received the call, you called another trooper at that time.
Yes, sir.
And who was that?
Michael Proctor.
After you spoke to Michael Proctor, did you have any firsthand knowledge about what had happened prior?
No, I did not.
Did you have any firsthand knowledge about what had happened the night before?
I did not, no.
Do you have any firsthand knowledge about the participants or the people that may or may not have been involved?
I did not, no.
Did you at that point know, or were you friendly with Brian Albert?
I knew who he was. I was not friendly with him. I did not know who he was.
Had you ever socialized with him?
No.
Nicole Albert?
No.
Were you friendly or ever socialized with her?
Just let him finish the
No, I've never.
question.
Jennifer McCabe? Did you know who she was or socialize with her?
No, I did not.
Her husband, Matthew McCabe, did you know him or socialize with him?
No.
How about Julie Nagel? Did you know who she was or had you socialized with her?
No, I did not.
Ryan Nagel, is that name, was that familiar to you?
No, it's not.
Sarah Levinson, did you know that person?
I did not.
He doesn't
you
know
mentioned
these
that you knew
people.
who Brian
Got it.
Higgins was,
Yes.
and you had worked on a case or some involvement in a case with him?
Yes.
Did you owe him any
Brennan-
particular favor or kindness?
It's a good line of questioning, Brennan. However, this witness also went through Proctor's texts and said that this investigation was committed with honor and integrity. So no matter what you do on redirect and what you do with this sergeant, knowing or not knowing the individuals involved, I don't know if that's going to help undo the, yeah, I think Proctor's great. Like, I don't know if it's going to unring that bell, but it's a good line of questioning for, did you know any of these people? No. Didn't know any of these people. Okay.
At that time? You mentioned that you knew who Brian Higgins was,
I had to
Yes.
back up to see what he laughed at.
and you had worked on a case or some involvement in a case with him.
Yes.
Did you owe him any
Brennan's getting
particular
snarky.
favor or kindness at that time?
I'll sustain it.
Did you have any
It's argumentative.
loyalty or friendship with him?
I'll allow
That's less
I did not know.
argumentative.
At this point, you are how far into your career as a Massachusetts State Police officer?
In 2022, I was approximately 10 years in.
And you had been honorably discharged from the military,
Yes, I was.
served the president?
Yes.
And so at this point,
And still thought that Proctor conducted himself with integrity. See, that's the underlying through line of all of this. Did you know any of these people? No. Okay, but
how about Heather Maxon? Did you know that name?
I did not know.
When you first received the call, did you have any firsthand knowledge whatsoever?
No, just what I was told over the phone.
You mentioned you went to the Canton Police Department first and spoke to Canton police officers.
Yes.
Was it at that point you learned about a physical item that was found at the scene? What did you learn from them that was important in your investigation when you first got to the Canton Police Department?
I learned that there was a broken, shattered cocktail glass that was recovered from near where Mr. O'Keefe was found.
I mean, I don't know.
And
if
also his
shattered
phone was underneath him at the scene.
represents
Were both those items available to you?
what
Yes.
you saw.
Did you also learn any statements made from any witnesses that were attributed to the defendant at that time?
Yes.
And what was the statements?
At that point in time, while at the Canton Police Department, the statements were, "Oh my God, did I hit him? Did I hit him?"
In a question format, questioning.
Yes.
Questioning.
And based on that information, was it somewhere around that point when you called the hospital or medical examiner's office?
Yes, I made a call to the medical examiner's office.
Is that all the information you learned that morning?
No, it's not.
After you learned that information, did you ask the police officers, well, let me ask it this way. After you learned that information, did you want to go somewhere?
Yes, I did.
Where did you want to go?
Away.
I wanted to interview.
I wanna go. It's time to bring back the Britney. Away. He wants to run the fuck away. No, that's not going to be his answer. That's his answer today. No, Emily, too much snark. Did you want to go somewhere? Away. Away.
The police
Away.
officers, well, let me ask it this way. After you learned that information, did you want to go somewhere?
Yes, I did.
Where did you want to go?
I wanted to interview the individuals that were with the defendant when Mr. O'Keefe was located and get their accurate and most first-person information from.
I might be being picky. Isn't the best way to determine the accurate information of a witness to, like, I don't know, interview them alone? So that you have their memory of the event and not everybody else's memory of events? The most accurate the most accurate would be to interview everyone alone. Adam Goals in the chat said, way down to Kokomo. Look, the Kokomo's a lie. Here's why. Because I was really excited when I learned that I would be visiting Kokomo, and have since visited Kokomo. Kokomo, Indiana is not what they were singing about. Is not what they were singing about in the song. There are multiple Kokomos, chat. Just be sure you know where you're going and to which one. Cause not the same. Not the same. Not that Indiana's not lovely, but different Kokomos. Different Kokomos.
Them directly.
The feed is tired of this answer.
Person, their
That was the feed buffering, not me.
accurate and.
I'm sorry. We need to get you back to talking about the accurate. The accurate. There, I will say, for all of you saying that you also know Kokomo, Indiana, there was a great Mexican restaurant that had really good tacos. I'm just going to say, I don't remember the name. Really good tacos. Like legit good tacos. I'm going to have to ask Travis to remind me, but
Well, let me ask it this way. After you learned that
we have to
information,
get back
did you want to go somewhere?
to disassociating
Yes,
with
I did.
this.
Where did you want to go?
He wanted
I wanted
accurate,
to interview
Right.
the individuals that were with the defendant when Mr. O'Keefe was located, and get their accurate and most first-person information from them directly.
accurate and most first person does involve interviewing them separately.
Differently witnesses.
At this point in time, prior to
feed
speaking
buffer.
to them, I just knew that they were eyewitnesses for the location of Mr. O'Keefe, but I did not know if they were eyewitnesses or witnesses.
And who did you speak to?
I spoke with Ms. Jennifer McCabe, Mr. McCabe, and Mr. Brian Albert.
When you spoke to them, did you separate them or speak to them as a group?
I separated them.
You went to whose house to speak to them?
The McCabe household.
Is it typical to go to a person's house rather than bring them to the station under these circumstances?
Ask it differently, Mr. Arm.
I think
Why
he's allowed to ask
did
that,
you
and I think
go-
he's allowed to ask that because the defense has been asking a lot about police procedure and proper procedure. He's allowed to ask.
Go to their house rather than ask them to come to the police station?
Well, there were multiple factors involved in that decision. One, the driving conditions. Two, these are witnesses that had suffered some sort of traumatic event, finding their friend on the front
Yeah, law enforcement normally interviews you where there's video, even if you've been through a traumatic event.
lawn of their own town. So going to their home would provide hopefully a more comfortable scene for them to recall information in the comfort of their own home.
When you spoke to them, did you receive any information from any of them that Mr. O'Keefe went into 34 Fairview at any time that night?
It's
No.
a good question.
When you were asked questions about scene versus crime scene, was 34 Fairview, the home, the inside of the home, a crime scene in your mind?
No.
Was the area where Mr. O'Keefe found an important or unimportant area?
It's very important.
Did you know whether or not any of the Canton Police Department officers at that time had done any type of limited search of the area?
Just whether you knew.
At that point in time, we did know, yes.
And what did you learn about the scope or the breadth of that search by the Canton Police Department?
I'll allow that.
I knew that it was brief based on the weather conditions and the item that was recovered.
After you spoke to Jennifer McCabe,
It was
did you say
brief
Brian
with
Albert?
Jennifer
leaf
McCabe,
blower.
Matt McCabe, and Brian Albert.
At that point, did you have any reason to want to go into 34 Fairview?
No, I did not.
Did you learn whether or not Canton police officers spoke?
Did you learn that your witnesses who were giving the whatever the most first person response is? Did you learn about them sitting down together to make a timeline? Did that come up in the questioning at all? Because I have questions.
To those particular people who lived
Did
there
they tell
before
you
got
that,
there?
or
I had learned, yes.
What did you learn?
I learned that Canton police officers went inside the home, spoke with members inside the home as well.
When you speak to witnesses, you've done many interviews over your
Yes,
career?
I have. Yes.
In addition to asking questions, what are you looking for when you speak to a witness?
We're looking for body language, how willing they are to provide the information, and as is with everyone, we always trust by verify. We corroborate their statements.
Did you
Verify?
see anything about
oh, that's not what he's asking.
these witnesses when you spoke to them that cued you or concerned you to do a further investigation?
Ask it differently.
Was there anything about their mannerism or demeanor
Sir, was
that
there
stood
anything
out to you?
sussy?
I'll allow it.
No.
After speaking to the witnesses, in your mind as an investigator, what did you need to do next?
I needed to take a look at Mr. O'Keefe's injuries for myself.
And you share with us detail about when you went down to Good Samaritan Hospital to make observations.
Yes, sir.
On direct examination, I pointed out you're not a medical examiner, are you?
I am not, no.
Not a biomechanical engineer.
I am not, no.
In your experience, when you looked at Mr. O'Keefe and had a chance to study his body, what impression did that leave you with relative to your investigation?
Objection.
At that point in time, after viewing Mr. O'Keefe's injuries, my impression shifted from him possibly being struck with the glass that was located at the scene where he was found to him being struck by a vehicle.
Why?
Due to the abrasions and cuts on his right arm and the amount of force, in my experience, the amount of force one would have to generate to produce the wound to his head.
Objection.
I'm going to strike that last part.
After coming to the conclusion, or strike that,
Chad, I'm with you. Does that make sense? No. Is there going to be a recross? Yes.
after making your observations and your determination, did your focus shift at that point?
Yes, it did.
Where did you want to go next?
I wanted to observe the vehicle that the defendant was driving.
How many motor
What were
vehicle
you going to be
collisions have
looking
you
for?
investigated?
Any damage to the headlights,
We're not going to get to another witness
windshield,
today.
and other parts of the vehicle that would have come into contact with Mr. O'Keefe.
You mentioned the windshield and the headlights. Those are in the front of the car. Did you have an impression at that point?
Yes, majority of the cases that I had exposure to with pedestrian vehicle strikes, the strike comes from the front of the vehicle. So in my assumption, speculation at that point in time, based on the limited information I had,
You fought for like 45 minutes talking about speculation and assumption, and now here we are on redirect, and you're like, based on my speculation. I'm not saying that you're not wrong to come up with theories and then try to figure out what's happening. I'm just saying fighting with the defense on it ad nauseum and then being like, yeah, based on my speculation is a wild choice.
vehicle strikes, the strike comes from the front of the vehicle. So in my assumption, speculation at that point in time, based on the limited information I had, that was my theory.
Theory.
When
There
you
it
got
is.
to
All of them used
Dighton,
synonymously.
did that theory change?
Prior to our arrival to Dighton, the theory had changed.
Why?
Based on information you received from
Why?
Jennifer McCabe?
Objection.
Sustained.
I don't know if I would object to that if I was Jackson. I think that's a good answer. Prior to even seeing Karen Read's car, the theory had changed. Why? Because I think the real answer is based on what Jen McCabe said.
When you got to Dighton, did that theory change?
I backed it up.
Prior to our arrival to Dighton, the theory had changed.
Based on information you received from Jennifer McCabe?
Objection.
Sustained.
What was that based on?
It was based on information I received from Jennifer McCabe's phone conversation.
Right.
And what was that information?
That the defendant told her that she had damaged her taillight and showed Mrs. McCabe and Mrs. Roberts the missing pieces and damage to the rear right taillight of her vehicle.
When you got to Dighton
Right.
and had a chance to look at the defendant's Lexus, did your focus of your investigation?
So between the time you saw John O'Keefe at the hospital and went, because I think the timing is off from his direct examination with seeing John O'Keefe and thinking he could have been hit by the cocktail glass. And now saying when he saw John O'Keefe at the hospital, he thought that it was a vehicle collision. And then by the time they got in the car, before they even saw Karen Read's vehicle, they have theorized, let's be fair, they have theorized that Karen Read has hit John O'Keefe with her vehicle based on Jen McCabe's statements. So when I went into the House of Cards option for closing argument and everything going back to Jen McCabe, we are right back to everything is going back to what Jen McCabe said.
Develop in any way?
Yes, seeing for myself that there was actual damage, coupled with the statements made, did I hit him, could I have hit him, along with the my observation, obviously, of the vehicle, my focus began to concentrate on the defendant.
You share with us that you went inside and
Right.
spoke to the defendant.
Yes.
Why did you speak to her at her home rather than ask her or force her to come to the police station?
Same reasons we interviewed the witnesses, the driving conditions, the time that it would take for her to respond, the comfort of her own home or her parents' home, where she had just experienced a very traumatic event, being concerned for her well-being. We
Wanted the
interviewed
car.
her in the comfort of her parents' couch.
When you
You wanted the car. You wanted to see the car. You wanted to see the car. You wanted to see the car.
interviewed her in her parents' home, where was she seated?
On the couch of her parents' living room.
Where was her mother?
She was in the home. I don't have a specific memory of her being in the room with us, but her father was in the room with us.
Did you ever try to separate the defendant from her father when you interviewed her?
You said you wanted to see the car. Why leave out that you wanted to see the car? You wanted to see the car. They're approaching at sidebar. We're going to zoom past them approaching at sidebar. Looks like a fairly short sidebar, all things considered.
Bless you.
Bandit said, don't parents and spouses have a privilege of being there during an interview? No, not for an adult. Karen Read is an adult, so no. And there's no privilege or anything that goes to parents. But if they weren't treating her like a suspect, could it happen? Yeah, her parents aren't precipient witnesses, so they can choose to allow somebody to stay. But do they have a right to be there? No.
Right ahead. Mr.
Thank you.
Chairman.
Trooper, to get back to my question, when you decided to speak to the defendant, did you ask her father to leave the room?
I did not know.
Why not?
We just simply wanted to get her recollection. Her father did not pose a safety risk to us. He was not present, to the best of our knowledge at the time when Mr. O'Keefe
Right, he's not a
was
precipient witness.
injured. So
Right.
him leaving the room
Doesn't matter.
just didn't appear necessary. Again, my concern was for her well-being, having known that she was sectioned, and we wanted to make sure it was a safe and comfortable environment for her to do the best she could to tell us what she remembered.
What was her demeanor?
Them keeping in mind that she was sectioned is fair. And keeping in mind that she had been sectioned, been released from the hospital, and then was at her parents' house is a fair consideration, considering that her dad is not a precipient witness. So her and her dad talking about anything isn't going to change the way she remembers things, different than if you have percipient witnesses talking about what both of them witnessed. It is a different consideration, and they didn't ask him to leave the room. I'm not surprised that they didn't ask him to leave the room. Different than when you have multiple percipient
when
witnesses.
you spoke to her?
She was calm, stoic. She was sitting on the couch with a pillow on her lap.
Are we there yet? Asked, can they interrogate her while sectioned? She was not still sectioned. She had been released at that point.
A laptop to her left. She was, I guess, maybe poised when she was answering our questions.
I'm sure that'll come up on
When you
recross.
finished your conversation with the defendant, had anybody in that home ever mentioned the idea of whether or not John O'Keefe went into 34 Fairview that night?
No.
That's what they wanted to get out of those questions about
When
Karen
you
Read's interview.
went outside to get in your truck and follow the tow truck back to Canton,
Karen, in her
did
interviews
you
with
have
police,
any
never said John
information
went
whatsoever
into 34 Fairview.
that there was any animus or animosity between Brian Higgins and John O'Keefe?
No.
After speaking to witnesses and the defendant at that point when you got back into your truck to go to Canton, did you have any information that there was any animosity between Brian Albert and John O'Keefe?
No.
And none of those witnesses said, and we haven't seen them yet, but Karen Read did not mention to law enforcement that there had been any kerfuffling between Brian Albert or Higgins and John O'Keefe at the waterfall. And none of the witnesses from the waterfall, and we haven't heard from all of them in this case, but we did in the first trial, none of the witnesses from the waterfall said there was any kerfuffling between Brian Albert and Brian Higgins or anyone else and John O'Keefe at the waterfall. I think the defense did a really good job on cross-examination of going through the video from the waterfall and leaving the impression that there had been some kind of words exchanged between Higgins and John O'Keefe, and the prosecution does not have all those witnesses in that they had last trial saying nothing was amiss at the waterfall. And so they're relying at this point on what Karen told law enforcement when she was interviewed at her parents' home, which is her saying no, not saying that there was any type of yelling or issue at the waterfall, or that she had seen John O'Keefe go into 34 Fairview that night. So they are going to use those close in time interviews to rebut that presumption that I think the defense did a really good job of introducing on cross when you see those videos of Brian Higgins, Brian Albert, and John O'Keefe at the waterfall.
We've already talked about, out of order, your return back to Canton, the Sallyport, and then you and Mr. Proctor going out to dinner and going back, so I'm going to skip all of that. After you went home
But they
that
don't have
night,
those witnesses in
did
yet.
your investigation continue?
Yes.
How long do investigations continue for?
Until they are completed and exhausted, sometimes years, sometimes decades.
If you were to receive new information tomorrow, would you consider it?
Absolutely.
Sustained.
When you write police reports, is there a time limit on when you can file a report?
No.
Throughout this case, did you write a number of reports over time?
Yes.
Over
you
how long a
engage
period
in-
of time?
Tasks after the case began?
Yes.
Have you engaged in tasks recently?
Yes.
As you were investigating this case, did you speak to a number of witnesses?
Yes, I did.
Did you consider reports that were provided by other troopers who interviewed witnesses?
Yes.
Mr. Proctor was the case manager of this case?
Yes.
You were his supervisor?
Yes.
Were there other troopers who participated in this case?
Yes.
Do you know whether or not Lieutenant O'Hara participated in this case?
I do know.
You do know?
I do know
Did
that he participated.
Yes,
Yes.
do you know? He said, I do
Did
know.
he?
Yes.
Yes.
Do you know if
You
he had a
asked.
team with him of other troopers?
Yes.
Do you know if Trooper Prince engaged in any interviews?
I do know. Yes.
Are you familiar with the name Nick Gianturco?
Who?
Guarino. I saw it.
Yes, I.
How did Brennan butcher Garino's name so badly? What the hell did he call Garino?
In this case.
I do know.
You do know?
I had
do
to
know that
back
he
up.
participated, yes.
Did he?
Yes.
Do you know if he had a team with him of other troopers?
Yes.
Do you know if Trooper Prince engaged in any interviews?
I do know, yes.
Are you familiar with the name Nick Gianturco? Guarino. I saw it.
Hell. I mean, I'm a girl that mispronounces shit all the time, but I don't know how you get Guarino so fucking wrong. It's the first time this trooper looks like he's actually amused versus being snarky.
Yes, I am.
Brennan
And
also
do you know if he
laughed a
engaged in
little.
any tasks in this case?
I do know, yes.
What did he engage in generally?
He generally conducted the digital forensics portion of the investigation, extractions.
Trooper Keefe, is that a name familiar?
Yes, it is.
And do you know whether or not he was involved?
Yes, I do know.
Yes, Chad. Brennan went full
Were
Adele
there a number
Dazeem.
of other troopers
And
who were involved
100%.
in different aspects of this case?
100%.
Yes, there are a number of different ones.
Trooper Evan Brent?
Yes.
Oh my goodness. Yes, full Adele Dazeem.
Did you
Trooper Garino's
look or
getting a new
seek
nickname
other
in the group
information
chat, I imagine.
after you left the defendant's
I'm joking. There shouldn't be a group chat.
house?
Yes.
Did you look for other witness statements?
Yes.
Did you try to obtain further evidence?
Yes, we did.
Was there an interview with firefighter Timothy Nuttall on February 8th?
Yes, there was.
That was about 10 days after the incident.
Approximately, yes.
Did you learn any statements from him in addition to the earlier statements you learned that added to your investigation?
Yes.
Really?
I'm going to allow it.
Really?
And do you remember what Timothy Nuttall told you on February 8th, 2022 about any statements of the defendant?
Brennan,
So folks, again, this is being offered not for the truth of the statement, but simply to show that the information was provided to the police.
Yes, Mr. Nuttall was one of 3, I believe.
So talk about Mr. Nuttall, please.
Mr. Nuttall told me that the defendant
Lord.
stated, I hit him, I hit him, I hit him.
Was that information different than the statements that you were first learned about that she had allegedly made earlier that night?
Yes, it was.
the court gave that admonishment to the jury because it's
Did
not being
you
offered for the
interview
truth
firefighter
of whether or not the defendant said to Nuttall, I hit him, or whether or not the defendant hit him. It's whether or not this trooper had that information, because it goes to the investigation. So the defense asked a lot about the investigation, what you knew, what you didn't know, and that is going towards their defense that this investigation did not follow other leads. So when you get into what did you know as the investigation was going, then the redirect to that is, and what else did you know in this investigation? Because the defense is going to argue there are other leads they should have followed up on. And Brennan is going to go right back in redirect, which he's doing now, but these are the things that you knew during the course of your investigation. And this, they will argue, I am sure, is why other leads weren't followed. So you can't ask about the investigation and what they know and then object when it's followed up about the investigation and what they know. So that's why some of that is coming in for what the investigation knew.
Daniel Whitley on February 8, 2022.
I did.
When you spoke to him, do you remember whether he shared any statements about the defendant telling him anything about her interaction with Mr. O'Keefe at the end of that night?
I believe that he stated that they got into a fight.
Do you remember the words that he used when he described that fight?
I do not remember the exact words. Those will be reflected in my police report.
Would
In
the
your
police
report.
potentially refresh your recollection?
Potentially.
May I approach?
Yes.
Thank you.
And we're not going to be done with this witness today. That's what I'm suspecting.
not want you to read from it.
Okay.
I want you to look at it, determine whether it refreshes your memory, and then I'll ask you if it
Brennan,
refreshes your memory. If it does,
just
I'll ask
read
you
it.
about If it doesn't, then I won't.
Don't read it out loud.
Okay, sir.
KK, the reference to who is Adele Dazeem is a reference to Adina Menzel being introduced wrong. Not the Grammys. I think it was at the Academy Awards when she was introduced by John Travolta as Adele Dazeem and not Adina Menzel. So, yes, it is a callback to a name getting completely wrong at a very large moment. I think it was the Oscars. Was it the Oscars? Yes, the Oscars. With, I don't think it was the Tonys. I think it was the Oscars. So, and her name was just completely not right. He just buffered in real time and called her a totally different name. Because she was getting ready to perform Let It Go. That's what I thought, Emily Ippolito. The chat is like Oscars, 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 Oscars. So it was a name mispronunciation to the extreme.
After reviewing your report, does it
Cultural
refresh your
moment.
memory about your conversation with
Yes,
Daniel
it was at the
Whitley
Tonys when she got him back. Yes.
on February 8, 2022, about statements made by the defendant to him?
Yes.
And could you share with us what the statements were as related by Mr. Whitley back on February 8, 2022?
The statement was,
Again, jurors, this is an offer for the truth that's contained in the statement, simply to show that this information is provided to the police.
the defendant made a statement questioning whether Mr. O'Keefe was still alive.
And anything about the nature of their disagreement?
Is that the answer? Is that the answer that the prosecution was expecting? Not only did the prosecutor say, did Karen Read tell Daniel Whitley something about her having a fight with John O'Keefe the night before? Then he said, would it refresh your recollection to exactly what was said to Daniel Whitley by Miss Read about whether or not she and John O'Keefe had a fight the night before? And then he gives him the report, and then he's refreshed his recollection, and then they come back with Karen Read was asking if John O'Keefe was still alive. How are you not following the line of questioning on direct examination? I might have to rethink if he was just being difficult during some of the cross. Because how do you not? I know the question that's being asked. The entire chat, though not there and having no benefit of the reports, knows exactly what Brennan wants the answer from you to refer to. What exactly did Daniel Whitley tell you that Karen Read told him about whether or not she and John O'Keefe had a fight? She was questioning whether John O'Keefe was still alive. Sir, at least it's not just on cross. At least it's not just on cross. Because you've got to be kidding me that you don't know what's being asked. She wanted to know if John O'Keefe was still alive. That's not the question at all.
Statement, simply to show that this information.
That's not the statement at all.
The defendant made a statement questioning whether Mr. O'Keefe was still alive.
That's not it.
And anything about the nature of their disagreement?
Mr. O'Keefe and the defendant got into an argument.
So for the same purpose.
As you're learning this information, does it in any way shape your continued investigation?
Yes, it further supports witness statements. It further supports and corroborates information that we're learning. The more information we collect,
It doesn't
the
sound like it
stronger
was very
the case
impactful on you.
becomes.
The stronger the
Did
case
you
becomes.
interview a person by the name of Anthony Flamate?
It doesn't
Yes,
sound
I
like
did.
it was very
And when you
impactful
spoke
to you.
him,
Because you look
do you recall whether
confused.
he shared any statements that the defendant made to him?
The judge is continuing to remind the jury that this is not being offered for the hearsay purpose. It is being offered for the investigative purpose. So that's what the judge keeps saying and keeps reiterating to the jury, this is not being offered for the truth. But again, the defense on cross got very much into what did investigators know and when.
Yes.
And do you recall what those statements were?
What did Flamati say?
I do have a general recollection of what they were, but
I don't want you to guess. Would your report potentially
Probably not,
help your memory?
yes, it would.
because you asked him very specific questions about what Karen Read
Yeah,
told
Coach.
Whitley, and he dumped all over it. I mean, for everyone who's going to ask, how does Brennan do a redirect? Well, if your witness is just like, I don't know,
Thanks, sir.
the best you can.
Protocol that I mentioned before. Take a look, see if it refreshes your memory. If it does not, let me know. If it does, I'll then ask you some questions about it.
I don't think these felt very impactful to him because here's what's not working for this redirect. And not for lack of Brennan trying. Brennan is trying. Brennan actually has a pretty decent strategy for redirect. This witness just can't answer a question. What Brennan is trying to do, which is, I think, obvious to everyone watching this, Brennan is trying to say, hey. So the defense said you didn't know all this and didn't investigate it. And he is saying, or Brennan is trying to redirect him saying, but what is all the information you had that pointed towards Karen Read so that you weren't investigating other leads? And he just cannot tell you with any energy or vigor or confidence the things that pointed them in the direction of Karen Read. And it's like, I'm going to have to see my report. Sir, you're not confident on the evidence that pointed you in the direction of Karen Read? You remember what Jen McCabe said, but as to everybody else, you just don't know? Okay.
May I approach, Your Honor?
Yes.
He said, was it yesterday? No, not yesterday. Friday? That all the
After
evidence
looking at
pointed
the
in one
report, does that
direction.
refresh your memory at all?
But he can't
Yes, it
point to
does.
the evidence that pointed that
And
direction.
when you were learning information to shape your investigation, did you consider anything that Anthony Flamati told you?
Yes, we did.
Okay. And what did he tell you that the defendant told him that helped shape your investigation?
Objection.
I'm going to see counsel at sidebar for just a minute here on this one.
Oh boy. Oh boy. What factors in your investigation pointed you in a different direction? He's like, I don't know. I need to see my report. And there's our only fan and its friend, the only crack. I don't think that that's actually the only crack in the ceiling. It's just the only one we can see. If you want to know if the prosecution is also frustrated with this witness at this point, the answer is probably yes. Probably yes. The prosecution is also probably very annoyed.
In addition to trying to get or obtain information about statements of the defendant, was there physical evidence that was important?
Yes.
They moved on.
Was there any data evidence that any of the team from the Massachusetts State Police were you aware of them pursuing any data type evidence?
Yes, there was.
Was there some phones involved?
Yes, there were.
What phones did you understand or pursue that you thought might be helpful for your
I
investigation?
mean, do we have a date?
For one, Mr. O'Keefe's phone was a device that we were looking into. We also had seized the defendant's phone and we're attempting to access that device.
You didn't have it yet, though.
There was other digital information that we were seeking as well.
Like what?
Was the potential data from the defendant's Lexus important to the
I don't
team of
think they have that
investigators?
yet.
Extremely important.
And did any of your team or the team pursue that black box, so-called black box data?
Yes, we did.
When did you get it? You decided, or I'm sorry, theorized that Karen Read had hit John
You were
O'Keefe
asked whether
by the time you drove to Dighton.
interviewed or present for
When did you get the black box information on the car? Give me a date, I'll wait.
interviews of Nicole and Brian Albert?
Yes.
And after you spoke to them, including and considering all of the prior information you had, was there any evidence that John O'Keefe went into 34 Fairview Road on January 29, 2024?
There was not.
I'm sorry to everyone I just made yawn. I apologize.
Relative to the
I'm also yawny. It is
information
just slow.
that could be stored in the computer systems on a Lexus, do you know which troopers, or do you know if Trooper Garino was involved in any process regarding that?
Yes, I do know, and yes, he was involved in conducting that portion of the investigation.
He wasn't asked
As
about
part of the
it.
investigation, was it important or was it considered to look at John O'Keefe's phone to see if there was any specific or particular information on it that would be helpful?
Yes, it would be.
What were you looking for?
After you
What was
extracted
the
it?
team looking for on Mr. O'Keefe's phone?
Well, the all-encompassing data includes location of the device. It includes communication, the party's identity with whom an individual could possibly be communicating. In this case, Mr. O'Keefe, his text messages, phone calls, emails, other applications like Signal and WhatsApp could have been also in use.
How about voicemails?
Voicemails, yes.
Did you ever review or consider any of those things?
They were so top of mind for him that he forgot to mention them.
Just mentioned in your investigation?
Yes, I did.
Speaking of interviewing witnesses, did
Yes,
you,
voicemail.
along with
Yes,
Michael
yes,
Proctor,
voicemail. Oh, yes,
interview
voicemail.
Katie McLaughlin on January 30th, 2022?
Yes, I did.
Was this the very next day?
Yes, it is.
And as part of your investigation and the direction and scope of your investigation, did you consider the interview with her and what she might have told you?
Yes, it
And when
was.
you were speaking with her the very next day, is there any
Brennan is so over it. He's like, Brennan's questions have gotten so short. It's just, at some point, I'm waiting for the leading objection, but it's just yes or no. Just yes or no. Because even Brennan is tired of fighting with this witness right now, because Brennan is also fighting with this witness. And just for a refresher, not all yes-no questions are necessarily leading. You can have yes-no questions that aren't leading, and Brennan is going between the two, but Lord, he is so annoyed with this witness.
statements that she attributed to the defendant that you considered in the next days of your investigation?
Yes, there was.
Do you remember what she told you the defendant said that was part of your consideration for your future investigation?
Yes, I hit him, I hit him, I hit him.
Oh, that you remember.
Remember that the statement is not being offered for the truth of the statement, but simply to show that the information was provided for the statement.
Did the statement that Katie McLaughlin attributed
You're
to
gonna run out of water
the
there,
defendant
guy.
that very next day, January 30th, 2022,
You're gonna run right
did
out of water.
that shape your investigation at all?
It helps attribute to the investigation. Again, all the evidence, all the statements, all the digital, all the circumstantial, all of that information is coupled and then put together, capped off by the defendant's statements herself to form the case.
Good to see you in the chat, Amy. Amy was talking about being on a jury and saying that it was hard not to react, but her face is loud. And
There
we both
there were
have
questions
loud
about
faces.
a plow driver by the name of Brian Loughran. When did you first hear or learn of that name?
It was quite some time after
Oh, why was
the
that?
case had made its way through the court system.
When you learned of his name, did you attempt to speak to him?
Yes.
And before you spoke to him, were there any issues you identified relative to Mr. Loughran before you actually spoke to him?
In regards to him, no, I didn't know him. I've never met him.
Did you, in fact, speak to him and interview him?
Yes, I did.
Was that interview, did anybody attend that interview with you?
Yes.
It was asked whether
With
or not
who?
there was a car that was seen. And that was what type of car?
Ford Edge.
Was he specifically asked whether or not that was a Ford Edge owned by the Albert family?
In our interview?
Yes.
I don't remember specifically, but it is along the line of questions that would have been in my report and transcription of the audio recording.
Oh, there was an audio of that interview.
In one last interview, did you speak to Brian Albert Jr.? Or did you consider a report of his interview?
I saw a report and
Did you
considered.
attend that interview?
I did not know.
What did you understand his relevance to be in your investigation?
He was at the home, at his parents' home, when some of his relatives and parents' friends came back to 34 Fairview.
Because
And
he was
after
at the
you
home?
considered that interview, did it change your perspective or knowledge about whether anybody had suggested that John O'Keefe went into 34 Fairview Road that night?
No, it did not, no.
When I asked you questions earlier on in the case, days ago now,
Yup.
we went through a number of pieces of evidence that was found at different times at 34 Fairview Road. Remember those questions and going through that process?
I do remember, yes.
Same. Yeah, he's not
When
done.
we went
He's
through
not
that
done.
process, were there any items that I did not ask you about?
Yes, there were.
And the items I did not ask you about, were they retrieved or found on different dates?
Yes, they did. They were, yes.
And the items that I did not ask you about on those different dates, do you remember how many different dates other items were found?
I want to say 3 different dates.
And on those other items I didn't ask you about, who recovered those items of evidence from 34 Fairview Road?
Michael Proctor.
Were you with Michael Proctor on any of those 3 dates when he turned in or reported the recovery of other evidence at 34 Fairview Road?
I was not, no.
And do you understand whether anybody was with him on those 3 dates?
I'll allow that.
My understanding that nobody else was with him.
And I did not ask you about any of those pieces of evidence?
No, you did not, no.
On cross-examination, you were asked about those 3 pieces of evidence?
No, no.
Yes, I was.
3
Were
dates.
you shown what are now exhibits containing pictures and a photograph of the bags in which those items were bagged?
Yes, I was.
Do you have those physical pieces of evidence?
I do.
Now I'd like to ask you about those 3 pieces of evidence.
Interesting,
Was there
Brennan.
evidence produced from February 8th, 2022?
There was.
Who produced that evidence?
That was Michael Proctor who recovered it.
And you were not there that date when he recovered the items?
I was not, no.
I'd ask you to retrieve 7-13, the items that were found on February 8, 2022.
Yes, sir.
Do you have gloves?
I do.
So Proctor recovered these alone. Brennan waited to see if the defense was going to bring it up and show those items of evidence. And now the prosecution is going to seek to admit those. He hasn't asked how they were retrieved from evidence before they were brought to court, because he didn't ask how they were retrieved from evidence before they were brought to court. So I think he's going to try to admit these into evidence without calling Proctor. The defense hasn't objected yet. It's not outside the scope of cross because they brought it up squarely in cross to show all these bags. And if the defense doesn't, well, we'll see if the defense objects, but they came up all during
7-13.
No, I move to introduce this into evidence.
and the defense doesn't object to them coming in. Okay.
Exhibit 128.
I think that could have been more of a
Can
fight.
you describe what is
The
in that
defense didn't
bag?
make it a fight.
And if
There it
necessary, you
is.
should open it and show it to the jury.
Interesting. The defense didn't object to that. He said no objection.
The description is one large piece of plastic, red in color, one small piece of red plastic, and one piece of black plastic. I will open it to further show.
Okay. Angela asked, what's EDB's highest chat number? It was over 470,000, I think is our largest chat. Not for this trial. Emma asked, why would the defense object? Because the chain of custody is a shit show on these, and Proctor collected them. These were not collected by this trooper. He doesn't know exactly where they were collected from. I don't know how they were obtained out of the evidence locker or when they were put in. Nobody knows. But here they are. One piece of plastic. One piece of plastic. So, but on chat
This
numbers
one's
today,
labeled
we were upwards of 50,000 earlier today.
22-02-184-7-13 as the bag. And this is letter number, or a letter labeled A as an alpha.
Okay.
Could you again tell us the date that was recovered?
Interesting
This was
strategy
recovered on February
for
8th, 2022.
Brennan.
This appears to be a black piece of plastic, same identifying numbers, but this one is labeled with the letter B as in Bravo.
I was really wondering how they did that.
This small piece of red plastic is not labeled.
Shocking. Tracy said mine reads 48K. You beat your prior views. No, we were at 470,000 live concurrent. No, not 47,000. 400.
You mentioned this was on February 8, 2022.
I don't think we'll be close to that.
Earlier in, are you
Which
done
is
with that
okay.
package?
Yes.
Earlier in
Are
your
we done?
testimony,
I don't know.
you had
I don't think
shared
we're
that
gonna get
you
into the
went
hundreds of
back
thousands
to
on this
34
trial.
Fairview on February 10, 2022.
Yes, I did.
And on that date, you recovered pieces of taillight.
Yes, I did.
At that point, on February 10th, 2 days after that February 8th production, was there still any snow on the ground at 34 Fairview?
Yes, there was still
Were
snow on the
you
ground.
there?
Obviously not in the amount that was there the first day.
Were you
The
there?
second production from Mr. Proctor, do you know what date that was?
Don't hold me to it. I want to say the 11th of February.
Don't
And did you bring
guess.
7-14 and 7-15 with you?
Yes, I did.
Could you produce those, please?
Because he didn't cover them. Yeah, I think we might have, Ms. G said you had 500K one day in Deptford. Heard we might have gotten up to 500K live concurrent at one point during Deptford. It's just during this trial, we're going to be in the 50,000 range. It's commensurate with the interest level of this trial. But don't hold me to it.
Let's take one at a time, please.
7:14 and 7:15.
Let's start with 7-14. I'd like to move that into evidence, please.
No objection.
All right.
Thank you.
Regarding 7-14,
Look,
can
the
you
defense
show
knows
us
the
what
rule of
Mr. Proctor
rules of
found on
evidence
February 11th, 2022?
full well.
Yes, sir.
They are choosing not to fight on this point. It's probably not a fight worth having because the defense's Brennan is just flipping papers. The defense's fight isn't that these weren't found at 34 Fairview. The defense is saying they were found at 34 Fairview. But isn't that sus? They were only found by Proctor and then they weren't admitted into evidence well, and then this and this and that. The defense's argument is not that they weren't found, it's how they got there. So is this a point worth fighting on for the defense? Probably not, because they're going to argue that this is sus AF.
There appears to be a variety of wax, like stamp bags, as well as plastic containers. And this is consistent with having glass in it, as it was earlier.
Does the packaging, it seems different than the other bags?
It's marked from the
reason
lab.
you know of that the packaging is different?
It appears that these are small fragments of glass, so for safety reasons, it appears that they were placed into a hard containers to prevent injury or maybe possibly losing it.
Could you just hold up a few examples for the jury to see?
Yes. This one here is labeled 714 and then A. This here is B. This here is C. And then there's fragments in here.
You don't need to take them out, just describe them generally.
Don't
Small
squish them with your
pieces of
fingers.
what appears to be glass inside the wax paper.
With his hands, he's just like,
Can we bag all that? We'll move to the next item.
Yes, sir.
it appears. At least the lab photographed everything. Have we seen anyone testify from the lab? No. Are we going to see them testify from the lab? I don't know. Are they going to do the reconstruction they did last time with the
715?
taillight casing reconstructed?
Please,
I don't know.
move 7-15 into evidence.
Mr. Jackson?
No objection.
Were
For all of you asking,
7-14
why are they
and
doing
7-15
these?
Two separate bags, both found
These are being moved
On-
into evidence
February 11, 2022?
from February 11th
I can confirm that as soon as I
from
come back at the
Proctor.
bag.
From Proctor recovering them from 34 Fairview.
Yes, February 11th.
If you could open that and show the jury.
Yes, sir.
Yeah, this witness isn't going to be done today. This witness isn't going to be done today. We're going to have to do another at least morning with Trooper B. For those of you asking, why didn't they do this in direct? Well, they don't really have foundation to do it, and the defense got into it on cross. And here we are. And Brennan was like,
This item is
"No,
labeled
let's go for it.
with the same limbs number, 715, and the letter A.
So that's a That's not an insignificant piece of plastic recovered on February 11th.
And the letter A.
A big piece of plastic.
This is 2 pieces of clear plastic that are taped together. The longer one here on the left is labeled H, and the one on the right is labeled F, if my eyes are not failing me.
I mean, that's kind of fair.
This is a canister labeled debris collection
Please don't shake it. Please don't shake it. Please don't
with the
shake
same
it. Thank you.
numerical identifiers.
When would you use a canister as opposed
Elizabeth
to
Mee said,
putting
is
it
this
in a
person
bag
going to
or a
finish this
plastic
week?
bag?
Oh,
Is there
yes.
a reason it's in a canister?
They'll be done. They've got to be
I
done
do not know the
tomorrow.
reason behind it. I would strictly be speculating.
Thank you.
This small red piece of plastic is labeled E as in echo.
But no, there's a lot of witnesses the Commonwealth needs to get to.
There are more small pieces of that, similar to that size that I just showed, but
Very well. If you can rebag that.
Oi. It's just all rattling around in there.
You mentioned there was 3 different days where Mr. Proctor found pieces of taillight at 34 Fairview. I'd like to go to that last day.
that would be the 18th, I believe, of February.
And do you have a bag?
I do.
Could you produce it, please?
Do you have a bag? We have a bag.
It's 7-16.
Yes, it is.
Do you have it?
I do.
I'd like to move that into evidence, please.
No objection, Your Honor.
So the evidence that Proctor has the foundation for is coming in with this witness without objection from the defense. And it gives the Commonwealth room to choose whether or not they call Proctor, which after these are in, it might be a no-win, but it is a real bad look if they do not call Proctor, I think.
If you could open it, please, for the
They
jury.
may disagree.
Yes, sir.
I mean, it opens up a giant can of worms, but that can of worms exists. It exists. So I don't know if you can get around it. The jury's aware there's a can of worms there. Big piece of taillight.
This one's labeled B.
And these were shown during cross. So I'm not surprised the defense didn't object because they showed all these during cross. Look
Here
at what
we
Proctor
have
found.
3 red taillight pieces taped together. Appears to be mechanically fitting, labeled A, C, and D.
Do you typically label items?
No.
Not
Do you
like
know
that.
where those labels and the taping come from?
I believe that's from the crime lab. They identify each item according to their protocols to help them facilitate their portion of the investigation.
Okay.
Small clear piece of plastic labeled E as in echo. Small piece of clear plastic labeled G as in golf. And another tin canister labeled piece of plastic.
Thank you.
Yes, sir.
You earlier mentioned that the tow truck brought the defendant's Lexus to the Canton Sallyport. Do you know if there's a video depicting that arrival?
Yes, there is.
With the court's permission, I would like to.
Are we
play a
gonna see that?
portion of Exhibit 127.
All right. Seems like all the recovered pieces of taillight are in evidence now. It's definitely more snow at this point. We are now at 5:33 on January 29th, 2022. You can see the tow truck coming into frame quickly. And a truck following it. And a SUV, looks like a law enforcement SUV following that.
Have you seen that video before?
Yes, I have.
What does it depict?
It depicts a tow truck from Diamond Towing arriving at Canton Police Department, followed by my personal pickup truck that we're following the vehicle in.
That video, that's before the video of being in the Sallyport?
Yes, it is.
When you were considering the physical pieces of evidence as part of your investigation, were you considering the weather conditions that night?
Yes.
When you were evaluating pieces of physical evidence that were found at 34 Fairview, were you making any assessment about their location or depth or closeness to the ground when you were evaluating them?
Yes.
And why were you considering the closeness of items to the ground?
Well, common sense will dictate that if a item is found on the grass and there's snow covering it, that it would have to have been placed prior to the snow accumulating. If an item is shoved into the snow, it will be exposed as the snow melts prior to it reaching the ground level.
I'm going to ask you
Interesting words.
to, with the court's assistant, retrieve Exhibit 85. May I approach?
Yes.
It was not a good question on Brennan's part. The answer was very interesting, but it was not a good. It was not a good question on Brennan's part. Those are questions for cert, not for this witness.
You have some questions while we wait?
I can.
I don't know what they're trying to pull up.
When you retrieve pieces of taillight on February 3rd, did you consider their location, not only where on the lawn they were, but about the depth of where they were found?
Yes, I did.
And based on the items that you found on February 3rd, how close to the ground were they?
They were on the ground, or in the instance with the hat, it was frozen almost in a solid piece to the grass blades, to the ground.
And was that significant to you, how the hat was found?
Yes, it was.
I could have 99 feet. And could we now have 99D? Beneath the hat on the left side next to the ruler, what do you see?
Yellow grass and a leaf, I believe, a brown leaf.
Was that of importance to you?
Yes, it was.
I may approach, Your Honor.
Yes.
And if you could turn the lights on and take that down, please. Thank you, sir.
They did have pictures from that day. I think that was the only day they had
85.
a lot of pictures of from February 3rd.
Could you take the item out of your bag, please, sir?
Yes, sir.
I think they already did this. We're going to do it again. Those are the victim's jeans? Why?
Can you look at the back of the pants, please?
Oh, because the internet has questions.
As part of your investigation and the significance of the evidence, did you consider any debris on the back of the pants as part of your analysis?
Unlikely.
Yes, the grass stains on the left.
Objection.
The appearance of the
Go ahead, I'm sorry.
the appearance of the staining that's taken place or had taken place on these jeans was significant in the fact that it appears to be green and grass stain.
What did that suggest to you as part of your evaluation of your investigation and the decisions that you made after?
It suggests that Mr. O'Keefe impacted the grass area with his left
Frozen grass?
glute, transferring green staining onto his pants.
Why is the pocket ripped?
Are you or do you know from your investigation the amount of snow that was on the ground at about 12:32:09 to 12:32:12 on January 29th of 2022?
Yes, based on my investigation and review of video from surveillance footage, it appears to be very little to a coating of snow in some areas.
You could repackage that for us, please?
Yes, sir.
Mr. O'Keefe's pants?
We're not going to talk about the pocket? I guess not. I guess we're not going to talk about the pocket. Yes, it's a cat track of snow at that time of day, but I guess we're not going to talk about the pocket. I mean, I have questions.
I have just a few final questions for you, Trooper Bukhenik.
Oh,
Yes,
do you
sir.
promise?
You were asked questions about interviewing Brian Higgins,
Yes.
and you shared with us that he provided you a number of text messages between him and the defendant.
Yes.
You began to explain that you vet information during your investigation.
Yes, we do.
What did you tell him you were going to do with the messages he was giving you?
I explained to Mr. Higgins that we have in our custody and will eventually get into both the defendant's phone and Mr. O'Keefe's phone so that protect his integrity as a law enforcement official. I told him that the information he was providing better be true and accurate or else he would suffer the consequences of the ulterior.
I told him, I'm surprised that they didn't get into this more on cross. I think the defense was going to keep it and argue it. I told Higgins that if you are giving us texts, that we are going to have the other side of those conversations. So you better be sure that they're going to match. It's the wildest thing that Brennan is asking this question again. It's what the answer was so bad the first time, and then Jackson didn't follow up on it. Why are we following up on this again? Does Brennan think this is a good look? He can't. Brennan, you can't. You can't think that this is a normal answer. We told Higgins, protect your integrity, bruh. Give us the text messages and make sure they're going to match.
Our custody and will eventually.
I need to play that again.
Information during your investigation. You began to explain that you vet information during your investigation.
Yes, we do.
What did you tell him you were going to do with the messages he was giving you?
I explained to Mr. Higgins that we have in our custody and will eventually get into both the defendant's phone and Mr. O'Keefe's phone, so that protect his integrity as a law enforcement official. I told him that the information he was providing better be true and accurate, or else he would suffer the consequences of the ulterior.
Did you, in fact, vet what he gave you?
Yes.
Better be true and accurate.
Before you vetted it, did he make any changes, additions, or subtractions from that information?
No, he did not.
Or suffer
When
the
you vetted that information,
consequences.
was there anything different from the alternative source, that being the defendant's phone, from his phone?
Not that I noticed, no.
You know, that exhibit or that document has been marked for identification. I'd like to introduce it as an exhibit.
Highlighting that is not a serve. Protect his integrity. Because here's how it sounds to me. And maybe I've been watching this investigation too long and I've seen the first trial and maybe it comes across as different to me. It may well just come across different to me because of what I know about this case. So this may come across completely different to the jury, and I just can't distance myself from it when we're talking about this, because it sounds to me like, hey, Higgins, we are going to be able to verify everything you provide us. So big heads up, big heads up. If you're going to provide anything, know that we're going to have the other side of all those conversations. So you need to ensure that whatever you provide to us, because we're going to let you do it on your own. We're not going to extract your phone. We're going to let you provide it to us. Whatever you choose to give us, better match, because we have it on different sides. Now, when it comes to Canton PD video, I don't think anyone thought that still existed. So when Higgins testified the last trial, and if he testifies again, when Higgins testified the last trial, I don't think he knew that Canton PD video still existed. I think, in fact, Higgins was probably confident that there was no video of him at Canton PD at all. I bet it was a big old shock to Higgins that there's, in fact, video. I think he is stunned. But it sounds to me like it was a heads up, big guy. We're not going to extract your phone. Do you a solid. But if you fuck this up, we're going to have to get your phone and everything else. So, be forewarned. That's how it sounds to me. It sounds like a heads up. I don't know how the prosecution thinks that that's coming across differently. Higgins, have integrity or suffer the consequences when you voluntarily give us your phone. Why does the prosecutor think this is a good answer? Because it seems like, hey, if you fuck this up, you're totally fucked. Just so you know. I don't see how Brennan looks at that through a different lens. I just don't. Does Brennan think that this shows that they all made sure that there was integrity in the text message? Because the text messages, I don't think, are the issue in this question. The text messages in this question aren't the issue. The issue for me is that you allowed him to just give you a snippet of what he wanted to give you. Like, that's the real issue. Not whether the texts all match and whether he's got zero riz. Like, that's not the issue. For the defense, the issue is going to be, right. Y'all were just like, hey, Higgy, don't fuck it up. But if you just give us some texts, we're not going to get the rest of your phone. Can you just do us a favor and just make sure that we can just say that you were cooperative? Good. Thanks, buddy. We know you're cooperative. But isn't that the argument of the defense, that they didn't investigate? They were like, hey, buddy, just give us your text. It's fine. Just make sure that that they square, because we're going to be able to verify them from the other sides of other phones. So, heads up. The fact that the prosecution thought that doing this answer again was a win is fucking baffling. He got another bottle of water, though. Just fucking baffling. Why in the world would Brennan ask that again?
I'll need to look. I don't know the number offhand.
I think the clerks might have it.
It's marked for identification.
No, it's actually marked.
And if I'm the defense,
Oh, was
I'm
it?
probably not following
I
up
didn't
on it
realize
again.
This has been introduced.
I'm tucking that little nugget away to argue it. It's going to become pocket tots, and it's going to come back out at closing to be like, remember that they gave Higgins the heads up. Hey, we'll be able to verify these. Make sure that you don't suffer the consequences.
As part of your investigation,
That
did you
just-
look.
You just put it in closing. Leave it alone, which is really hard as an attorney. It's like chumming the water for sharks. Leaving it alone is hard, but you leave it alone and bring it up on closing. They told Higgins, you better make sure that they square or you're going to suffer the consequences. Wink. Don't let him explain it.
To see if there was any animus or difficulty between Mr. Higgins and Mr. O'Keefe.
So wild that
prior
that's
to
the
Mr.
choice.
O'Keefe's death.
Yes.
Did you look at text message records to see if there was any motive that was evidenced in those text messages for Mr. Higgins to want to murder Mr. O'Keefe?
I did look.
May I approach?
Yes.
The defense is going right after the third-party culprit defense, or the prosecution's going right after the third-party culprit defense with this?
I handed you a document. Do you recognize that package of materials?
Yes, I do.
And what is it?
It's the extraction printed out from Brian Higgins' phone, dated 2/3, meaning February 3rd, 2022. And it is a conversation between the defendant and Mr. Higgins.
Does it extend a number of different dates?
Yes, it does.
Did you look through those conversations or text messages to
What's that have to
identify
do with
whether
John
there was
O'Keefe?
any animus or motive?
What?
Yes, I did.
I move to introduce those documents as the next exhibit.
No objection, Your Honor.
What are you
Did
text
you find any?
Hold on.
between the defendant and Higgins from February 3rd forward?
Trooper Bukhenik, did you find any evidence in the conversation?
Hold on, I'm sorry.
What about January?
Okay, thank you. Sorry, go ahead.
My apologies.
No, that's okay. So-
Trooper Bukhenik, when you studied the materials, the conversation,
10 out of
communication
10.
between Brian Higgins and John O'Keefe, did you find any evidence shaping your investigation that there was a motive to harm, hurt, or murder Mr. O'Keefe by Mr. Higgins?
No, there was not.
Well, recross will be interesting.
I have no further questions at this time.
Thank you, Your Honor.
Oh, boy. Recross. Well, today's gotten real interesting at the end here. For all of you that were like, this redirect's boring, then it just goes whoop.
You were just asked about Brian Higgins and your interview with Brian Higgins. Where did that take place?
The defense is like, so you say motive, do you? Let's talk about that.
In Sharon at an attorney's office.
At his lawyer's house, correct?
Oh, this just gets better and better. Oh, starting spicy on recross.
Where did that take place?
Oh boy.
In Sharon at an attorney's office.
At his lawyer's house, correct?
I'm not sure if he resides there, but it was an office.
With his lawyer present, correct?
Yes.
Did you find that unusual?
Objection.
Sustained.
He wasn't under arrest, correct?
No.
You hadn't read him his rights.
I don't know. This can go both ways, arguing, isn't it suspicious somebody got a lawyer? I would tread carefully because normally the defense attorneys are arguing, hey, just because somebody gets a lawyer doesn't mean it's suspicious. So starting to argue, hey, just because he has an attorney, isn't it suspicious? Is tenuous ground. It's tenuous ground.
No need to know.
No need to, because he wasn't in custody, right?
Correct.
He was just a witness in a case that you're investigating.
That's correct.
But he asked that you interview him in his lawyer's presence, correct?
Yes.
Look at him answering
You were
just
asked about
directly without any fluffer,
any evidence
nutter,
of-
or whatever.
Brian Higgins having a motive to murder John O'Keefe just a few minutes ago by Mr. Brennan, right?
Yes.
I mean, seconds ago.
And you said, no, I didn't find a motive that Brian Higgins would want to murder John O'Keefe. Is that right?
That's right.
What about a motive to confront him? About a girl he was interested in. Did you see that?
I believe the text messages speak for themselves. Everybody heard me read them out loud.
Yep, the text messages do, but I'm asking you. You were just asked about your opinion, whether or not there was a motive that you found for Brian Higgins to want to murder John O'Keefe. I'm asking you a different question. Did you, in your mind,
Brennan
in your
walked this
opinion,
witness right
after
into
having read
this.
those texts, find a motive for Brian Higgins to perhaps want to confront John O'Keefe because of jealousy?
If you're asking for my opinion is that he would need to confront Mr. O'Keefe. Mr. O'Keefe was not the one pursuing Mr. Higgins. It was your client that was pursuing Mr. Higgins.
Okay, so, well...
Unless, perhaps, because you said on Cross like 700 days ago that John O'Keefe and Higgins were buddies. So unless John O'Keefe wasn't pursuing him, but do you know that John O'Keefe didn't say to him, yo, fucker, why are you texting back? I thought we were friends. WTF? You said that they were friends. So from the perspective of Higgins, in continuing to engage in the texting, if that's your friend, is kind of fucked. Like, hey, if she's texting you, why don't you either stop texting her or tell me? Oh, I know, because you were interested in seeing if maybe, just maybe, you could bang. And I think that maybe Karen Read led him in the direction of maybe he had a chance. And instead of saying, that's my buddy, even if there is a chance, I'm not DTF on the chance. He didn't. He was like, I mean, I might could. So I'm not going to cut off those texts. She says things aren't good. Hey, T. So I got a question for you. The cats are probably watching the birds, but I got a question. I got a question for you. As we're going to take a pause from trial. I got a question. People are dating. Girl starts texting the guy she's dating friend and starts hitting on him. We together with that?
Yes.
What is the friend supposed to do in that situation?
Tell the dude and tell her to knock it off.
One would think, but what if she says, but we might be breaking up and things aren't really as good as they seem? You talk to your homie first. And then you say, look, if you guys break up, hit me back later. Or not at all. Because you got a man.
Bro code.
You just don't engaged.
Precisely. That's just weird. You know?
It's just weird. Thanks, T. I appreciate it. If everything could just be this simple with a bunch of 40-year-olds. Thanks, kid. Appreciate it. So the 17-year-old calls foul. The 17-year-old is like, You just tell your dude. Like, that's it. That's all. All right. Back to court. Travis's opinion, that's just weird. And now he's off to go find his cat, which is exactly what he's doing now that he's home from school. All right. Let's get back to redirect. I mean, it just.
Front, Mr. O'Keefe. Mr. O'Keefe was not the one pursuing Mr. Higgins. It was your client that was pursuing Mr. Higgins.
Okay, so, well, text messages, like you said, speak for themselves. You'll agree that showed that there was a mutual interest, right? It just wasn't one-sided.
At times there was
Oh, come
flattering.
on. Stop it. Higgins thought he didn't have a chance. Reed reached out to him and was like, you're hot. And he's like, nuh-uh. No, you don't really think so. And instead of going to John and be like, hey, your chick's going to start some drama, just a heads up, because I like and respect you. I don't know what's going on with y'all, but like, I don't want anything to do with it. Instead, he was like, really? You think I'm hot? I think you're hot. I mean, I thought you were hot from the moment I saw you. He didn't think he had a chance. And then she said, you're hot. And he said, I've always thought you were hot. So he's like, I feel like we're from the same neighborhood. It'll be fine. Right. So was there interest on Higgins' part? Interest plus disbelief. Higgins is like, I don't think I have a chance, but maybe I have a chance if she's like pissed at John. Like, I'll take it. Now, when he testified last trial, he was like, I didn't want to cause drama. That's why I kept asking her what she wanted. But he was like, but if she breaks up, I'm here. I'm here. Me and my Cape House are a nice place to land. We're ready. If you need that rebound, I got you with some Smirnoff on the Cape and maybe a mudslide. Like, let's go. Come on. Don't pretend that those texts don't give exactly that. Detective or sergeant or whatever.
Text messages from both sides. But your client reached out to him first.
Right. I mean, somebody's got to reach out, right? Everybody's got to reach out to somebody.
Hands.
First, someone's got to do it first, right?
Touching hands.
It depends.
Doesn't mean that there's not mutual affection for one another.
Reaching
Is that right?
out.
Or at least perceived mutual affection.
Touching me.
I don't understand the question.
Did you see in those text messages, in your mind, a motive that might lead to jealousy on the part of Brian Higgins?
No, I think Brian Higgins was pretty clear in his request for explanation of what the defendant wanted out of this, and stated that he's friends with Mr. O'Keefe.
Such good friends that he's like, come on, though. Come on. Such good friends that he didn't tell John O'Keefe. He's such good friends that he was like, she says we're not married and we're adults, so I'm here for it. Come on.
He wanted clarity from the defendant about what was going on.
Actually, sorry, go ahead.
I didn't read it to be that he was jealous as I sit here thinking back on the content.
What about after drinking Jameson and ginger all night long and sending a text that said, well?
Objection.
Might that change things?
I mean, I'm not mad at Jameson and Ginger. Nobody should have been driving.
I don't know what Mr. Higgins' state of mind was. Well, could mean many different things. They could have had a face-to-face interaction, a look. We'd be strictly speculating what was intended by that.
I mean, they weren't strangers in a smoky room.
The intent of communication by that text message.
After weeks of communicating with Ms. Reed,
he speculated just fine. You speculated just fine that Higgins was maybe not interested. But now when we get to, well, he's like, no, I can't speculate about that. I can't speculate about that one.
and then seeing him walk in the door with John O'Keefe and sending the text message, well, after having been intoxicated, you see that detective as an investigator, as a reasonable, objective investigator, as a possible scenario for Brian Higgins to be jealous about John O'Keefe.
There's a possibility there, but I didn't see it.
Did you explore that possibility?
Right.
When you got all these text messages?
We did not follow up on that
That's exactly
aspect
the
based
point.
on the totality of the entire investigation.
Did you pull the tape at the waterfall and review the tape as we did here in court?
That is the defense's entire argument, isn't it? There's a possibility there, but we did not follow up on it based on the totality of the evidence. Isn't that the defense's argument? There's a possibility there, but you didn't follow up. Ding, ding, ding.
That happened, yes.
Okay. Did you see on the tape a time just before Brian Higgins left the location where he was confronted by Chris Albert?
I think that's a good point to bring it back to that video.
Change the wording.
Sure. Did you see a circumstance, did you see a situation on that tape where Brian Higgins is standing and Chris Albert physically puts his hand
Because
on Brian
that
Higgins'
tape
arm?
looks different
Left
in
arm.
context, and I don't think we saw that part last
I
year.
don't have a specific memory of that.
You remember a circumstance on that tape where Brian Higgins pulled his arm away and looked past Chris Albert over toward the bar.
If he doesn't remember, play it
where
again.
John O'Keefe was standing.
Just run that back again.
Yeah.
I do remember you pointing that
play
out.
it again.
But we couldn't tell him who exactly he was looking at based on the video.
It's
You see a
Monday.
circumstance in
Let's
which
roll it
Brian
again.
Higgins then put his hand on his forehead and began rubbing his forehead like this.
I don't have a memory of that.
Did you see a circumstance in which he then motioned over
Play it
toward
again.
that side of the bar with his left hand?
That I remember, yes.
Did that seem realistic to you? Let me ask it a different way.
Possible.
Did that seem to you as a reasonable interpretation? Hey, come on outside. Or come here.
Very reasonable since they've been invited to 34 Fairview.
Did it look, in your opinion, that was just a hey, let's go together? Or did
He thought it was,
look
hey,
more
let's go to
like,
Fairview.
Hey, come outside.
No, he doesn't think it is a, hey, let's go outside that way.
The totality of the investigation, the fact that when they stepped outside, there was no confrontation and they were invited to the address. Again, totality of the investigation suggests otherwise.
Let's talk about that totality of the investigation. You're aware that Brian...
This, I think, looks worse than it did last trial because of the way that Lally put it in last trial. Last trial, Lally put in every single person that was at the waterfall. And I bemoaned it for days because it was where did you sit at the Canton basketball game and how many high tops were there? But we heard from both Kolakithises, who really aren't close with this friend group, that they said everything was jovial. Everyone was jovial. There was no yelling. There was no fighting. There was no fuss. Everyone seemed to be having fun. And you see Nick Kolakithis in plaid sitting there the whole time this is going on, but we don't have any of that testimony this time. And this investigator has not said once, everyone that was at the waterfall, including people not related to these parties, said that everyone was having a nice time. That testimony's not in at all. So the impression that's left is we don't know if anyone heard anything. We don't know if anyone saw discomfort. All we really heard was from Jen McCabe saying everything was fine at the waterfall. That's it. They don't have any other evidence in front of the jury that people testified that it was fine. So I think the jury can draw the impression that that video looks like either Higgins is saying, come on, let's go, we're going to 34 Fairview, or come on, let's go, motherfucker. And it leaves it to interpretation. And if there's two reasonable interpretations of a thing, you know where I'm going with that. So do I think that it can reasonably be perceived in the evidence that we have at this time, the way the defense is presenting it? I think there's an argument that it absolutely can. Absolutely can be interpreted that way. And they didn't follow up. And they didn't follow up. They see this video, they see those texts, and they don't follow up. And isn't that the point? We'll see if Brennan's going to call any witnesses from the waterfall. I don't think they're going to.
Higgins left first. He was the first to arrive at 34 Fairview, even before Brian Albert.
I am, yes.
And you're also aware that John O'Keefe and Karen Read were among the last to arrive. So they didn't step outside together, right?
They didn't step outside, but once he was invited, according to your narrative, wouldn't they have a discussion outside where he was invited to come out?
So, Mr. Jackson, I just want to ask you, how much longer do you think?
Not long.
No, he called Jen to find out where to go.
Probably 10 minutes.
Okay. Jurors are saying yes. Is it okay with all the jurors? We usually break at 4.
I don't want to overstep. I'm happy to stop now, but I think
The court's like, how much longer do you have left? And the jurors are all saying yes. Of course they are. The jurors are just like, yes, please. Can we get to the bottom of this? Yes. Yes. So the court's like, can we run overtime? Yes.
I'd like to finish with this witness and not have to bring him back again tomorrow. Thank you.
The jurors are all like, we're here. We're here. Let's finish. The court said, I'd like to finish with this witness so we don't have to bring this witness back tomorrow. And it sounds like the jurors were like,
you're aware that,
yes,
according to the
please.
tape, John O'Keefe left about 10 minutes after Brian Higgins, or so.
I'll take your word for it.
Okay. You would agree, as a homicide investigator, not every death starts off as an intended murder, correct?
I will agree to that.
Sometimes a fight could go wrong, and you intend to fight and duke it out. Something goes wrong, something goes south, someone dies, right?
Objection.
It's literally unintended homicide.
So, move along.
Yeah, that's like the whole realm of manslaughter cases. Just ask Sarah Boone. She gets real confused about that. Just ask her. It was unintentional. And there's a whole realm for unintentional homicides, ma'am. But she can contemplate that from prison. Let's resume.
It was
You were asked
unintended.
on redirect examination about taillight pieces that were found by the CERT team. I want to
really
ask you
wanted
real
to see
quick
that
about
waterfall
that.
video
Your
again.
testimony was you recall that the CERT team found a large piece of red taillight material during their initial search. Is that correct?
That's my recollection, yes.
Okay. Did the CERT, you had a debriefing with the CERT team, correct?
Not the CERT team. I had a debrief with the members of our unit at the Canton PD conference room. I do not have a memory of the CERT team being there.
Do you recall ever being told or informed
'Cause
that
Keith
the
was
CERT
there.
team actually recovered maybe
Keith was there both
5 or
places.
6 pieces, maybe 7 pieces of small plastic material in addition to the shoe? As opposed to a large piece of red taillight.
The memory that stands out to me that I have is that there was a large piece of plastic recovered. It wasn't a shard. It was significant enough that, shown on the photograph taken by Detective Lieutenant Tully.
And do you recall that the CERT team, or were you ever informed that the CERT team found those, according to the CERT team, within inches of one another, within about a 2-foot square radius?
I don't have a memory of where they found them exactly. I wasn't there.
Okay. You were asked about the taillight. You were shown a photograph of the taillight, where almost the entirety of that lens material is missing, gone, correct?
Yes.
And you remember talking to Jenny McCabe, originally interviewing her within days of this incident happening. Correct?
Same day. Interviewed her
It
same
was
day.
the 29th we
As a matter
interviewed.
of fact, the day.
That day, yes.
The day.
Do you remember her saying that the taillight was cracked/broken?
She communicated that over the phone to Michael Proctor, which was then documented later on in the interview report,
Okay.
From
In that
earlier.
I'm sorry, go ahead.
and it was documented within the interview report.
Okay. And in that interview
She said to
report,
Proctor, who
does it
said to
say
me,
the entire lens cap of that taillight is gone, correct?
Correct. The report does not say that, no.
And she didn't describe that, did she?
I don't know what she described to Michael Proctor over the phone.
You pulled out a pair of jeans belonging to Mr. O'Keefe just a second ago.
I don't know what Jen McCabe said about the taillight to Michael Proctor over the phone, but in redirect examination, I told you that what Jen McCabe said is why we changed our mind when we were en route to Dighton. That's why we changed our mind. By we, do you mean that's why Proctor changed his mind?
Yes.
And you noted that on his, what would be his left rear pocket, there was a stain.
Yes.
You said that that was an apparent grass stain, and it was green.
Based on my observation here holding them, that's what it appeared, yes. Maybe dirt, maybe other substances.
That was my question. Did you seek to analyze what that discoloration was from? Or have caused that to be analyzed by the crime lab or anybody else?
The genes were processed. I don't know what their protocol is to analyze it. They process those genes. There's pieces missing from cuttings and stuff like
Understood. So as you sit here, you have no evidence at all that those are grass stains, correct?
that. Strictly my experience of knowing grass stains and observing it.
Could be dirt,
Could be.
could be oil or grease.
It would smell.
I don't know about that, but
They look brown. Stains look brown, doesn't it?
there's different parts of the stain. Some has brown, some has green, different parts of it.
Could you get, in your experience, stains on the back of pants from being dragged?
I've never dragged anybody, so from my experience, I can't tell you.
I didn't ask if you've ever dragged anybody. You've never murdered anybody either, but you're a homicide investigator. Right?
I mean, he's gotten dragged through days of cross-examination.
Did you get those stains from being dragged? It's just a common sense question.
My common sense dictates that it was not a drag, a mark, because it would have linear characterizations, and it would be both buttocks that are engaged in contact with the ground while being dragged.
Or if he was being dragged and he had something in his pocket, or being dragged at an angle. Being dragged through a crease spot that was only on the left. What about all those possibilities?
Again, my opinion, common sense dictates it was not the case.
But you certainly didn't take any action to investigate forensically what those stains actually were.
I mean, I guess he's not running Tough Mudders, I suppose.
I did not know.
By the way, can
Don't
you
you
lose
have
a
to-
shoe from being dragged?
Don't you have to grapple in the Marines?
It depends. I guess you can, depending on how loose it is.
You said that there was no information that you had regarding Brian Higgins and John O'Keefe having any animosity toward each other prior to January 29th, 2022, correct?
Correct.
But you did, now let's talk about on January 29th, 2022. In your experience, does drinking alcohol increase a likelihood or increase the possibility of getting into an altercation?
I would say, in my experience, in my opinion, the alcohol could become a social lubricant and exacerbate emotions. But to speak in a definitive form here, I can't.
You've heard of beer muscles. That's a common.
Don't you work in Boston? I just have a few questions about that.
Speak in a definitive form here, I can't.
You've heard of beer muscles. That's a common phrase, right?
Never heard that before, no.
Beer
Beer
goggles.
guts. You ever heard that one?
I've heard of beer gut, but not beer guts.
Having the guts to walk up to someone you might not otherwise walk up to in a bar because you had too much to drink. Is that what beer
Like
muscles
beer goggles?
mean?
I would say maybe liquid courage,
Even better. What does liquid courage mean?
giving you courage that truly shouldn't be there.
There's the
That you
chat.
might not otherwise have.
A lot of you said
you
liquid
weren't
courage before he did.
Yeah. Yes.
Can we wrap this up, Mr. Johnson?
I'm trying, Judge. I won't be much longer.
I'm trying, Your Honor. I really want to finish him today, but I don't. I really want to just finish him. But we might not get to the end of this today. Let's see. I mean,
You
he
had
walked
evidence
right into the
that
liquid
Brian Higgins
courage.
had been drinking most of the afternoon and evening or most of the night, that evening and night, at the time that John O'Keefe and Karen Read walked into the waterfall, correct?
I had information that Brian Higgins had returned from a police officer's funeral and then went to Waterfall after he changed clothes and took a shower.
Went to the hillside before he went to Waterfall and started drinking there, correct?
I don't have an independent memory of that, no.
But you did, at the time, you didn't pull the tape at Gesundheit. At the time, you didn't pull the tape at CPD that we saw with Brian Higgins on the phone at 1:30 in the morning, correct? You didn't have that information.
I'm sorry, can you
At the time-
give me a reference when at the
Sure.
time?
At the beginning of your investigation, January 29th and probably the next, let's call it a couple months.
Mm-hmm.
You did not have that information, correct?
No, we did not.
And you didn't seek that information from CPD at that time.
No, I had no information that he went there.
Okay?
What?
And you didn't extract his phone, correct?
That's correct.
And finally, you indicated that you were asked on redirect examination, did you have any evidence that John actually went into the home? Did you ever interview Trooper Guarino during the course of your investigation at any time?
Interview him?
Talk to
No.
him about his extraction of John O'Keefe's phone and any of the data that came off of his phone.
No.
You did not realize that Trooper Guarino had information that John O'Keefe took 36 steps covering a distance of some 84 feet that would have placed Mr. O'Keefe inside the residence at 12:32.
I think that misstates.
Objection.
Yeah, I think that misstates the
Did
evidence.
you have any information from Trooper Greeno about steps that were logged on Mr. O'Keefe's phone?
No, I did not.
Is that it, Mr. Jackson? You said finally, that's what I'm wondering.
May I have
he's-
just a moment?
if he's not
I'm trying
done-
to wrap this up. I only have a couple more things, but I may be able to.
If he's not done today, he's not done today, and then it goes till tomorrow. They stayed overtime. You've got to let him finish his recross.
As you sit here now, are you aware of whether or not there's evidence that John O'Keefe, the phone describes John O'Keefe's phone taking 36 steps, covering a distance of about 84 feet at 12:32 and 16 seconds on the morning of January 29th, 2022?
Objection.
Can you answer that? Are you aware of that?
I am not, Your Honor.
So the answer is,
The answer was?
No, I'm not aware of that.
all right.
All right.
All right. Chairs, I appreciate you staying late, so Trooper Bukhenik, you do not have to return.
Thank you, Your Honor.
So,
Thank you.
folks, those same cautions, please do not.
No
discuss this case.
final
We don't
redirect.
do any independent
This
research
trooper is
or
done.
investigation into this case. If you happen to see, hear, or read anything. It's
Probably why Jackson didn't play the waterfall video again, because the court is not going to look friendly upon it. The court kept the judge. The judge kept the jury after their normal time to try to allow the defense to finish up their cross. Jackson said he had about 10 minutes. I think he went longer than that. And the court was like, we kept the jury for an extra 10 minutes. If Jackson had said, I'm not going to be finished with this today, then they would have just taken the day break and bring the witness back tomorrow. But he said he would be done, and the court was definitely going to hold him to it. So, especially with the jury being there overtime. So, he said he is done. Let's see if they go back on the record today at all. It looks like they do not. So, let me just take a look at the end and see. It doesn't look like they come back on the record at all at the end of the day, and that is the end of the court day. So, it looks like at the end of day 14, Sergeant Bukhenik is done with his testimony. It has been a number of days of Sergeant Bukhenik's testimony with a lot of information. And while Attorney Brennan, I think, really tried to do some damage control on redirect, I don't know how much damage was controlled. I think one of the stronger lines of questioning during redirect was, does Trooper Bukhenik know any of the people involved in this case? He doesn't. But is that going to be undermined if we get into testimony of everyone that Trooper Proctor knows? I don't know if it will help. I don't know if it'll help. And beyond all imagination to me, and I don't know if I'll be able to tell you tomorrow either, we saw Attorney Brennan ask Sergeant Bukhenik again what Brian Higgins was told when he gave over, I can't say extracted because it wasn't, when he gave over the text messages between himself and John O'Keefe and himself and Karen Read. And again, Sergeant Bukhenik said, in sum, I told him we had John O'Keefe's phone and we will have an extraction from Karen Read's phone. So to preserve your integrity as a police officer, they better match. I don't know how the Commonwealth thinks that that is a helpful answer, because I perceive that answer as, hey, we're not going to extract your phone and we're not going to get into the rest of this, but if anything doesn't match in those text messages, it's going to be a problem. And Trooper Bukhenik said at the end of that answer, and he would suffer the consequences. Is that a helpful answer to the Commonwealth, or does it play right into the defense's theory that there were avenues of this investigation that weren't followed up on? Because I can see a world where the defense argues, see, they didn't even do a phone extraction of Brian Higgins. They just said, hey, give us those texts. And just know that we're going to have the other side of those conversations. So if anything looks wrong, well, then you're going to suffer the consequences. It's a wild thing that the Commonwealth elicited that answer again, thinking that it helped. And there were times when the Commonwealth was trying to give this sergeant room to explain all of the evidence that they considered in their investigation, and he kept needing his memory refreshed. So to rebut the defense's, hey, these are all the things that the investigation didn't look at, the prosecution on redirect was trying to get into the weight of the evidence pointed in one direction. I think that's a bit undermined when you are using the sergeant to go through it and he doesn't remember what the weight of the evidence is. He just kept saying the weight of the evidence. Okay, the weight of the evidence, what? The statements from Nuttall? Well, I need my report to look at the statements from Nuttall. Okay, what about the statements Karen Read made to the, other paramedic when she was being taken to the hospital? I would need to refresh my recollection from that report. What about your interview with Katie McLaughlin? No, I would need to refresh my recollection. So instead of being able to list out the totality of the evidence, he just said the totality of the evidence repeatedly. And I don't think he well explained all of the evidence that he knew that was leading them to believe that there were no other avenues for investigation. And I think the defense did a better job of pointing out all of the things that were there with Higgins. So you never extracted his phone. You didn't look at the video from the waterfall. You didn't look at his text with Karen Read to think that that might cause some kind of an issue between Higgins and John O'Keefe because Higgins is texting his girl. You didn't think that that might cause a problem or that Higgins might want to confront John O'Keefe. And he was like, well, no, John O'Keefe's not the one pursuing Higgins. I'm not even exaggerating. That was his answer. You didn't pull the video from Higgins walking around Canton PD that we saw quite thoroughly earlier today. And he said, no, I didn't know he went there. You didn't know that Higgins went to from 34 Fairview to Canton PD at 1:30 in the morning when he was, by all accounts, like a bottle of Jameson deep? That might be an exaggeration on my part. He had a lot to drink. Okay. And because Higgins has not testified yet, I think the defense made a lot of ground with, isn't it a reasonable interpretation that these things could have happened? And Sergeant Bukhenik agreed with the defense a number of times. Yes, I guess it could be interpreted that way. Yes, I could see how you could interpret it that way. Yeah, that's a reasonable interpretation of that. That's not how we saw it. But they didn't follow up that investigation. Even when Brennan tried to bring up better points during redirect. And then, surprise, surprise, the defense had brought up all of the pieces of Taillight that Trooper Proctor collected. And photos of them and photos of the bags. This name is Proctor. This is the handwriting that matches that other handwriting. He was by himself. And the prosecution moved those all into evidence without objection with Sergeant Bukhenik after the defense brought them up on cross. So now we have all of those pieces in evidence as well. So if the Commonwealth chooses not to call Proctor, they don't have to. Everything that Proctor collected at this point, at least all the pieces of taillights, are now in evidence. Though a long day with Sergeant Bukhenik on the stand, it seems to indicate that both sides are anticipating a world where the Commonwealth does not call Trooper Proctor. And at the end of the day, because I had a chance at the break to take a look at what was filed before court started today, the motions that I saw, and we're just going to go by title, we'll talk about these more tomorrow, is the Commonwealth's motion to preclude inadmissible hearsay under the guise of the Bowden defense. The defense got into a lot of hearsay with regard to Bowden defense, and then the Commonwealth was allowed to get into it too on their redirect into things that this trooper was told. The Bowden defense, again, being the defense that other avenues weren't investigated. And I think the defense has very much started to vet that out, that other avenues weren't investigated. Then we had a Commonwealth motion to introduce additional evidence of the nature of the defendant and victim's relationship. Quote, 4 weeks prior to the murder, the defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. So it seems that the Commonwealth has, as of this morning, made that motion to bring in the information from Aruba. Has the court ruled on that? No. Do I think it'll come in at this point? Yes. I think Aruba at this point will likely come in. And then we saw the defendant's opposition to the Commonwealth's motion to preclude inadmissible hearsay under the guise of the Bowden defense. And we saw a lot of objections from the defense about that today. I will take a look at those over the evening, but it looks like what went down in Aruba is going to come in after the cross-examination of Sergeant Bukhenik. And I think the court will allow it. Will it help the Commonwealth much? I don't know. The jury has to be sitting there wondering how in the world John O'Keefe was killed at this point. But the impression that was left, or at least one of the impressions that was left, was from the text between Karen Read and Brian Higgins, that Karen Read believed that John O'Keefe cheated on her. And I think the Commonwealth wants to present what they might see as the other side of that, which is this was a overreaction to a more innocent situation. I think that's why the Commonwealth would want to bring this in. So saying, hey, in the text messages, she is stating that they hooked up, though in some of those text messages, Karen Read does say that John O'Keefe was absolutely, what did she say? Puddled, but absolutely hammered. So she doesn't think they actually hooked up, but she still thought that they had hooked up. So I think we're going to see that testimony come in part to show the Commonwealth's side of those text messages. So it looks like we're going to get into Aruba, maybe the other Kokomo. Maybe not Kokomo, Indiana. Maybe the other Kokomo. I'm just teasing at this point. I think Aruba is going to come up because they did talk about New Year's. Will it be a nothing burger for the Commonwealth? I think the Commonwealth runs the risk of focusing on all these side avenues before they show the jury what happened to John O'Keefe. Because now we're running down who perceived what and when. And Karen thought that he cheated. And did he not? Was it a big reaction? Was it not a big reaction? Was everybody drinking? Yes. Does it help? And do they need to run down that avenue to show that Karen Read had a large reaction to John in Aruba during New Year's? I don't know. I think it's already in evidence. And again, they've heard her voicemails. So I think there's an argument that she had a very big reaction to him on New Year's and everybody was still alive. So did she blow up at him? Yeah. Did she blow up at him over voicemail? Yeah. Does that prove that John O'Keefe was hit by a car? No. It proves that that's consistent behavior. Okay. So if it's consistent behavior, is it out of the norm for them? Probably not. They were drinking and then they got upset and there was yelling. Does that seem consistent from what we've seen? I think so. Will the jury see that big reaction as like one big reaction too many? I don't know, because I think the jury's going to really want to know what the coroner has to say about how John O'Keefe died before they make a decision based on voicemails. Because I imagine that the jurors are going to sit there being like, okay, so where's the rest of it though? I want to see the rest of it. How did this happen? And then they might have more context for everything else. But right now they're being given context that they have not a lot of framing for because they don't know what happened to John O'Keefe and how. So will leaving the scientific experts to the end be a problem? It might. We're going to have to see. I hope that we see that soon. We'll see what day 15 brings when we go back to court tomorrow, which means it's the perfect time for me to remind you to get the Law Nerd app so that you know when things happen in court. And I've seen many of you in the chat say that you are very tired of Brennan's questioning. I get it. His questioning is much more direct and succinct than last trial, but we keep you up to date in the app when we changed across and when things move from one way to the other. So we will see what happens. But the jury now has seen, the jury now has seen as of today, the Sallyport video of Karen Read's car arriving at Canton PD, Karen Read's car in the Sallyport, both inverted and non-inverted or mirrored and non-mirrored with timestamps. They saw that horribly janky, unwell camera that you can barely see anything on. And I don't think they ever played it again when they were trying to get it to play. I don't think they ever got back to it. We saw all of the very clear cameras that show presumably Brian Higgins getting out of his own SUV and walking around Canton PD. I don't think there's much of an argument that it's not Brian Higgins. But that video's so much clearer. One of the cameras outside the Sallyport wasn't, but the other ones were very clear. And yeah, so we finally have the Sallyport video after 14 days. Let's see how many days till we get to a cause of death. I'm curious. Let's get to a few questions, and then, are you tired? I'm tired. Are we tired? Just like, I want to see what they extracted from Karen Read's SUV. I want to see what the accident reconstructionists say. I want to see the medical evidence. And we are in the drama of all of these adults drinking way too much and not communicating well with each other. Like, we're just sucked into the drama of it. I want to see the facts. We have a lot of fuckery right now. We do not have a lot of just solid facts. We do have some video with timestamp, so I guess that's something. I mean, there's times I'm just like here for the fuckery. And then we got into it and I was like, oh, fuck, that's right. This was exhausting. And everybody was catching strays for everything. Ugh, and then no one asked about the pants pocket. Damn it. Just so many questions. And it is not great to leave that many questions in the jury's mind, because you really want to know this. Just chat, let me know if you're where I'm at, if I'm overreaching. Going into day 15 on week 3, don't you anticipate week 3 of testimony? Don't you anticipate that the jury knows how the victim died in a murder case? Like, it was my preference that the jury learned how the victim died early on, even if we didn't get to the coroner later. Like, they understood the mechanism of death, and then we went back to all the context. Because it seems to me, if you are asking them to understand all the puzzle pieces in a murder case, you need to know how the murder happened and then bring in the other information. So you need the foundation, but but we're not there. And I did a lot of vehicular related cases. And there are still ways to bring in the vehicular related information early on and then give the rest of the context. But, I'm just a girl. What do I know? It's just frustrating. Crocker and everyone who gifted memberships, thank you for the gifted memberships. I saw a number of you in the chat asking and having a conversation if the jury can ask questions. The jury in Massachusetts does not ask questions. I practiced in a jurisdiction where the jurors didn't ask questions, but now that I've seen trials in a few jurisdictions where the jurors can ask questions, I don't know. I'm still kind of mixed on it, but I like that the jurors can ask questions. I just wonder if the jurors get frustrated when their questions don't get asked because there are rules of evidence. And so the jurors might ask questions that they can't get asked or that can't get asked of the witness. And then I just wonder if the jurors are just like, but I wanted this question answered and you didn't answer it. Or if they understand, hey, some questions won't get asked and they appreciate that they can even ask at all. I think that it helps. You also get a little peek into what the jury's thinking when they ask questions. You're like, ooh, interesting. Majo S asked, who is in charge of the order of the witnesses and all that? The Commonwealth. The prosecution gets to choose. Excuse me. But they're told. Amy Van Dyken in the chat said, let's see if I can grab it real quick. The chat is jumping. EDB on the trial I was part of, we could ask and are told they may not be answered, which is consistent with what we just saw in the Vallow case in Arizona. And that doesn't surprise me. I think jurors prefer the option knowing that they might not get a question answered versus not having the option. But the jurors are allowed to take notes if they want to. Some people take notes more than others. So we'll see. Sue said, does anyone wonder if anyone in the case watches this feed and commentary? They shouldn't until the case is over or until they are excused because there's a sequestration order. So they shouldn't. But in other cases, I know that after testimony, witnesses have watched my coverage of their testimony because they've told me. Music to My Soul says, I don't know how going into the Aruba events proves how John died. It doesn't. It's going to prove Karen's reaction. I think it will make the jurors think they are just trying to make Karen look bad. It could. It could. Or it could go, it could. It could go both ways. Is there video of the troopers questioning Karen? Sabrina, I appreciate your optimism. I really do. Yeah, that's a big negative, good buddy. Nope, not even audio. And in other cases, in the Corey Richens case, they were like, we didn't have body cam on the uniform. So they busted out the work cell phone and just put it on a voice note and recorded. Okay. Jurors, the tea is piping hot. Please finish. I think the jurors were done with the round and round. Also, I think the jurors get it. The defense made good points about the video at the waterfall. And because there's no witnesses from the waterfall saying, yeah, everything was fine, everybody was jovial, everybody was joking and having fun, the jurors are like, wow, the fuck happened at the waterfall? So let's see. I love everybody. You guys filling in the rest of the song lyrics have been fantastic. Denise, thank you. Love your commentary and snarkiness. Look, there's plenty of places to watch the trial just play out in real time without commentary and toxic chats, or snark, music lyrics, movie references, and the best chat on the internet. I think the choice is clear, but y'all make it the best place to watch trials on the internet, and I appreciate it. But I also get that some are like, girl, you keep talking. That's what I do. That's what I do. That's what I do. Yellow Pill, I will take a look when we get to the end of this case. I am not going to reference back to, right now, I'm not going to reference back to trial one because I'll start getting confused about what this trial knows. It's what this jury knows now. I am trying to keep parsed what this jury knows now versus what we knew from the first trial, but I will when we get to the end. Kokomo here, was it Hacienda? It might have been Photo Lady. I need to ask, I need to cross-check with the other family members because I have no memory at all. I should have taken a photo. It was so good. Musical161 said, question, law enforcement will only come to your house to arrest you or to let someone know, or to let you know someone has been injured or passed, correct? No. There's many reasons law enforcement can come to someone's house. They are not constrained. They can come and do interviews if people aren't getting arrested. They can come and ask for things. They can come and inform you of things. There are many different reasons, but you have a choice to talk to law enforcement or not. You can see why I generally say or not. Mary said, Emily, you should be a judge. You're wicked smart. No. My ability for judicial demeanor is low. My threshold for busy work and paperwork also low. So much of judges' jobs is like the awful paperwork that they give you in elementary school to keep you quiet. Maybe it was just me. But like all kinds of check boxes, like the amount of tedious paperwork, it is so much paperwork. Not new. Also, you have to keep your face neutral. And I'm real not good at that. Not at all. Not at all. Nope. I would not want to be the referee. I want to be the commentator. Even when I was playing sports and after sports, I didn't want to be the referee. Even when it's like senior year and it's like, hey, seniors, do you want to referee the alumni game? I'm like, no, but do you want to put me on the mic? Because I'll call it. I'll call the alumni game and be like, class of 92. What have you been doing? Not working out. You look like you're drowning. Get it together, guys. You gonna swim? You really? You call that a block? You're barely out of the water. I played water polo, by the way. Nope. Even then didn't want to be the ref, wanted to be the commentator. Perfectly happy doing commentary. So, Emily, what sport? Water polo. We had an alumni game. Emily, did you want to get in the water and play at an alumni game? No, I didn't. Especially after I tore my rotator cuff. Fuck no. Did I want to make fun of people? Yes. Yes, I did. Holly Cass asked, question, is there a limit on the amount of retrials? This is probably a more in-depth question. It's really going to depend on jurisdiction, on case law, and if headway is being made or not. I hate trying to ask or answer this question because people are trying to figure out what happens if the jury doesn't reach a verdict. My optimism in this case is that the jury does reach a verdict and the case has some finality. But if the jury did not reach a verdict, could they retry again? There would be motions about it. Could a judge allow for a second retrial? Yes. Do I have any idea what the most retrials in this jurisdiction has been? No. And I don't know the case law well enough in Massachusetts to tell you where their boundaries are on when you have to stop retrying cases. But in theory, you can keep retrying cases if there are mistrials. And at some point, the case law in each jurisdiction is going to give guidance to, you're just not making any headway and this case can't be proven. And that's different if a case hangs 11-1 for guilt versus 11-1 for not guilt versus split 6-6, which is why I think polling the jury is so important. So it really, really is. Heartscapes Reiki said 7:30 a.m. court start here in California, and this dedicated law nerd clicking the live before rolling out of bed. Let's ride. I love it. Good morning. I know we had a little later start this morning and I loved it. Emily, do you like starting at like 9:15ish better than 8:15ish? Yeah. Is that going to happen tomorrow? No. Court's back to regular time. We feel you, Judge. It's early for these things. It's Monday. It's an early Monday. I know. Just email the judge. Just email the judge a courtesy copy of the motions before. Just before. But I don't know. Wedge said, this is the part of law enforcement I really hate. Yeah, we screwed up, but let's shield each other over a lie instead of just being like, yeah, we messed up, so let's be adults and someone else take over. Some of the testimony is wild. I do think that the testimony from the CERT team was the type of testimony that you would hope to see in any case. We did this, we did that, we documented this, we documented that, boom, done. That's not what we're seeing. I don't know what else Bukhenik can do, because he's trying to preserve the investigation while also trying not to co-sign what he got disciplined for Proctor doing. But also, it's going to undermine him when he keeps saying this investigation was done with honor and integrity. I just wonder if there's a way to say this investigation had multiple officers involved, multiple supervisors involved. Everyone came to the same conclusion. This was the evidence, and the actions of Trooper Proctor are deplorable, do not reflect this department, and do not reflect on the investigation. But even that's a bit strong, because he was terminated. And so I think him answering this investigation was conducted with honor and integrity is gonna backfire when the jury hears more. Because we didn't even get into the rest of it. We just didn't even get into the rest of it. So Shane, it's good to see you in the chat. Hopefully the background's keeping you company at work. Just me said silent honored, but had to say I'm putting my BA to use and starting my paralegal program on Wednesday. My Gen X self is nervous but excited. Love watching trials. Emily, I appreciate your insight. Paralegals keep the legal field going round. You will learn a ton, and it is incredibly needed. So enjoy. I hope it's great. It's fantastic. Jackie asked if she missed anything spicy. It just depends on what time you came in at. It's been a long day. There were spicy moments. Jenna said, today is my birthday. Best way to spend it. Happy birthday. We've got all the May birthdays going on around here and going on in the chat, which is fantastic. So let's see. Performance reviews should be neither copy and paste nor a creative writing exercise, sir. A non-mouse. Yeah. Yeah. I think it was a really good use of performance review. And the only reason the defense had the performance reviews is because the IA investigation was done. And I really think it was a good use of performance reviews. I thought they brought it forward very well. Motion to add the Teletubbies did it to bingo. No, we're not having the Teletubbies catching strays, Matt Bond. Motion for the big goat. I don't know if there's a big enough goat scream and eye roll for some of the earlier testimony today. Let's see. We've got hey, why not give him old-timey binoculars? I mean, goes with the theme. I think the technology, allowing them to see the timestamps in court embiggened was very helpful. I do. For all of you in the chat that held the name calling of Proctor during the reading of those texts and Bukhenik, I appreciate you. I know it's hard. And I saw a lot of super chats being like, I am fighting my fingers. I know. I know. You're just like all ready for like, what is the movie with Devon Sawa? Is it Devon Sawa? I think I've said that last name wrong. With the possessed hand. What? I forget the name of the movie. But that's what it was like. You guys were just fighting with the idle hands. You were fighting with the idle hands today. It's the 90s. Oh, the 90s. Emily, our outdoor cameras show a whiteout, but we step outside and it's lightly snowing. Snow off the roof makes it look heavier on camera. Minnesota gal here. I know snow. Anyone else notice that? Very, very fair point. All of you. Thank you, chat, for all the idle hands. Exactly. The one with Seth Green. Yes. Not scissor hands. Idle hands. Idle hands. 90s. Just 90s. Just 90s. But yes, that's you all were like, no, hand, no. Brain, yes, hand, no. Let's see. Paraboo said, I may be mistaken, but didn't it come out pre-trial hearing that the Sallyport cameras recorded continuously? No, they had more recordings than we knew about, but the cameras were motion activated. That was my understanding, but they had so much video, they needed to break the 6-hour blocks of video down because they had so much video. But they said they were motion activated, but it was so much video that they did clip it down because people were in and out. I interpreted that as people were in and out of the Sallyport constantly, and they had that much video. MEK S14 question: are the jurors expected to watch all these discs and deliberations? Only if they want to. They're marked into evidence. They can choose to. They can choose not to. We'd like to call the Sallyport camera as our next witness. Oh, Arminda, it's been rehomed. That Sallyport video is. How is this the next chat that is saved? Rehomed Sallyport camera said before, when you rewound, an orange cone app opened on the taskbar of the computer. What was that app? I thought the program used before the taskbar image was different. I do not know which program they are using to play these back. And I forget the name of the program. The chat probably knows the name of the program that has the cone. Is it the VLC player? A lot of you are saying VLC. And Megalina is saying VLC. So we'll go with VLC. Thank you. Michelle said, thank you for sharing your knowledge with all of us. Look, somebody's interested in wanting to know the ridiculousness that is court. Tomorrow we can talk about what attorneys eat for lunch when they don't have a lot of time. We can get into that. We've heard about Alessi's Yannetti cooler and what he's bringing for lunch, but with all of that, we will get into it. Let's see. Olive Dane said, hey girl, assuming Higgins told his attorney how complicit he is prior to his interview, what the fuck does Higgins' attorney do with that info if Karen's ultimately convicted for this? Any attorney rules on this? Your attorney rules are ultimately loyalty to your client. So I don't assume that Higgins would tell an attorney anything like that. I think the reason truly Higgins has an attorney is because of his own downloading of his phone was an improper use of government resources, and he could get in trouble or more trouble for that. But no, as an attorney, your duty is to your client unless your client is going to cause imminent harm to someone. But past actions stay between the attorney and the client. That is a very, very tight attorney-client privilege. So unless there is something that is about to happen, it stays with the attorney. But I think the reason, again, that Higgins had the attorney is because he was improperly using government resources to extract his phone before the rest of the phone just went missing. Weird. So strange. So strange. Touche said, any reason defense wouldn't give both options, that maybe John confronted Higgins instead of the other way around? Either could end in a fight. I don't know. It's probably because they don't want to blame John for what might have happened, if that is what happened. And also they want to get into third-party culprit. It doesn't mean they won't ultimately argue it that way when they get to closing, but they want to get into that third-party culprit with Higgins, and they can't argue third-party culprit until they have enough evidence to do that. So I think they are really trying to bolster the third-party argument, and that is where they're going with that. So Celeste, does the jury even know that John O'Keefe is dead? At this point, it would be difficult to imagine that the jury thinks that we're doing all of this and they're not going to be shown how John O'Keefe died, because the defense and prosecution both talked about John O'Keefe dying in opening. It seems, or I think it would seem to the jury very clear that the argument is over how that happened, not that it happened. So with all of that, and they also heard from the junior officer that they went to the autopsy, so they know in evidence that an autopsy happened. They saw some of the pictures from the hospital. They didn't hear from anyone at the hospital yet, but they did hear about the officer attending the autopsy. And so you only attend the autopsy if someone is at that point deceased. I think they got to time of death but I can't be clear if they got to time of death in evidence or if they talked about it in opening at this point, because they didn't get into any of the hospital testimony. And they heard from his mom that she saw him at the hospital and he was gone. So they do have those things in evidence. And I think the emotions of his mom were really genuine, and same with the emotions of his friend talking about taking care of going out with John that night, taking care of John's niece and nephew, and then going, I think they talked about John's memorial. They may or may not have, but going to John's house with his family after John was deceased. So they have a number of things in evidence, but they do not have the cause of death at this point, and they do not have the manner of death at this point, and then they don't have the mechanism of injury. That is all still remaining. With that, Law Nerds, I'm going to wrap up for this fine day. We will see you tomorrow back in court. Don't forget to get the Law Nerd app, because that's how I let you know not only when shit pops off in court, but when the daily case briefs drop. To all of you who have been subscribing on the second channel, The Emily Show, thank you so much. To everyone who's been subscribed on that channel since it was the Quick Bits channel that never delivered on their name. Quicker than a live stream. Thank you. And those are also on the podcast app. So if you want to listen in the background on The Emily Show channel, you can do that on your favorite podcasting app, or you can do that on the YouTube, The Emily Show channel. The Emily Show podcast drops on Monday. During trial, it's going to be in between Mondays. And then the daily case briefs are up the next day in the morning if you want to refresh before we go to court. For those of you that are either early risers or getting to bed on the other side of the world very late and just want to watch them before court. But either way, I will see you in court tomorrow. Law Nerds, happy Monday. We are into week 3 of the government's case in the retrial of Karen Read. And what a busy day it was. All right, I guess we'll just wait and see what happens tomorrow. Who the next witness is really top of mind for me. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court, and of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.